Well, regular meeting of the Pennington County Commission to order. Advise you that there's agendas in the back of the room. Speaker request forms are back there also. If you want to speak on an item, please fill one of those out, turn it in to Holly Hennies, who sits on your right at the front of the dais. And we will begin with a moment of silent reflection, the Pledge of Allegiance, led by Commissioner LaCroix.
Thank you. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Commissioner LaCroix. Also ask you to please silence your cell phones. Next item is to review and approve the agenda.
Mr. Chair,
Commissioner LaCroix.
move to approve.
Second. I've got a motion and a second. Is there any public comment? All those in favor of the motion indicate by saying aye.
Aye.
Opposed? Motion carried. Might also mention that Commissioner Hadcock will be absent from today's meeting. Consent agenda. Holly Hennings.
Good morning, Commissioners. Holly Hennies, Commission Manager. For public notice, the Board of Commissioners uses a consent agenda to act on non-controversial and routine items. The consent agenda is acted upon by one motion and vote of the Board. Items may be removed from the consent agenda and placed on the regular agenda at the request of a board member or a citizen. Today's consent agenda contains the following items: approval of the minutes of the budget hearings from June 28th and June 29th, 2022. Approval of the minutes of the regular meeting of July 5th, 2022. Number 7 is to approve the renewal of the retail on-off sale malt beverage and South Dakota farm and wine license for Johnson Siding General Store and to release the license upon payment of appropriate property taxes. Number 8 is to declare 1998 Subaru Outback, asset number 29654, as surplus for the purpose of trade-in as submitted by the Department of Equalization. Number 9 is approval of the third quarter 2022 local emergency management performance grant as submitted by Emergency Management. Number 10 is approval to apply for a John T. Vukovic Foundation grant for 2022 to 2023 as submitted by Health and Human Services. And number 11 is to recognize and thank the volunteers for the month of June 2022. And Commissioners, at this time, you have received requests to pull numbers 5, 6, and number 9 from the consent calendar by members of the public.
Is there a motion to approve items 7, 8, 10, and 11 on the consent calendar?
So moved. Second.
I've got a motion and a second. All those in favor indicate by saying aye.
Aye.
Opposed? Motion carried. Item number 5, Mr. Ellsworth, I believe.
Chad Ellsworth. I'm proceeding on the public comment of the June 28th and June 29th budget meeting minutes and Commissioner's application of the consent agenda procedures on the basis of being routine and extraordinary on those standards. As you know, the consent agenda procedure is an extremely efficient procedure under the strict disclosure applications and without repression of any of the narrative becoming an arbitrary risk or a conflicted interest. In other words, doing secret law by burying it into the consent agenda, and that's why I'm speaking. When that happens, the conflict of interest can cause the system to fail. The system is preserved and protected by you as commissioners. and the application of the section 125-2 and the vigilance of the public, of which I'm trying to be part of. When any of these three of the systems fails, the system could fail and conflict grows. Repression can occur at the minutes level or by the code, withholding the code, the code that you guys put in on just here last month, and Pennington County Policy and Procedure Manual Rule 4, limiting people discussing anything outside your jurisdiction, and by withholding that statutory protection of the public. The statute 125-2 is a protection against folks coming in. You're the ones that can stop it. If you withhold it, you're hurting us. On June 28th and 29th, the commissioners were the sole watchmen of the extraordinary conflicts of interest. The public was shut out. On the 25th, you did have in your agenda, you had a notice to the public, but that notice to the public was for items that were already presented. That left you. You didn't, in like most times, routinely, you would put the protection item of the statute in there, 125-2, and you withheld that at this meeting for obvious reasons. But as you might imagine, if there's a tremendous conflict of interest building in there that you've just consented to, and you missed it, and the public had pointed out, it's a benefit to all of us. In this one, going into it, you were protecting the people that were there speaking. You had stood down. This is just like Uvalde. This is just exactly what happens down in Uvalde. Everybody knows Mark Vargo was the de facto attorney general and a federal agent. You've got proof in the packet that was delivered by Ms. Moeller of the $11 million that was received directly from the feds by you folks through him. That makes you and him a federal agent. You can't be a federal agent and be a commissioner. You've received that money, and she admits it. She had it right there in her packet. She's admitting that she didn't receive the second $1 million. And what is that waiting on? Is that waiting on all these other things that came up within the narrative of the meeting itself? I can evaluate and I can enumerate several of them. The conflicts of interest that Mr. Vargo is involved with, and the judge that was there, Judge Pifley, and your defense, one of the other guys that was there. And so at that time, I say that the conflict of interest was all known to all of you, and you didn't say a word to these people when they admitted things to you about changing jobs from one job to another. You knew that he was already the de facto attorney general. You knew from September 22nd when he took the job down there in Highmore and went to work. He never filed any appearances with anything down there and worked all the time. He ends up not being any part of the impeachment proceeding, but his people that work for him that you have seen here through Gunderson, those folks that come in here, those are all beholden to him, and they were part of that trial. He's been in every instance come totally in conflict with everything that he's done down there. And you choose to take out our protection against something like that happen by taking out, not naming the statute, not bringing it up in either the agenda or the minutes. There's remedies for things like this. They're very, very serious. I have a lot of information about all the different people and everything that are involved with it. It's not a small problem. On this matter, I'll rest. If you have any questions, I think that any questions on how a person can remedy this situation and the complete conflict of interest that you yourselves are involved with. If you don't, it's going to grow. Conflict of interest is fatal to a system. It's fatal if you don't do something about it. I can address the item 6.
Well, Mr. Ellsworth,
Yeah.
item 5 was on the budget hearings?
Yeah.
Okay. And so I failed to understand some of the connection that you're trying to
Okay.
make with that.
In the narrative, the films, there was admittances to you in front of you there from Mr. Vargo and the judge on when and the timing they picked to change their positions. One of the most prevalent ones is that why did he come in and admit to you at that meeting that he knew the night before on the 27th, but he wasn't allowed to talk to you? On the 27th, the governor was up for an ethics charge over in Sioux Falls. I mean, the timing and everything and the secrecy of the law is your real problem. As the public, I'm here telling you this all has to come out. You consented, you yourself considered. You said congratulations on the job change.
No, I'm sorry, but I did not. The congratulations was for another item. Had nothing to do with, I didn't even know about the job change when I said congratulations to him that morning.
Well, it's right there.
He
on the record.
had been successful in the impeachment. That's what I was congratulating him on.
That would call up, probably we need to get a copy of transcript, and I can show you where that could be a consent to his job change.
That was not even part of the meeting.
Then
Prior to the meeting.
I'm telling you what I understand it to be, and you disagree, and I object.
Well, I can tell you this, that you're wrong. That was done before the start of the meeting on that day, that I said congratulations to him. Had nothing to do with the job because I didn't know anything about the fact that he had been offered the Attorney General job at that point.
Would you agree to participating in getting a transcript of the proceedings?
Well, we have a transcript of
It's on
the
YouTube.
proceedings.
Mr. Chairman, I just want to make sure I'm following along. Are you talking on June 28th or are you talking July 5th?
No.
Because July 5th
No,
is
I'm
when
not on July 5th yet.
Okay, because I thought we didn't know anything about it until
don't
July
think we did.
5th. That's why I'm confused.
He announced to you his job change.
On
And
June
he told
28th?
you on the 28th. And he said he got the call the night before, but he wasn't allowed to talk to you. That is governing in
I think you
law
have the wrong
in
dates.
secret.
I think you have the wrong dates.
I stand for what I just said, and I respect your rebuttal. I can come back and prove it.
Okay. Jay, would you mind commenting on it?
Jay Alderman with the State's Attorney's Office. Thank you, Mr. Chairman. On June 28th, when we had the state's attorney's budget item up here, I think Mark had received an email, and I think that's what he told people at that time, that he had received the official that he was going to be appointed, if I recall that correctly. You're not the Attorney General until you're sworn in. He wasn't sworn in until after that meeting. As he stood before you at our budget meeting, he was the state's attorney for Pennington County. There's no conflict of interest, period. I also heard something about being a federal agent. But nonsensical, as I said here, you're not federal agents. If you receive a federal grant or ARPA money or whatever that was being referred to, 11 million, that sounds familiar as ARPA money, that doesn't make you a federal agent. Do you have to follow some federal guidelines? Well, of course, with a federal grant, but you're not a federal agent. So Mark Vargo has not created a conflict of interest, and he alerted when he got the official news, and he was sworn in later that morning. And it happened quick, sure did, but it had to. So, thanks.
Thank you.
I object to all of that. I don't think it's accurate at all, and I challenge you to get a transcript of what happened that morning, and I can prove my points.
Do you want to go on to
As far as Mrs. Moeller, that goes back to April 27th, which I object to also, when they announced that there was money received from a year before, direct from the Fed. That's your words. You got the money direct from the Fed. That makes you, with no agency, with nobody in between you, that makes you a federal agent. I'm not going to argue until we get some more.
Would you like to go on to the minutes of
Yeah.
July 5th?
Yeah. I adopt my procedural adopt my procedural comments from the time before. I guess that makes it up a little bit. And I'm applying this routine disclosure application to the minutes to decide whether there's a standard that's been broken here as far as the routine, and in this routine, and whether it's appropriate as far as an extraordinary situation like before. And I want to say the same thing happened in this case on 7-5. Your agent, your agenda did state the same thing about public comment, but it was for, that public comment is for somebody showing up that is already on the agenda. You can comment on other things, but not on the thing that was on the agenda. On item 6 here, the minutes of that meeting, the application of the 125-2 was put in there for the protection of the public. And in this case, it was ignored. The hiring of Ms. Rotag, which was done through this 125-2, apparently didn't approach and didn't show the public her conflict of interest of taking that same day, the 28th. The judge gave Mr. Rotzel the right to go ahead and be the acting state's attorney. This was not available to the public. We couldn't see it happening. She wasn't announced as an employee, and it was done many days after. This is 7-5. She was put in on when the other thing came out on June 28th, and so you skipped days in there. You didn't notify any. You've never notified here anybody of Mr. Vogt Vargo's employment, but you hit hers too. You diminished hers, and it's a major situation. To make things short, I find that the agenda invoked the public comment, but it was repressed, and it's certainly repressed also by your policy that you folks put in here in April, saying that you couldn't talk about anything that's extrajudicial, of which she would be, she knew of and knew of Mark Bargo uh, uh, acting as a attorney general in the things in Highmore from June all the way down. She's mixed up in quite a few of those matters. You never said a word about that at the meeting, but you went into the secret session, which is supposed to be for our protection. You're supposed to keep the conflict of interest out of these meetings so that the public is not affected, so there's no conflict of interest. That did not occur here, and
Mr. Ellsworth, I'm going to stop you there. Just to clarify, this was not something that was done by the Pennington County Commission. The state's attorney, Mark Vargo, had taken a leave of absence, which is appropriate under our guidelines. In that case, it is not up to the commission to appoint a replacement. It is up to the presiding judge of the circuit to do that, which he did, which we found out. We weren't aware of that appointment until after the fact either, which was probably appropriate that it was done that way. And so there was nothing that the commission was holding back from the public.
I don't believe it happened that way. I think that you knew about it as it was occurring, that she was involved with very
You
conflicted
can believe whatever
interests.
you want. I'm just telling you what it was as far as from this commission. From my commission spot, I had no idea on it. I don't think the other commissioners knew anything about it either.
Mr. Chairman, if you don't mind me expanding on that, I agree. I'm not sure any of us were aware of it. In fact, after that meeting, I went over to Holly's office, and then fortunately Jay came in there because we walked through. I was like, I'm confused. How did this happen? Because I would have thought that we had to appoint. And that's when we went through a lot of the statutes to understand where it was. We may not necessarily agreed with the state statutes, but they were state statutes that dictated based on the situation who got to appoint the replacement temporarily.
Well, we're talking about the June 5th meeting, and you were notified on June 29th. Or we're talking about July 5th now, but we're talking on June 29th, Judge Pfeiffer informed you of exactly what he did. You knew at that time. And so any announcement or any changes of status in her pay status, which you went ahead and did here, you did it through the conflict of interest clause. You knew on June 29th exactly what happened. You also knew why it happened. And it goes back to the ethics charge against the governor. The name and all of a sudden her naming that night, but not wanting anybody to know that.
I think Mr. Ellsworth, I think you're trying to connect dots that don't exist, or certainly not under our purview.
You're talking to the public now.
I am.
And you're talking to somebody that wants to help you, that wants to clarify the situation. This is not a political situation for me.
But you're not understanding the position that the commission or commissioners were in.
That's valid. Is there something else that wasn't put out to the public that I don't know about? And why was it withheld? Any withholding of any information on matters of this enormity would be a conflict of interest between what you are and what you say you are. I believe you have some difficulties with that, what your qualifications now are. And I've mentioned that before, but you've just told me now there's something that you knew that the public doesn't know. And if that's the case, then a normal proceeding under the statute 125-2, there's generally, after the meeting is over, they state what happened in that meeting. You've never done that. You've kept it. You've never done it. You've kept it. But in this case, it shows up at the end of the thing where they're giving her raise and stating that she's a state's attorney. That's withholding.
Again, Mr. Ellsworth, we did not establish that Ms. Retzel would be the state's attorney. That was done by the Chief Justice of the Circuit Court here. Her salary was established by him. It wasn't established by us.
I agree, but you knew of the conflict of interest in him doing that, and you should have said something to the public.
Well,
you should have objected right there. When he came out and announced his move, and then the judge announced his move, there should have been an objection, and there should have been a hearing. This should be put up on the agenda, and possibly a commission, because it's enormous. You folks have stood down now. You're letting us down. It's your job to catch these guys. If there's something there, and I'm telling you, there's something there with holes in it.
I don't agree with you on the conflict of interest. I don't believe there was. Jay?
Again, Jay Olram, State's Attorney's Office. The county commission has not let anybody down. You didn't know until you learned on the 28th, after he was appointed, that he was officially the Attorney General. You couldn't have known, you did not know. I will attest to that as I stand here. You've not let anybody down. The statutes our legislature put in place dictate that you had no jurisdiction in setting Ms. Retzel's salary to be appointed by the Circuit Court, not the County Commission. That happened. It happened fast for all of us. But there's no conflict. They didn't let anybody down. The Circuit Court had the jurisdiction, not the County Commission. If there's a vacancy in office, and I'm sure I'm going to get into this here shortly, then the County Commission can take action, but not as you describe it today.
Jay is a state's attorney in the state's attorney office here.
He's a deputy state's attorney.
He would have all the reason in the world to deny this.
Okay.
But that's a conflict.
Anything further, Mr. Ellsworth? We have a long agenda.
I'm sorry.
We have a long agenda. I asked if you have anything else.
No.
Thank you.
Mr. Chair,
Commissioner LaCroix.
move to approve items 5 and 6.
Second.
Motion to approve items 5 and 6. Is there a second?
Second.
All those in favor indicate by saying aye.
Aye.
Opposed? Motion carried. Item 9, approval of the third quarter. Is that Chuck?
That's Mr. Henry.
It's been a while since I've been here. Maybe years, I don't know, a while. Wait. On item 9, I was in the CERT class, and it is great. You learn stuff, and you have fun. I'm glad Dustin had those going. And I have an issue with the state's attorney. I was assaulted in December.
Okay, item 9 is the approval of the third quarter 2022 LEMPG, Local Emergency Management Performance Grant.
Right.
So your comments are related to that?
No, I'll hold back till general comment again.
That'd be
Okay,
Okay,
thank you. Is there a motion to approve item number?
So moved. Second.
I've got a motion and a second. All in favor indicate by saying aye.
Aye.
Opposed? Motion carried. Okay. Item number 12, citizen petition to the Pennington County Board of Commissioners to request the resignation of Mark Vargo. Tanchi Weaver.
Good morning, gentlemen. Can I approach and give these petitions to you, Mr. Chair? Okay, what you have there are the signatures of over 100 Pennington County residents who have been fully aware of what's happened in the recent days. Mr. Vargo is our state's attorney in Pennington County. He attained that position in 2020 by providing 50 signatures on nominating petitions, and he did not have an opponent. So what I have given you is twice that number of people asking for you to request his resignation. This is not an adversarial thing. One of the wonderful things about our country is we have the right to petition our government when we see something wrong. And I have just read our governor's book, and one of the things she says, in fact, it's the underlying theme of her book, is that in South Dakota, when we see something that's wrong, we don't complain, we just try to fix it. And so that is what we're trying to do here, is remedy a situation and just make it right. The AG, the Attorney General, and the state's attorney are both partisan elected offices. And with that in mind, we are requesting the permanent resignation of Mark Vargo for the remainder of his term because the Attorney General has statutory oversight roles with respect to county state's attorneys. Mr. Vargo, his leave of absence will go through January, at which time he wishes to resume his role as Pennington County State's Attorney. But that means that many corrective actions or decisions that he may be asked to partake in as Attorney General with respect to Pennington County State's Attorney's Office will be effectively taken for or against himself at that point. And we see that as a conflict of interest. We have no problem with the governor appointing Mr. Vargo. She has the right to appoint whoever she wants. We have no problem with the appointment of Ms. Retzel. In fact, I have a letter here from the governor that's part of the packet, and she expresses that the county is in good hands with Ms. Retzel. And I would agree with that. I would posit that Ms. Retzel has been the de facto state's attorney for the majority of Mr. Vargo's term because of his deep involvement in the proceedings with the impeachment and the investigation since the beginning of what happened with Attorney General Ravnsborg. So I think, yes, she's terribly, eminently qualified. And in Mr. Vargo's letter that was submitted to the record yesterday, he also says that Laura and Jay are clearly capable of dealing with the office in his absence. And again, so I am echoing that confidence. I would also say that, yesterday, and this is a little bit of confusion because yesterday I wanted to see what was submitted in writing as a leave of absence because I think the issue here is who can grant a leave of absence. I did find in your county handbook, it's section 5.2, I believe, a policy that Pennington County has for employees. And that is 5.2 reads personal leave of absence, and it is to fulfill personal obligations. It also says that leaves of absence for non-medical reasons are not encouraged and that Pennington County cannot guarantee reinstatement. That's for their employees, but Mr. Vargo is not an employee. He is an elected official. And he has certain functions as an elected official that overlap with his position as Attorney General. I have sent through Holly, and I think each of you has this list of statutes I've done some digging, and, I don't do this lightly. I am not, as maybe some might say, a Roundsburg apologist. Truth be told, I didn't vote for him, and I have not made any public statement as to the accident that he had or the process. The impeachment process is a function of the legislature, but it is not a legislative function. And I only concern myself with legislative function, or with the functions of legislation. So, so that's a category I will object to being called. I am not an apologist for Mr. Roundsburg in any way. Now, just going through these statutes, let's start with 1-11.1, or 1-11-1, which is a list of the duties of the Attorney General. And you will see in number 5 that one of those things is to consult with, advise, and exercise supervision over the several states' attorneys. Well, that would include himself, because so many proceedings are protracted, they take a long time, and there's a very good chance that he will be administering things in the office of AG pertaining to our county, and his office here in particular, that would constitute a conflict of interest. In number 9 in that statute, Section number 9, part of his job is to prosecute state officers who neglect or refuse to comply with the provisions of statutes of this state. One of those statutes is 7-16-19, which requires counties with a population of 50,000 or more to have a full-time state's attorney. So again, that would indicate himself. If he is not, doing his job, then he has basically vacated that position. Next statute is 3-8-1, which requires that the Attorney General devote full time to the duties of their respective office. In Mr. Vargo's letter to you yesterday, which I can only assume was provided as a type of explanation, because yesterday I, kind of quantum leap backwards to yesterday again, I did seek out anything in writing that indicated that he had submitted to someone. And you just told us that you didn't have the authority to appoint a replacement, so you really don't have an authority to grant a leave of absence, as he is an elected official. He is accountable to the people. In a statute down the line here in your list, you will see that, and I think that's 3-4-2, when resignations from office are made, and actually he should have submitted a temporary resignation rather than a leave of absence. That's not defined in law as a reason for vacancy in office. But that is submitted to the auditor of the county. It is noted in your minutes, but it is submitted to the auditor, which indicates that, yes, he is accountable to the people that elected him and that he serves in office. Just as, our commissioners are accountable to the people. I was on page 1. The next page, I think, point 2, okay, papers filed and appearances, that's 23-3-4. It shows, again, some overlap. Most of these are on here to show how there is interweaving of both of these positions. And in regards to Pennington County, that would either give it that would basically give our county a leg up and an advantage over other counties to, that is what we see from the ground, that these things should be separate and occupied by separate people. If Mr. Vargo comes back to the position that he vacated, then and in his letter to you yesterday that he submitted, because there is nothing in writing anywhere that could be found indicating from him that he had taken a quote-unquote leave of absence. There was nothing filed with the auditor and nothing filed with the commission. He says here, when I return with greater knowledge of the inner workings of the AG's office, I believe that the reach that I will have over this time frame will also enable Pennington County to have a great reach in recruiting and retaining attorneys. Recruitment is an issue, but it's an issue for all counties. But he said right there that he intends to leverage his position as Attorney General to benefit himself when he returns in the effort to recruit. So I think right there we have an admission that there certainly could be an overlap. I'm going to just read the language of the petition to show you that this is actually just about being accountable to the people. The petition is to the Pennington County Board of Commissioners. Whereas the elected Pennington County State's Attorney Mark Vargo is absent from the office, and whereas elected officials are normally granted a leave of absence only for military service, ill health, or family matters, and whereas Mark Vargo has accepted an appointment to the position of South Dakota Attorney General, and whereas serving as Attorney General, Mr. Vargo has oversight and authority, which these statutes prove, over the position of Pennington County State's Attorney. It creates a conflict of interest due to Mr. Vargo's direct connection to the office and his intention to reoccupy that position. And whereas the Office of State's Attorney belongs to the people of Pennington County, and whereas the Board of Commissioners now has the authority to request a resignation and appoint a permanent replacement, you do have the authority to appoint a permanent replacement. The judge did have the authority to appoint a temporary, but it says in that statute that nothing in the statute is to be construed to mean he can appoint a permanent replacement. So whereas the Board of Commissioners now has the authority to request a resignation and appoint a permanent replacement to fulfill the current term of office, now therefore we, the undersigned, qualified voters of Pennington County in the state of South Dakota, petition the Pennington County Board of Commissioners to request the resignation of Mark Vargo and appoint a permanent replacement to fill his elected term. So, in conclusion, I will say that Pennington County, the people of Pennington County, and specifically victims of crimes and those accused of perpetrating crimes, deserve a permanent replacement for the vacancy of the state's attorney. With a temporary replacement, those accused of crimes may not be able to rely on plea agreements, and crime victims may be reluctant to request prosecutions when those prosecution decisions are subject to review and reversal within just a few months. Pennington County taxpayers deserve a state's attorney with the power and time to implement corrective action with respect to office staff, staff compensation, and staffing levels. Taxpayers and voters deserve the accountability that can only be had with permanent long-term leadership. We have no problem. No one that I talked to, no one that signed the petitions, had a problem with Mr. Vargo running for his seat again. That's not the issue. The issue here is how best to serve the community, the people who elect the state's attorney, and the people in the system that are directly affected. So with that, I'll conclude.
Okay, any questions of Ms. Weaver? I do, Commissioner Roskinek.
Lake County, you mentioned state's attorney, but then I keep looking at, maybe he's inferior, but we still have an acting state's attorney that's taken his position that we've already agreed that she's got the ability to do that. So I get a little confused sometimes when you say state's attorney. Sometimes I think we should be saying, in some of those clauses, acting state's attorney.
Well, he's actually the Attorney General, so he can't be both. And Ms. Retzel is the state's attorney as long as there's that vacancy. But that is why, if you review those statutes, I think you will see that he probably should have at the very least, temporarily resigned and submitted a resignation. I think that would be the proper way to handle this. And then, I honestly do think that he should resign for the remainder of his term. I think Ms. Retzel is very capable. I think that, and he said so, and the governor said so. And I don't disagree. I will point one other thing out. They both thank you for your willingness to support Mr. Vargo. I think that your willingness to ask for his resignation is supporting the voters and the taxpayers. It's not adversarial to ask him to step aside for the remainder of his term. It really makes a clear-cut division there. There's so much overlap here that even the appearance of conflict of interest should be avoided. That's just code of ethics. And that's why we're stepping up and asking for this. It's for no other reason.
Tanchi, you indicated that he had sent us a letter. Obviously, he must have sent that to you also.
Holly actually sent it to me.
Okay.
So, but it came, I think, as a result of my inquiry of, I wanted a copy of whatever he submitted in writing, and there was nothing.
Okay.
So,
I have several speaker request forms, but I am going to, since you mentioned that, I want to share the balance of that letter that he did send to the commission. But first of all, I'd share the letter from the governor. And you don't need to stay up at the front if you choose not to.
Yeah, the governor's letter was in the packet, but this one was later added.
On July 14th, we received a letter. Dear County Commissioners, I understand the County Commission may discuss at its next meeting the fact that Pennington County State's Attorney Mark Vargo agreed at my request to step in as South Dakota Attorney General for the rest of the year through early January. I would not have made this request to Mr. Vargo if it was not important to the entire state, including the county, to have a man of Mr. Vargo's integrity leading the Attorney General's office. I know the county is in good hands with Ms. Retzel as the acting state's attorney until Mr. Vargo returns in January. I appreciate your willingness to support Mr. Vargo as he takes a brief leave of absence and serves the state in his temporary but important appointed role for the people of the state of South Dakota. Sincerely, Kristi Noem, Governor. Also, then yesterday we did receive, as commissioners, an emailed letter from Mark Vargo addressed Chairman Drews and commissioners. I understand there's an agenda item this week in which Ms. Weaver has said that she intends to present petitions calling upon you to call upon me to resign as Pennington County State's Attorney. I do not know the language of the petition, what any signers were told when their signatures were solicited, or even where the signers live. I've seen an email which was forwarded through the Wingnuts political group. That email suggests that taking the AG appointment will hurt the office and that I should therefore resign. The logic of that position ignores the fact that my resignation will only make permanent the loss of my experience and talents to the office, to which I have every intention of returning. I have every faith that the staff I leave behind, led by Lara and Jay, are clearly capable of dealing with my absence. I am available to them, and much of what we are working on together 3 weeks ago, particularly recruitment, continues through their efforts and with my support. Efforts that I led prior to being sworn as AG have resulted in recent hires, attorneys in the pipeline, and several others who we're hopeful will be finalized soon. Accepting the request of Governor Nome to serve as Attorney General was not a decision that I made lightly. I did it because I felt that it was important to serve in the area of greatest need. I did so after consulting with Mr. Jackley, who at present has no opponent for the AG race in November, and who joined the governor in asking me to take on the task of restoring faith in the AG's office. I did so after talking to Lara and Jay. I did so with the support of my wife, who supported me in accepting the appointment, but also predicted that Mr. Ravnsburg's apologists would likely use my service as a way to attempt to lash out against me despite the absence of any legal mechanism for recall or removal. I could certainly wish that there could have been a way for this to have happened more slowly, but as it has been reported by the press, this was a decision that the governor had to make immediately in order for the AG's office to have any ability to perform its functions. I was formally asked to serve on Monday evening, and the announcement was made just seconds before I began my presentation to the board at our budget hearings on Tuesday morning. I'm proud to be part of the great team of the AG's office and a great team at Pennington County. I believe that my work over the next 6 months will make me a better state's attorney when I return with greater knowledge of the inner workings of the AG's office. I also believe that the reach that I will have over this time frame will also enable Pennington County to have great reach in recruiting and retaining attorneys, which is one of the greatest challenges that we anticipate over the coming years. I get a fair amount of grief from my fellow state's attorneys about alleged relentless recruitment efforts. All I can say to them is, you ain't seen nothing yet. I appreciate the commission's continued support. The next 6 months will allow me to work for the good of the people of South Dakota while protecting and promoting our home, Pennington County. Mark Borgo. I'll now call on Chuck Henry.
Mr. Chair, there was one little thing at the very end of the handout that you got from me, and I neglected to mention it. I thought it was important to bring a historical example of where the interests of the AG, the state's attorney, and even the courts have conflicted in the past. And that historical example is South Dakota's Supreme Court decision. It's State v. Tapio in 1988. It involved prosecutorial misconduct involving the Pennington County State's Attorney, the Attorney General, and the Circuit Court judges. I believe it was Merton Tice and Judge Moses ultimately. So if you do research that case, you see why it's important to have clear distinctions between these offices. Thank you.
Okay, thank you. Chuck Henry? I'm going to ask those speaker requests to keep your remarks relative to the item at hand, which is the request for Mark Bargo's resignation. Thank you.
Okay. Before I even get into it, it seems like everybody's blaming officials. Take the shooting up in the motel. It was all about politics. We're supposed to respect our leaders, not tear them down. So this attack on everybody doesn't benefit anybody. They're just a big problem. I don't know if I do this. Yeah. Back in December, I was assaulted. I went through, called the police, When policeman came in the door, I told her I want her arrested for assault. Well, he didn't arrest her for assault. He just took a detox, and that angered me because she was back in the building and actually bragging about it. But when the police department, their investigation ended that Friday, and was given to the state's attorney. It took 3 months just to get the arrest warrant. And if they had it, they had a chance to arrest her twice.
Mr. Chair.
When we were going.
Commissioner McCroy.
Chuck, I don't mean to interrupt you. I know this is a personal tough situation for you, but right now we're on the petition for Mark Vargo,
Okay,
and what you want to discuss would be public comment.
okay. That's what I thought. Thank you.
Next one is Jeanette McIntyre.
Thank you, Mr. Chairman. My name is Jeanette McIntyre. I'm actually here in support of Laura Retzel. I think she's completely capable of doing the job, and I would like to see her in a permanent position and serving through the end of the term, which would be 2024. But there's another example that I think might be appropriate, or at least a different way of looking at this. Let's take an example of a Senate seat in South Dakota Senate that someone might vacate for whatever reason, and the governor has an opportunity to appoint a replacement. Well, if she took someone from the House side and said, would you like to be in the Senate side, and they took the job, they wouldn't actually be able to keep both seats because they're both elected positions. And I think that's kind of a point that maybe has been overlooked in this, and I think it applies. Vargo was elected to the state's attorney's job here in Pennington County, and he's been fortunate enough to be appointed by Governor Nome to the Attorney General's position. I think that's a feather in his cap for a job well done, maybe, and he's capable of doing that job. But I think he also should respect the fact that Laura Retzel, who he says has the ability and the wherewithal to do the job here, should be able to have that job through the end of his term. So I believe the resignation is appropriate, and I think it's something that you should seriously consider asking him for. There are some confusions as to leave of absences and what can and can't be approved or are appropriate, but I think his resignation would be appropriate in this case, and I strongly support Laura Retzel in the position of state's attorney through the end of the term. Thank you.
Thank you. Any questions for Jeanette? Janet Saylor.
Good morning, Commissioners. I am here as a Pennington County taxpayer, not as the Pennington County Treasurer. I can't believe that we're here today even having this discussion. As a citizen, I am proud to think that we have a state's attorney in Pennington County who the governor feels has the knowledge, trust, and integrity to move the state forward as our new attorney until our new Attorney General takes office. Mark accepted this honorable request because he knew that our state needed to move forward and get back to the business that we should have been doing over the past several months. At the time, things weren't being done with Mr. Brownsburg's trouble. Have any of you bothered to look at the credentials that Mr. Vargo has? Check them out and tell me he should resign. He is not taking one dime from the county while he's serving as Attorney General in the state. He was named South Dakota Prosecutor of the Year in 2015, and as a Pennington County taxpayer, I am proud to have him as my state's attorney and would gladly welcome him back. As for Laura Retzel being named as Mr. Vargo's replacement, we should all feel very fortunate to have Laura, who was also named the South Dakota Prosecutor of the Year in 2017. Laura has prosecuted many high-profile cases, including murders, sexual assaults, just to name a few. Her credentials are outstanding. She is very intelligent. She takes her job very seriously. She is very devoted and very passionate about her job. I, for one, feel honored to have her at the helm of the state's attorney's office until Mark Vargo's return, and I think it's wrong to ask him to resign. Thank you.
Thank you, Janet. Mike Mueller.
Morning, Mr. Chairman and Commissioners. I applaud Mrs. Weaver's research. I represent South Dakota Citizens for Liberty, and two of our mantles are accountability of government officials and the rule of law. If you choose to ignore statutes that may pertain to this that she well has laid out for you, our sheriff and our sheriff-elect would not let you get by with speeding in a residential zone that's not marked 25. Ignorance of the law is not an excuse for breaking the law. So I would suggest those statutes be studied well before a decision is made. I myself took an interim position with the university as an assistant director, physical plant up to physical plant director. And I think if Ms. Retzel's qualifications are there, and that's the decision of this body to assign her, the resignation is due per the law. In a competitive election, when the term is up, Mr. Vargo could come back and state his interest in being state's attorney again. But I think the rule of law bears on your mind here today. Thank you.
Mr. Chair. Say, Mike, I think the position that we're going to take today, or at least myself, is I'm going to take a position that I feel is the best for Pennington County and for the best of the state of South Dakota. I don't know that, there's a lot of subjective comments out there, and based on the testimony that I've seen so far, that's where I'm going to be at as far as my position.
Very well.
Thank you. Kevin Tome.
Morning, Kevin Tone, Pennington County Sheriff. I appreciate Tanchi and others bringing their concerns forward, and I respect that. As far as the legal nuances of what you can and can't do, I would defer to your own legal experts on that. Jay and others, they've always given you solid legal advice, and you can draw on that. From a perspective of Mark and him taking the appointment as Attorney General, the actions of the former Attorney General put us into uncharted waters. And the legislature thankfully followed through with the impeachment of him. And again, that put us into uncharted waters and had to move quickly to fill those positions. So maybe some things weren't done perfectly. There is no roadmap to do this. It's never been done before. So maybe it isn't perfect, but Mark is a good Attorney General. He'll be a good state attorney when he comes back. He took one for the team, so to speak. It's not convenient for him to uproot and move to Pierre temporarily. I have a personal interest in the office. I retired from DCI, was a director for 3.5 years. My last 3.5 years at DCI, worked closely with the Attorney General's side of DCI, and the office is in disarray. And Mark took on that challenge to fix that. I hope in the process we don't punish him for that. And I already met with Laura. She'll be an excellent state's attorney in his absence. I look forward to working with her. We have a good relationship with her and the office. I'm not concerned about continuity during this next 6 months or continuity after Mark returns. So I would ask you just to support Mark and him taking on one for the state of South Dakota and helping fix the mess that was left by the former Attorney General. So thank you.
Mr. Chair.
Thank you. Commissioner LaCroix.
Thank you, Kevin, for bringing that up, because I do believe this is uncharted waters for what happened in our state. And I think we've never navigated through this before, but I do concur with your findings, Mr. Tome, because some of the stuff that I'd heard that was going undone as the absence of the Attorney General, it was on hold, and so they needed somebody right away, as from my understanding, even before we knew the governor had asked Mark. But him stepping up, I was the one in the meeting that congratulated Mark Vargo on his position that was referenced earlier. That was me.
Okay.
So I think it was confused, but because he's stepping up for a temporary position, knowing he's have to come back and do his work, and I believe he stepped up and is helping South Dakota and Laura also. I mean, it was from my understanding, it all happened so quickly that some decisions had to be made quickly, and I appreciate both of you for stepping up.
Last speaker request form I have is from Marguerite McPhillips.
Thank you, Mr. Chair and County Commissioners. I have nothing personally against Mark Vargo, The law states, though, that he never put in a resignation or a leave of absence request until it got hit at Wingnuts, that I attended, and somebody there put the bug in the governor's ear, and then that's when Mr. Vargo and the governor. So it's like a reversal of what should have been handled. And that's the point that I don't care for. Why didn't he, when he accepted it, put in for release from his job from Pennington County, and he didn't. So we're doing a reversal, and that is not fair. As Mike Mueller has stated, we have to follow the law, and the law has been abused in this case. You would never have gotten a letter from the governor or from Mr. Vargo if Mrs. Weaver hadn't gone to the auditor's office to see if that was on file, and because someone at Wingnuts contacted the governor and let her know about this. So I just find this is a convolution of things, and the law wasn't followed. And if Mr. Vargo is supposed to be an attorney and know the law, and nothing against Ms. Retzel, I don't know her at all. I just don't think we, as a county, that it was followed correctly, and that's why Mr. Vargo should be resigning, and then he can apply for the job again. Thank you.
Thank you. I guess, anyone can ask for his resignation. We as individuals could do that also. I'm not of the opinion that I care to do that. Our handbook does allow for leave of absences up to the 6 months. And there's nothing in the Pennington County Handbook that says an elected official cannot have a leave of absence. And so I'm of the opinion that Pennington County is better off at this point in time with Mark Vargo as being appointed as the Attorney General. I wish him well in that position in the next 6 months, and I look forward to his return as the state's attorney early next year.
Mr. Chairman.
Jay.
Jay Alderman with the State's Attorney's Office. I too, as the sheriff mentioned, I appreciate the taxpayers' right to petition their government. That's a long-standing right that we all endorse. However, where my job comes in is if there are statements that are misleading or there's statutes that aren't fully read and presented, then I feel a duty likewise to inform you on some of those. First and foremost, your comments, Mr. Chairman, just seconds ago were spot on. There's not a form to fill out for leave of absence in Pennington County, and we can work on that, and maybe there should be, but there isn't. So Mr. Vargo didn't fail to follow and fill out some form and file it. I know he took a leave of absence, which he absolutely has the right to do as an elected official. It's an unpaid leave of absence. He's not being paid by the county. And there's comments made by Ms. Weaver up here today that he created a vacancy when he took his leave of absence. That's false. That's not an accurate legal statement. She mentioned that, and she provided it in her documents that she just gave to everybody this morning. We hadn't seen any of it until this morning, literally. She says he should take a temporary resignation because his leave of absence, he should just do that. Well, her own statute, she didn't read to you. The temporary resignation is where there is an incapacity in office due to illness or accident. Clearly, that's not the case here. There was no illness and there is no accident. So the temporary resignation statute has absolutely zero application to this question or subject today. You can certainly ask him to resign. Of course you can. And he could say yes. And if he resigned, that would create a vacancy under our state statutes. And vacancy under our state statutes, a real vacancy, not a perceived, not a leave of absence. A leave of absence does not create a vacancy by statute. If a vacancy were in fact created by his resignation, then this legislature has given this body the authority to appoint. And you would absolutely be able to do what some here today would like you to be able to do. Until that actually happens, you do not have that authority. Leave of absence under Pennington County Employee Handbook, again, something was left out when it was leave of absences, as Ms. Weaver noted, for non-medical reasons, this would be a non-medical reason, are not encouraged, and she stopped there. Then it goes on to say, except where there's unusual and emergency situations. Well, as everyone has heard here today, there's probably few things that have happened in the history of this county as unusual as the impeachment of an attorney general. In fact, I think it's unprecedented, if I'm not mistaken. Very unusual. What we also learned from that impeachment, and it might have caught a few people by surprise, is once that attorney general was removed from his office, the attorney general's office literally and the employees left behind were hamstrung. They lacked legal authority to proceed as they would with an attorney general in place. Guess what that required? An emergency to appoint a new attorney general. And yes, it was kept quiet while the governor was looking at those options and applications and considering, just like any of the rest of us would do when we're considering employees for appointment or a job. And it had to happen fast, and it did happen fast. In this particular case, one last point I guess I want to make. The last thing that Ms. Weaver, I think, finished with is she referenced this state of South Dakota versus Tapio case as somehow making an analogy to prosecutorial misconduct. When you actually read that case, I won't go into all the details, but only the finding of the Supreme Court found that the prosecutor's actions did not rise to the level of prosecutorial misconduct. Trial court didn't have authority to remove members of the state's attorney's office and didn't have authority to require the attorney general to prosecute in place of the state's attorney. So the purpose behind her use of this case is non-applicable at all to what we're talking about here today. It's a misnomer. I want everybody to know Ms. Retzel has been prosecutor for over 25 years in our office. I've been here for over 25 years in our office. The two of us together have over 50 years of personal knowledge in a prosecutor's office right here in Pennington County. I assure you we're up for the challenge. The challenge being for 6 months, try to make the office run as best we can. That's what we're doing. It's 6 months. I can also assure you that as per statute, when the Supreme Court Justice appointed or swore in Mark Vargo to Attorney General, as soon as that happened, he's the Attorney General, and he has to devote full time to that job. He can't be the state's attorney. When Judge Fifley appointed Laura Retzel as our state's attorney, same thing. She has to devote full time to being that, and she takes on the full duties of that state's attorney. Mark Vargo's not the state's attorney. We don't talk to him and ask him what to do in our office. Laura Retzel is our boss. That's the way it is. That's the state law, and it's going to be that way for 6 months. Mr. Vargo does not maintain an office. He hasn't been back to our office. He doesn't run or manage the day-to-day operations or management of our office. He can't. The supervision of the Attorney General, at best in practice, we know that if the state's attorney didn't prosecute a particular case for a particular reason, the AG's office could look at it and prosecute. And that's maybe one of the things you occasionally hear about across the state. The AG can step in. It's with the request of the state's attorney, and they work together. They coordinate as well we should. And we will do that if that occasion arises, because we should. That doesn't create a conflict of interest. That's just common sense and good professional conduct. So Mr. Vargo shouldn't resign, in my opinion. He's doing what the governor asked him to do. Our state's attorney is now acting as the state's attorney. We're just fine. We're going to do this job for 6 months. And when Mr. Vargo comes back, he will take over and be the state's attorney. That's not a conflict of interest. That's just a fact of where we stand. It's an unusual and it is an emergency circumstance. Thank you. I don't know if you have any other questions about legal statutes.
Commissioner Lassiter.
Mr. Chairman, I'm glad I'm not an attorney. I'll just tell you, after reading everything that I've read, my goodness, how y'all can keep anything straight is beyond me. That's probably why you're blessed with that ability to do that. But I will say this, I have a question, because as I've read through everything, I wrote down a lot of questions. You answered a lot of them with just this last speak, so I was able to cross them off because of the emergency situations. There's no precedent on this. I mean, this is kind of new territory waters. I guess what my question then comes down to is, can somebody hold two elected positions at once, regardless whether they're being paid in either or? And my limited knowledge of this is if somebody runs for a different office and they get elected, then they have to resign from the other office. This is an appointment to an elected office, but yet he's still an elected official here, even though he's not fulfilling that role. Is there something in state statute that handles that, deals with that, says what can happen? And do we have any precedent in the past of someone being appointed to an elected office and then going back to a previous elected office after they're completed? Maybe that's probably the best way to ask that question. I hope I asked it right and you know what I'm asking.
Yeah, and I think the best way I can answer that is, in my opinion, the answer is no. And in this particular case, we know that the AG has to devote full time to being the AG, which means by default, he or she could not devote any time to be a state's attorney or secretary of state or some other job. So in this case, they are very distinct. Mr. Vargo, under no stretch of the legal imagination, is holding two offices at once, elected offices. He's not. When those appointments were made, when he was sworn in as AG and Laura Retzel was appointed as the state's attorney, that put a divide and separated those two offices 100%. When you read the statute, all of the authority granted to the state's attorney is now given to Laura Retzel. Mark Vargo is not our state's attorney. He's the Attorney General of South Dakota. So my opinion is, no, you can't. And by those statutes, he's not. It's not happening.
Mr. Chair, a follow-up with that. And I'm totally asking this so I can find out, understand, that, make sure that we're looking through everything, single aspect to make sure we're not going to violate some kind of law. Could I run for District 27 House of Representatives when request a leave of absence to fulfill my term obligation January to April, and then come back to the county commission to serve on the county commission? Is that viable? If I said no pay during that time frame?
I would want to research that in specific, but I don't think, if you're on a leave of absence and if you're not doing the duties of both offices at once, then you're not doing the duties of both offices at once. I don't know how else to say that.
Once you're elected.
But I could research
But something like that has.
Which is unrelated to our issue here today, of course.
I agree directly, it's unrelated, but it could put us in a similar situation, maybe not necessarily our county, but some other county if someone did that as well, depending on the county. So that's why I was asking that question, is that legal?
If you're on a leave of absence and you have left one office to take the other, which is our case here, then there's no conflict, obviously, and you're not engaged in both offices at the same time. So.
Mr. Chair.
Commissioner Roskinek?
I agree with Jay. We're in uncharted waters. Just like COVID, we didn't have a textbook on how to deal with that, and we really don't have a textbook how to deal with this. But I think we can all agree that there's two caps out there, two hats. One, Mark's wearing Attorney General, and one, Laura, State's Attorney. Simple as that.
It is.
Thank you, Jay.
Mr. Chairman, one final question. What happens if a special session's called? Does that change anything? Because then the legislature goes into session, and if Mark Vargo is Attorney General, does that change any of this? Because if I read, and I can't remember where I read in the statute, or if it was in some of the briefings that we had, that something says he serves temporarily until the next session. Does a special session count as the next session, or is that still part of the current session? That's just a special. Do you get what I'm asking?
Well, I think what you're asking about is the governor's appointment.
Correct. And if she calls a special session, then does that count as the next session, or is that still part of this 2022
I think a special session is special to whatever that topic she calls it for. It's not the general session that happens each January for the legislature.
Right.
So I think your question under that statute of the governor's authority 343 part 1 or whatever was with the legislation consent during session, I think is what you're referring to. And in this particular case, there is no session. The session's over. And coincidentally, I think the new session begins, if I'm not mistaken, in January.
January.
And by that time, we'll have a new Attorney General.
Okay. No more questions? Back to the commission. Further discussion? Is there a motion?
I'll make the motion.
Commissioner Roskinek?
I'll move to deny the action requested in the petition.
Second.
We've got a motion and a second by Commissioner Roskinek, second by Commissioner LaCroy. All those in favor? of the
Mr. Chair, do
motion?
we have a discussion?
Certain.
If you don't mind, I'm still kind of torn on this one because if we don't know what can happen to somebody, and like I said, hearing everything out there, and I've done a lot of reading on this, and Jay, I've been fair. I asked you when I had questions. I just didn't have time to ask you questions during this last week because I'm down in Custer, and so as I'm reading all this stuff, I don't know if I can't support one way or the other on this one in the aspect of, I think we need to ask the question if an elected official can hold two offices, whether they're active or not. And I think that's a fair question to ask, because if the answer is yes, then technically any of us could run for state legislature in our district and then take a leave of absence during the time frame that the state legislature comes into session. And that may open up the door to a whole world of other things. I think it could be a bad consequence across the state if that's not clarified in state statute. Maybe I'm just looking at it wrong, Jay, but.
I don't believe you can hold two elected positions at once, and I can do the research for you and provide that to you. But my answer is no, you can't.
Too political.
Right.
I think it's too political. So you could serve as a city council person, city mayor, plus a legislator, but you can't serve because that's a non-political ballot.
And I believe there may be an attorney general's opinion on that topic. It's been a while since I've read it, but. Sure.
Tracy Decker, State's Attorney's Office. I've had to research this issue for some other races in the county. And what my research showed is that the example that Mr. Lasser is giving of a state legislature and county commission, that specifically cannot be done because the state legislature sets laws for the counties. That would create a conflict of interest where you could benefit your county. Where we're talking about two elected prosecutors' offices, one, doesn't pass laws or pass policy or have any supervisory duty over the other office. That's different. So it really depends on the elected offices you're looking at. Same as the example that Mr. Drews gave. Does that help? Is that helpful? I can send you the Attorney General opinion that Mr. Alderman referenced because that's what helped me kind of with some of this.
I would appreciate that.
Okay.
Further discussion? Hearing none, all those in favor of the motion to deny the action requested in the petition indicate by saying aye. Aye. Opposed?
No.
Motion carried 3-1. Item 13, items from the auditor, Cindy Moeller.
I just want more information.
Good morning, Commissioners. Cindy Moeller, Pennington County Auditor. The first item that I have on the agenda is a new retail on-off sale malt beverage and South Dakota Farm wine license for, I don't know if they pronounce it Sobos or S-O-B-O-S, LLC. And this license, there were no problems with the sheriff's office, but there are some planning issues. So we would ask that it be conditionally approved until their conditional use permit is approved, and that is going to the Planning and Zoning Board on August 8th. So if it's conditionally approved, we will submit it to the state upon approval of the conditional use permit on August 8th by the Planning Commission.
Okay. Is there a motion?
So move.
I've got a motion. Is there a second?
Second.
So the motion would read to conditionally approve a new retail on-off sale malt beverage and South Dakota Farm license for SOB SOBOS LLC until a conditional use permit is approved. The conditional use permit is scheduled to be heard August 8th, 2022. If approved, the application will be submitted to the state for final approval issuance. Correct language?
Yes.
Is there any public comment in regard to this? Seeing none, back to the commission. Any further discussion? All those in favor of the motion indicate by saying aye.
Aye.
Opposed? Motion carried. Item B.
We are looking at the 2023 provisional budget. And I addressed the changes in my memo that I had made as far as in the elections budget. We had reduced the insurance budget. There was a reduction in natural resources budget. And then I also did go back and reevaluate the amount that I had estimated for federal PILT dollars to anticipate in 2023. So I did increase that. And using all of those numbers, our unassigned fund balance reserve estimate at the end of 2023 will be 19.42%, which is almost at our 20% goal. Don't know if there are any questions in regards to budget. If the commission would like to approve the provisional and in August and September work towards final. How would you like to proceed?
Commissioner LaCroix?
You know, Cindy, I really don't have no questions at this point in time, and this is provisional, and we have the opportunity to request changes or information up until the 6th of September at this point in time. So I would support the provisional budget at this point in time.
Okay.
That'd be a motion.
Okay. Got a motion by
Second.
Commissioner LaCroix, second by Commissioner
I
Lassiter.
think I need to read the total amounts. Okay, I knew she was going to be. Move to approve the fiscal year 2023 provisional budget in the amount of $115,075,044 cents, and schedule a required public hearing for consideration for the fiscal year 2023 budget for September 6th at 2022 at 10 a.m.
Got a motion and a second. Any public comment in regard to the provisional budget? We'll make note that the total dollar amount is less than what it was for the current year. We still have an opportunity to go through and make some adjustments between now and the September 6th date. Seeing none, back to the commission for the discussion. Commissioner Lassiter.
Mr. Chairman, so that's it. So the consideration of the final is on September 6th, so that would when we pass the final budget, September 6th. So we could potentially add another hearing here or there if something comes up that we need to discuss in all of that. Is that correct?
Correct.
Okay, just want to make sure.
All those in favor of the motion indicate by saying aye.
Aye.
Opposed? Motion carried.
Thank you.
Next item, Mike Cool.
Good morning. Mike Cool, Director of Buildings and Grounds. Buildings and Grounds are struggling to attract and retain employees in several positions, and I'm here today to request authorization to expand our hiring range for those positions. If you allow me, I'll discuss the three positions. B&G has had custodial positions open since May 2021. We haven't had a full staff for more than a year. During this time, thousands of people have looked at our listings that are advertised, and very few have applied. Our starting wage of $12.69 is just not competitive within the market we have to compete in. A recent survey that the HR had done indicates that the custodial wages have increased significantly. A midpoint now is for a custodial position is $16.80 for a wage. Furthermore, our building technician 2 positions, we've had open since the beginning of this year. We've also lost a couple of relatively new hires to higher paying positions. Generally, believe both of those left for $20 an hour positions. The building techs are kind of our building tech 2 is kind of the backbone of our, I don't want to make light of positions, but our building tech 2s are the people who handle the majority of work requests. They're kind of our handyman type of people. So any requests that are submitted from departments for work to be done, it's generally a building tech 2 that's doing that work.
Mr. Chair,
Commissioner LaCroix.
I don't mean to interrupt you, Mike, but you're absolutely right bringing this forward. You mean you have worked and looked at on some of your employees and what's been happening for quite a while. And I think what you're doing here is trying to get up to a competitive market. And me being in a field that works with both these positions, absolutely need to get up there because these do not meet the standards of what's out there right now. And I believe you're bringing this forward, trying to work with the problem and work for your current employees is commendable. So.
Thank you. To expand further on that, addressing current existing employees is something that we're also will be bringing further forward. Changing these rates will create some compression issues within the department. So that will be something we will bring forward to probably at the next meeting. Currently, our starting wage for a Tech 2 is $17.54. It's not competitive. Also, our building techs 2 is expected to go on call 1 week 24/7 on call duty after 6 to 8 months of time on the job. When they do this, they are people that they come in and they got to solve the problem of whatever's happening. Typically in the jail, they have to come in and solve whatever problem exists at that time. So they take on a lot of additional responsibility when they come in to do that. So we like to be able to reward them when they take after 6 to 8 months. We bump their pay because of that. And finally, I guess the last one is we have had 2 specialists, building specialists 2 positions. Construction is how we labeled those. I would call these equivalently as carpenters, experienced carpenters who can build and fabricate walls or anything that's needed to serve a purpose within the county. So these are some experienced people who've got years in a trade that I would describe generally as carpentry. And I would also add that these are rare turnover positions as well. What I'm requesting for currently our starting wage is $19.63, which isn't close to probably what one can make. And what I'm asking for is probably not these positions will probably remain open for some time. We're just going to have to advertise them, and when the right person comes along, they'll fill. I got to get us in there a little bit to be a little bit more competitive, plus address the compression issues that occur because of some of these asks that I'm requesting today. So for all these positions, I'm basically asking to expand the range for hiring limits. For custodians, I'm requesting we can hire up to a step 11. For a building technician 2, hire up to a step 7, and a specialist 2 to a step 7. Traditionally, those would all have been step 5 positions. under the current system.
Questions of Mike?
Mr. Chairman,
Commissioner Lassiter?
is this part of your already proposed budget to us? Is this all wrapped up in there, or are those numbers gonna end up having to change?
We can cover, with our current budget. We've run some, this would be committed this year, so we have enough money reserved, left over from not having filled positions that we can cover the cost. Next year, the increase, looks like we can absorb it.
So you'll update the numbers, if this is approved today, you'll update the numbers on your budget so we can see those ahead of time?
Sure. I can tell you that currently, with these changes requested, if we were hiring at the upper limits of any of these positions, that would add $9,000 to our budget.
Mr. Chair.
Commissioner LaCroy?
First of all, I just wanted to commend your staff for some of the work that they do, Mike, and explain a little bit about these building specialists too, and some of their jobs. You know, they actually save the county quite a bit of money instead of contracting out to do repair works and that. So if anybody's seen some of the remodels of some of the courthouses, I mean, some of your building specialists too have created the molds to fix some of the stuff to keep that historical. I mean, they've taken the pride and the know-how to create those molds and remodel them. So I just want to pass that on to not only the public, but some of the commissioners that they do quite a bit of specialty work that's not normal repair work. So, and in turn, that saves the taxpayers quite a bit of money.
Thank you for that. Yes, the challenges today to do things, especially remodel work in the courthouse, which is to most people who work for Pennington County, and I am certain with most of the citizens of Pennington County, the courthouse is a very important historic structure to them, and taking care of it properly is important. Having people being able to hire somebody with the skills to be able to replicate some of those types of details is almost impossible at times. Do that. So having some people on staff that really care about the facility and is important. I would add to that as well as just the nature of the type of work, the 24/7 operations that we have to take care of, particularly the jail. It becomes very, very challenging to be able to bring a contractor into an operating jail. So having skilled people who can come in and do work in the jail is an important thing that saves the county overall money because of the challenges. We just don't get people who want to deal with all the requirements that have to go to bring somebody into an operating jail.
Mr. Chair.
Follow up on that, Commissioner LaCroy?
My follow-up would be with a motion.
Okay.
I'd move to approve starting the wage range for a custodian A12 up to step 11 on the county wage scale.
Got a motion, is there a second?
Second.
And a second. Any public discussion? Back to the commission. Further discussion on this motion. All those in favor of the motion indicate by saying aye.
Aye.
Opposed? Motion carried.
Mr. Chair,
Commissioner Roskinek.
I'll do motion 2. Move to approve the starting wage range for building 1 technician 2, B21 up to step 7 on the county wage scale.
Is there a second?
Second.
Got a motion and a second. Any public comment on this? Being none, back to the commission. Any further discussion? All in favor of the motion indicate by saying aye.
Aye.
Opposed? Motion carried. Motion 3,
Mr. Chair.
Commissioner LaCroy.
I'd move to approve the starting wage range for a building specialist 2, B22 up to step 7 on the county wage scale.
Second.
Got a motion and a second. Any public comment? Seeing none, all those in favor of the motion indicate by saying aye.
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 Opposed? Motion carried.
Thank you.
Thanks, Mike.
Item 15, items from emergency management. Dustin.
Morning, Mr. Chair, members of the commission. Dustin Willett, Pennington County Emergency Manager. Before you today is annual review of the local emergency operations plan. This is an annual function that emergency management brings before you. The challenge is the document is restricted to distribution, so it doesn't get included in the packet. Changes for this year are simply updating phone numbers and numbers that change annually. No substantive changes in the plan, no procedural changes in the plan. We just go through every year and make sure numbers are current, names are current, and statistics used are current. So there's no substantive changes, but it is a requirement for our grant process with the state that we review our LEOP every year, and that is adopted by the commission. So that's what's before you. Happy to stand for any questions.
Questions of Dustin?
Mr. Chair,
Commissioner LaCroix.
I'd make a motion to acknowledge the completion of the annual review and local emergency operation plan.
Is there a second?
I'll second.
Got a motion and a second. Any public comment? Not seeing any. Back to the commission. Any further discussion? All in favor of the motion indicate by saying aye.
Aye.
Opposed? Motion carried.
Thank you for your time.
Mr. Chair,
Commissioner LaCroix.
I'd respectfully ask for about a 10-minute break before we go to item 16.
Second.
Got a motion and a second for a 10-minute recess. All in favor indicate by saying aye.
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 Opposed? Motion carried.
We're ready.
Call the commission back to order. Next item is 16, which is first reading and public hearing on ordinance number 737, an ordinance for the imposition and collection of a wheel tax in Pennington County. And, 2 years ago, we adopted a $2 wheel tax in Pennington County. State authorizes us to have up to a $5 wheel tax, and that's what I'm proposing that we move to at this point in time, is move to the $5 instead of just the $2 at this point in time. There are 27 other counties that have actually imposed the $5 wheel tax. 17 counties that have a $4 wheel tax. There's one county with a $3 wheel tax and 15 counties at the $2 wheel tax, including us. And then there's 6 counties with no wheel tax. When the legislature in 2015 chose to establish the separate fund, the big fund, the Bridge Improvement Grant Fund, they said counties cannot apply for these funds unless they have a wheel tax in place. Municipalities could apply without having a wheel tax, or any other stipulations, but the counties had to have a wheel tax in place. Pennington County at that time attempted to impose a wheel tax, and I don't remember the dollar amount. Was it at $5, Holly? Do you recall?
I apologize, I don't remember.
Okay, so I think it was at a $5 wheel tax back in 2015 in order to be able to apply for the big funds. That was referred and defeated. Consequently, as part of that, what the county commission had done in counting on those dollars coming in from the wheel tax, they had reduced the amount of money for the highway department by an equal amount. That money was never put back in after the defeat of that. So the county's been losing approximately $2.5 million each year since then because of that particular action. So transportation right now, our highway department is down about $18 million from day one of this to today. We did implement the $2 2 years ago. It's generated just a little bit over 1.4 million for an annual wheel tax. Because of that, we were able to collect over $2 million from the big funds, but we are a little bit handicapped on the big funds because of only the $2. It works on a point system, and so if you only have a $2 wheel tax, you have to basically contribute more local dollars in order to get those match dollars. And so we've done that. I think we've done well with our applications. I think our applications have been very deserving of the consideration that we've received. But at the same time, we know that we're not gaining as much as we need to be relative to our bridges and roads. And so that's why I believe that we need to increase this to the $5 starting for 2023. And so that's the proposal that's before us. Joe Miller, I'd ask if you'd like to come up and just give a little bit of explanation of where we're at with our roads and bridges at this point in time.
Good morning, Commissioners. I think it's still morning. Joe Miller, Pennington County Highway Department. Appreciate the opportunity, Chairman Drews. This is a need, and I appreciate Gary bringing this back forward. As he stated, the county highway department has been operating down approximately $2.5 million down since 2015, equals out, with the 1.4 that we generated last year and what we're projected to be this year, it's around $18 million. That's funding that could have been used to upgrade our roads, keep our pavement in good condition. Over the last several years, our pavement condition has been going down. Our bridge condition has been going down. Just since I've been appointed to this position since 2018, we've had two major bridge collapses, one on Nemo Road, one on 164th Avenue. We had another bridge on Nemo Road that we had to close down to one lane due to it was imminent to collapse, just like the other one on Nemo Road did. Our bridges are unfortunately in deteriorating condition. There was a lot of bridges that were replaced after the 1972 flood, so they were replaced in that 72 to 74 range. So they're getting up to that 50 years of age. The average lifespan for a bridge is approximately 50 years, is what the expected lifespan of a structure is. We have 89 of those bridges that are needing replaced in the next 25 years. So currently, our average cost for a bridge constructed or reconstruction is $750,000, what we project for the next couple of years. With that being said, to replace 89 bridges over the next 25 years, and mind you, some of those are going to get to the end of their lifespan sooner than that, we need approximately $3.5 million annually over the next 25 years to get those structures replaced. With that, I guess I'll stand for any other questions that you may have.
Mr. Chair.
Commissioner Roskinek.
So Joe, I had a phone call last night from a lady, and she asked me what bridges are we currently working on that we can thank the big fund. And I told her the two on Thunderhead Falls and then one at Johnson Siding.
So we have the Sonquist Lane Bridge is one that is being done with county funds, but the wheel tax helped fund that. We didn't get a bridge improvement grant for that one. There's two on Thunderhead Falls. There's one on Sherman Street going into Silver City. There's also 4 preservation projects that we received funding for, 2 on 161st Avenue in New Underwood, just south of New Underwood there, one on Neck Yoke, and Sean, the other one eludes me, Lower Spring Creek. And so then going forward, we have 6 more preservation grants on the docket to apply for next year, which is another $2 million worth of grants. And another thing to note with the big funds is they just increased, I believe it was the Senate, just increased the limiting amount of funding going into that pool to $32 or $33 million. It was $15 million. And the state also chose to up the average rolling dollar amount from a $4 million over 3-year cap to counties to an $8 million over 3-year cap. So before they did that, in a 3-year time span, you could only get $4 million worth of grants, which we're already to half of that in year 1. So there's more money in the pot, and the state, it's generating more money for grants than the state originally thought it was. And now they're going to, from our conversations with the DOT, they're going to look at that every year and kind of evaluate how much money they have to put into it.
And another thing I'd like for you to point out is what funds the big fund. other than excise tax, license fees, and fuel tax.
Correct. So I pulled up it was a little over, it went from 3% to 4% in 2015, and that extra 1% is what part of that is going into the big funds. Prior to us having a wheel tax, we weren't even able to apply for that. So that 3% to 4% was about $27.2 million, and the county's paying into a portion of that.
And if the taxpayers like to see some of that money come back to us, we have to do the wheel tax.
That's correct.
We're kind of scrapped.
And we, to maximize our opportunity, because it is a competitive grant program, there's 66 other counties that put in for these same type of grants. So to increase our competitiveness and increase the funding, because these grants are something that we have to pay for up front and then get reimbursed for.
And the last thing I'd like to point out is that there are counties that don't implement the wheel tax, but those are counties that don't have that many bridges. Pennington County has 127 bridges.
Correct.
Joe, I think the other thing that in the research, it showed that the other alternative is going to a levy on roads and bridges, which goes back to the same property tax owners, where this is more of a user fee where everybody that's licensing vehicles is going to pay the wheel tax.
That is correct. Yeah, I did during my budget presentation. I think the max levy for on the property tax was 60 cents per thousand, and based on the valuation for the county for 2021, would have generated a little over, or about approximately $6.5 million if you were to go that route.
Say that again?
So if the county commission, instead of implementing a wheel tax, chose to go the road and bridge levy based on 2021's valuation, would have generated $6.5 million to put into the road and bridge fund. It was 60 cents per thousand is the levy.
And that would stay in the county?
That would stay in the county directly, yes.
So with that road and bridge levy, would that qualify you for the big funds?
No, it would not.
So yes, it generates more money, but that's the 1% that's getting made and put into the big fund from our county, we wouldn't be able to recover.
That is correct.
Mr. Chairman,
Commissioner Lassiter.
is there a minimum we have to put on that, or is that just at a certain rate that you come up with that 60 cents, or is that just the minimum you can put on as that levy?
That's the 60 cents per thousand is the max that you can put on. So I just did the max generation.
The max, okay.
I think you can do any sort of portion thereof. So whatever, if you wanted to go to the 2.5 million or the 3.5 million or whatever that dollar amount, you just have to back into that.
Other questions of Joe? Thank you, Joe.
Thank you.
I do have speaker request forms relative to this. We're going to limit speakers to 3 minutes each on this. First speaker I have is Rachel Hayworth.
Good morning, I'm Rachel Hayworth. And I'd like to ask two questions. One is, who's in charge of that $5 wheel tax for the fund? Where's that going to be appropriated? And who's going to oversee that actually goes for the roads and the bridges?
The law says it will go in your highway funds. It can't be used for anything else other than highways and bridges.
Okay. Two, I'm an owner-operator here based in Rapid City, and we pay a heavy use tax of $22.90, of $585 per truck, plus we have IFTA, which is international fuel tax, which we pay in every state for every road that we run in. And so I'm wondering if a portion of that is projected into the highway fund as well?
I can't tell you the breakout of the highway funds, and I don't know if Joe can, off the top of his head, tell you that either.
And also, we have a 30-cent tax on gas at a state, 18.3% gas for federal, 24.3 for diesel. That was also supposed to help with the funding of the roads and the bridges.
Well, some of that actually goes into the big fund, not the federal part of it, but the state, some of the state part of it does.
So I believe, and I don't know the revenue that we get from the gas tax, but the gas tax, the state gas tax, largely goes to the state. That doesn't fund the counties. I think we get a very, very small portion of it, and I think it's like $10,000 or $15,000 as part of our revenue. That gas tax doesn't get down to the counties. That's used to fund the state and the federal government. And then what was the other question?
The heavy use tax, the fuel, and like lottery and places, things like that, were supposed to go help fund the roads as well.
I don't know any of that.
Don't either.
Thank you.
Thank you. Tonchi Weaver.
Well, back when we referred the wheel tax, we had objections then that it was coercion by the state onto the counties, that the counties then had to compete. It pits counties against each other for the money. And Pennington County, being a large county and populated county, is going to and has been paying, is doing the heavy lifting for the rest of the state. Most of the bridge grants have been East River. So a lot of our money has gone to that. We can't do a lot about the 1% that's collected and submitted to the state. But if we decide to impose a $5 wheel tax on ourselves, then we will not be getting the return for our dollar. The levy that stays in the county is a far better option. And, my opinion of the wheel tax hasn't changed. I am a little disappointed because a couple of years ago when you instituted it with the emergency clause so it couldn't be referred, I looked for incremental increases, but we're just going for the gusto now, I guess. So I am disappointed. People are suffering. The lady that was here before me, obviously, she's suffering under the costs of government just to do business. And, we have to remember that all of the money that funds the county, the school district, the city, the state, and the federal government all comes from the same back pockets. So when we talk about new revenue, it's really not new revenue. It's just more revenue from the same sources. Thank you.
So Tonchi, up until this last year, when Pennington County was able to apply for those, there was hardly any western South Dakota counties that were in the position to even apply for those funds. So I think there's a total of 17 counties in western South Dakota of the total 66. So it certainly makes sense that most of those dollars went to eastern South Dakota previous to that point in time, and continue to go probably to eastern South Dakota at the present time. But with the referral of it back in 2015, when that put the stop to Pennington County having the option of collecting a wheel tax at that point in time, that really, overall, you just heard the statement from Joe, that really injured the county and its being able to utilize. In fact, we paid in for a number of years, paid into the state, and wasn't able to even make application to get anything back for it. So at least now we're able to apply for grants to get some of that money back.
To take one step forward and two steps back. Well, I would have to respectfully disagree with you, sir, that it put our county in, at a disadvantage. But I don't regret the 4 years that we had without a wheel tax. I feel that's money that stayed in the pockets of consumers and benefited the county in other ways. So thank you.
Thank you. Mike Mueller.
Thank you again, Mr. Chair, Commissioners. So many questions. I know we can't answer all these today. I know Mr. Cool, Mr. Miller all have preventive maintenance programs, hire consultants to do structural analysis, to bridges. I've got many questions, may not get any answers today. Of those 127 bridges, how many of those are private bridges? Or are those all Pennington County road bridges?
All Pennington County.
Okay, thank you. When was this last assessment done of labeling these bridges unsafe, putting load limits on them? Curiosity, is this a rush action because the emergency clause, as Tanchi said, takes it out of the people's hands again? That's a legislative trick that happens in the state legislature and many bodies. So that's, I think, probably has to be considered. When we look at a pay-to-play situation where it's almost like a raffle, you got to pay for more raffle tickets to win the raffle here in the state. And if that money can't be guaranteed left in Pennington County, how can we make sure our bridges are fixed if they're going East River? Some of the things that I would think we'd want to do as a county is prioritize our funding. When I ran for commissioner, I wanted zero-based budgeting from every department. That was going to be a request, and set priorities, making sure everything is set the way you improve your budget is necessary. And so, say Mr. Miller has an open winter and he's got some funding left from snowplow budget. Where does that money go? Is it stuck away if it's a reserve, or is it spent by another department? Those are the kind of things I would challenge to try and come up with ideas on how to not have to raise taxes, look at the spending side of the equation. And I know your provisional budget is less than last year, and that's commendable at this point in time. But I know safety is important, safety over everything. So, and your duty as a public official is to protect the citizenry to some degree. So if you have some thoughts on where money could be spent in other ways and not have to assess this tax again, we would appreciate it. Thank you.
I'll let Joe answer some of those questions.
If I may, the question on when the bridges are inspected. So we're federally mandated to inspect any bridge that's on the National Bridge Inventory, so the NBI system, every 2 years. So, and some of our bridges actually are inspected every year due to their poor quality. I don't remember exactly the quantity of bridges that are in poor condition. I believe it's 21 that are in poor condition. So they changed the rating system 2 years ago. They used to use a sufficiency rating to rate our bridges, and now they just use basically 3 different fair, good, and poor condition is how they choose to rate our bridges now. And we have 21 of those that are in poor condition, and I believe 17 or 18 of those are load-rated bridges currently. The other question, I don't remember exactly. There's a lot of questions there.
I think part of it is that every penny that's collected through the wheel tax, it retained in Pennington County, does not go anyplace else.
That was the other question. And then the other question, if we have an open winter, much like the one we did last year, we don't have any of our budgets, we have unspent funds in our budget, it goes back into our road and bridge reserves. So currently, we don't receive anything from the general fund, so everything that's collected stays in our road and bridge fund.
Mr. Chairman.
Commissioner Lasser.
Joe, can you, when you were talking about the bridge and how they changed the way they're rating, can you explain, and it's an easier way if you use the 2 bridges that are in my district that recently got it, was it just this year that they got that load rating? Can you explain that, how that all happened out? Because normally we wouldn't have put a load rating on them except for when they changed the protocol on how they look at them, right?
So the federal government previously allowed the engineering firm that was doing the inspections to use what they would call engineering judgment. So if there was a plan set available, but the engineering judgment and looking at the bridge structure said, oh, no, this bridge is in good condition, right? We don't need to load rate this. But the federal government changed that 2 years ago, and then basically said if there's a plan set available, you must rate it based on the plan set and how it was designed. So the 2 structures that Mr. Lasser is speaking about on 1416 were built in 1926. So as you can imagine, our vehicles were much lighter back then, so they were designed a lot differently. So when our engineering firm this year took a look at those, this was the first year they were looking at those structures because it was the odd year. They had to rate them based on the designs that we had on file. And that's why there was a load rating put on those bridges.
Mr. Chair,
Commissioner Roskinek.
Mike, just one thing we can probably all agree on today. The bridges are in bad shape and they need to be fixed. We're looking for funding sources. If there's something better, I'm open to it.
Mr. Chairman, can I ask a final question?
Lassiter.
Mrs. Weaver was up here and she said she would prefer the road and bridge levy. How about you versus a wheel tax?
If it was reasonable and it stays here, that makes more sense probably.
Okay, just asking the question. Thank you.
They both stay.
The reason I suggest
They
the
both
the
stay
wheel
here.
tax is the better option.
Wheel tax.
Is it captures everybody that has a vehicle, not just those that own property. Dan Richer.
Good morning. Yes. I guess we're right back to 2 years ago. First of all, you guys had a special meeting up in Hill City, very embarrassing. But you implemented the $2. And I really, when you told me that we can't run a petition because it's emergency funding, I told you guys that right then and there that you guys are going to nickel dime this thing right up to your $5. Well, it looks like you're just going to go for the gold instead of nickel diming it. And again, my biggest problem is this is extortion. I don't care what you call it. It's like paying the mob to protect you. You don't pay this fee, you're not going to get this money. That's extortion. I don't care where the money goes, where it comes from. It all comes out of my pocket and your pocket and her pocket and these guys' pocket. So I just think this whole big fund is a extortion. Okay, and I know it's legal, but that don't make it right. There's legal and there's moral. This is wrong. Taxes are immoral, period. But to add these, I wouldn't even ask you for a special meeting because everybody will bitch about it in the cafe, but they won't take the time to come in. So,
Well, Dan,
but that's where I stand.
We as a county or none of the counties in South Dakota created the big fund that was created by the South Dakota legislature.
No, I understand that.
Okay.
Now, the other thing, a couple questions. Lawrence and Custer jumped in right away on this bridge fund. I'd like to know how much they paid in and how much they got back. Just out of curiosity.
Mr. Chair.
I don't think anybody's looked at that. So, all right.
Thank you. I think, Dan, some of your answer would be the condition of their bridges. Were they bad enough that they categorized as ones that were selected to be receive the grant?
I understand all that, but they jumped right on it day one. They jumped right on it day one, and just out of curiosity, did they get their money back or not? Because they're smaller counties than we are.
Mr. Chairman, I have a question for Dan.
Commissioner Lassiter.
I'm going to ask the same question to you that I asked to Mike because I think Mrs. Weaver made a good point on it. Would you prefer a road and bridge levy rather than a wheel tax?
I know the wheel tax stays in the county, so it's apples and apples. So a wheel tax or a levy is no different. Because I know the wheel tax does not go to the state, it stays in the county for use. And the only problem I got with this whole thing is when they set up the big fund, and not the state, but the legislature, set up the big fund, every time you want this, you're gonna have to pay this, and then we'll give it to you.
Dan, I can fully agree. If you're charging the citizens a tax, and you're collecting it and you're holding it in a pot and you say, well, you can't get access to it until you add another tax. I agree with you in that aspect. You're saying you cannot get something without doing another tax. That is, I don't know if that's the right legal term, if it's extortion, or if there's another legal term, because I know there's different legal terms for different things. But I agree with you. I think that's inappropriate. And that is something that we should all be talking to our state legislators to have them remove that requirement, because I think that would help and it would stop that. my opinion.
But I know Joe talks to these guys all the time, counties to counties. He should be able to pull up exactly if they're making it,
Mr.
if they've
Chair,
got any advantage to it or not.
Commissioner Oskinen.
one thing that we really haven't discussed today, and I was asked that last night, is this wheel tax forever? And so I think the minimum is 5 years, if I'm correct. But something, you know,
No,
something that we
no
need.
offense, Ron. I've seen the state implement so many temporary taxes that never were temporary that, you know, that saying that's a temporary tax for the next 5 years, bullshit. You guys will figure out a way, make it permanent.
We saw that in the
Always
legislature.
do, always do. Thanks.
Lawrence Thompson.
She had to leave, sir.
Okay. That's all the speaker request forms that I have. Discussion back with the commission.
Mr. Chairman, I guess, if you don't mind, you know, y'all have heard me say it before, I'm actually a bit advocate of more of a sales tax rather than a wheel tax, because I think I've already done the numbers on it, I think it generates more, and I really think that, and I know, I'm pretty sure all of us are thinking it might be good, maybe I could be wrong, but I think some of our conversations, you know, but I think we should really push hard to see about counties being able to implement a sales tax rather than doing, you know, property tax or some of these other ones. I get it, we've got an issue with the big fund grants, because, and if you don't mind, Joe, how much are we currently eligible for through the big grant or the big fund? I mean, in general, I get it, it depends on what projects but what's the cost ratio when we have a grant? Is it like an 80-20? How's
So
that work out?
the minimum percentage that the counties are required to put in is 20%. So last year when we applied for the grants, we put in 30% to make up. So the wheel tax, they put 2 points per dollar basically. So we get 4 points because we have a $2 wheel tax. So if you have a $5 wheel tax, you get the full 10 points. So to make up that 6 points, make us a little more competitive, we chose to put in 30%. So you can go as far as, I believe, 50% cost share with the state.
And how much, just in general, let's say we did 3 bridge projects a year. And I'm guesstimating if we go on average to try to get them repaired 3 or 4, what would that bring back each year roughly in revenue if we got all 4 of them funded by the big fund? And I'm trying to process number in my head. I get it. Everything I'm asking you is in general numbers, but we've got to have something to kind of compare it to, because if I'm thinking, and I'm just putting this out there, if I'm thinking about that road levy that you mentioned, if we went down to 30 cents, that's 3.25 million. So the question is, what's the payoff on it? Do you see what I'm saying?
I do. I believe I see what you're saying. So roughly, so if we do 3 bridge projects per year, currently this year with inflation, oil prices doing what they're doing, contractors increasing their prices. 2 years ago when we did this wheel tax, the average cost of a bridge was about $500,000, what we estimated, what we've done them for over the last 10 years at that time. So this year, looking back over the last 2 years with the bridge that we have let and that we've seen let, the average cost is about $750,000. So if we take the $750,000 times 3 bridges, that's $2.25 million. 80% of that is funded by the state if we're successful on the grants. $1.8 million would come back to the county. So, and then $450,000 would come out of the county's coffer or the county highway department.
So we would get 1.8 million from the state, and then 400,000 would come out of the county coffers. So we actually could kind of recover most of that if we did a 30 cent, because that would get us about 3.25 million instead of the 1.8.
So that 1.8 is a grant that we get back, right? So you'd have to fully fund that. So that grant is coming from all the other 66 counties or 67 counties in the state, right? 66, right? So they all pay into that big fund, right? So instead of all the counties that are paying into that and the state funding it, it's all coming on the backs of Pennington County taxpayers instead of the entire state. So yes and no, I guess, is the answer to your question, I think.
Okay.
Mr. Chair.
Commissioner LaCroix.
You know, I think I agree with quite a few of the speakers, when this was implemented from the legislators, yeah, you have to do this, are you gonna get that? And it created some problems for the county way back in 2015 that we're trying to recover for. The $2 one, I even struggled with it back then. Ultimately, I voted for it because my main thing was trying to get the information out and trying to get input from, and get it out to the public, just like we are today, of what happened. And some good information came out today, because quite frankly, I didn't know that the money had already been taken out of your general fund in thoughts of that happening, because that was before my time. This talk of a road and bridge levy, absolutely, I will not support that. Not one bit. We already got a $2 wheel tax. You'd have both. The future commissions, when I'm gone, could increase both. So you're creating two. I won't support that, not one bit. I struggle with this because I kind of knew this was going to happen, but also I did not foresee the inflation taking place that's hitting every community across America today, including counties. We hear about it in our newsletters and in our conferences that we can't keep the same level of service that we could 2 years ago with what we have. So we're stuck with a decision on how to do this. I definitely understand every speaker that came up here and spoke on this part, but also we have a responsibility to the community as a whole for the safety and well-being of all, not just our area. Because we always have certain areas of town that we drive every day, and our road and our bridges are fine. So we think that it's unfair. But then we have other areas that aren't, which we've identified, that need to get repaired and keep up. So I struggle with this. Just like last time, I would like to continue this, but to get more input. But my fear with that is we're short one commissioner this meeting, would be short one next meeting. The time frame for this to happen and be effective to do what it's supposed to do would create some hardship. So I just wanted to communicate where I'm at.
Mr. Chair.
Commissioner Oskinen.
So what I've heard today is that we're at $2 now, 24 max, if I'm correct. We're thinking about going $5 a wheel, 60 max, but we haven't talked about anything in between. And I would be willing to continue this and discuss that idea. And as Lloyd said, we're missing one commissioner today, so I would make a motion to continue.
I'd second that.
I've got a motion and a second to continue.
Mr. Chairman?
Commissioner Laster.
I'd also like to point out, the emergency clauses got me hung up really bad on this. Whether I support it or not, I'm not, I really don't necessarily, I think there's another way that we can look at funding. And in other words, and Commissioner Drews pointed this out, whenever the original wheel tax was put in, the money is removed from the general fund from the highway department. I think we should look at that. If this doesn't go through, we need to look at reinstituting the funds so they can continue doing what they're doing if this doesn't pass one way or the other. But the emergency clause hangs me up a little bit because I think when you're putting in taxes, I do think the people should have a right to try to refer it if there's that possibility. I've heard a lot of people that are supportive of the wheel tax, and out in my district, out in eastern Pennington County, if it's going to fix our roads and stuff, putting it to a referral vote, I'm not opposed to that because it may not go to a referral vote if you're listening to the people out there. So I have a hang up of just saying we're going to do it with an emergency clause, and then there's no chance for the people to speak on it. I get we're in a time crunch, but I kind of like what Commissioner Roskinek said. Maybe we need to consider or talk about a different number, not 5, but maybe a different number in there. And I fully agree with Commissioner LaCroix. Your point was well taken. As if we do the road levy, then we have 2 taxes, and you're right. A commission after us can potentially raise either or, and I don't necessarily like that idea either. Good point on that one. So that's why I support continuing it, so we can have some more discussion on how to tweak it out. And if you don't mind me saying one more thing, and this is just the language of the ordinance 737, there's a statement in there, Joe, and it says tax revenue is no longer sufficient. I think it should be tax revenue has never been sufficient from this to support what you need to fix the roads. Just a small amount of correction from my perspective. Thanks.
Mr. Chairman,
Commissioner, correct.
sounds like I was heard, but I want to ask you, from my understanding, do we have the time to continue it in order to move forward? That's my question.
I don't, I don't believe so, to get it in for the final budget, September 6th, I believe. Holly might be able to speak to it. And if I may, one other comment, right? So in 2023, we just went through our budget hearings, right? And we had to take a look at all of our bridge projects and all of our road projects. We're doing a 2-mile overlay this year. We have 336 miles of asphalt, and we did 2 miles of overlay this year. Generally, an asphalt road needs to be overlaid every 20 years or so. We have a lot of roads out there, and our pavement condition is slowly declined. And you just approved in, I believe it was in April or May, we have a company coming in to do a pavement condition index. So it's not only our roads are in decline, it's our pavements, or excuse me, our bridges are in decline, our pavements are in decline also, because we don't have the proper funding to fund the pavement also. You know, nobody likes driving potholed roads or washboarded roads, but we don't have the funding to properly maintain those roads. Chip seal in 2017 or 2018 cost the county about $250,000, $300,000 for 33, 34 miles. This last year's bid came in at just under $1 million for 33 miles. So, and that chip seal is a major component of maintaining our asphalt roads. It keeps the moisture out of them, and it prolongs those roads. Crack seal is the same way. The other thing, going back to bridges, we had to cut projects, right? So Sherman Street in Silver City was one project that we got awarded a big fund this year, but we don't have the money to construct it next year. So that one has to wait another year. You know, the fire department is on the other side of that. So life and safety, right? So we've chosen to prioritize some things, and the funding's just not there. If the wheel tax is implemented, we'll have the funding to construct that bridge next year. Right? We would have the funding to do that. We already have the grant, but we just don't have the match to fund it next year. With that, I'll stand for any other questions.
Mr. Chair.
Holly, do you have something you wanted?
Just wanted to add in regards to the timing. Yes, the budget is something to consider. However, it's also working with the state. And when they send out the renewal notices, they will start sending those out for the January renewals in November, and then it takes timing for programming, so we're working against the clock to make sure that we send out accurate notices for that increase if the board so approves it.
So can I follow up?
Yeah.
So the question is to continue if, I'm assuming it's going to be the end of August before it would come up again. And if that was the case, is there going to be enough time to implement? And the reason why Joe's shaking his head, and this is one of the reasons why I struggled with this so much today, is because I knew of the timeline. And quite frankly, prices ain't going down. And I get what Travis is talking about taking money out of the general fund. Sure, we could take that 1.5 out. And then our reserve our goal of trying to keep our reserve is dropped. So one thing affects another. And we could sit back and, as Ron said, maybe do a $3 one. What are we doing? Are we kicking the can down the road again for the next commission that comes on, or next people? And then next year do the same thing to the people? Or do we take the max and do what needs to be done to get caught up with the inflation and keep up and maintain the roads that we have? You know, I respect my commission for listening to me and wanting to continue this, but I just think we can't. I think we need to make a decision probably today.
I tend to agree with Commissioner LaCroix. I don't think we can just continue it. In fact, I'm gonna allow anybody to speak on it, but I plan on making a substitute motion.
If-
For Ross Connect.
I will make a substitute motion to go ahead and approve as read.
Got a motion?
Timing's the issue.
I'll second that.
I got a motion and a second.
And that doesn't institute it, it's just the first reading, is that correct?
That's right. So I've got a first and a second on a substitute motion to approve the first reading of the ordinance as presented. Any further discussion? All those in favor indicate by saying aye.
Aye.
Opposed?
No.
Passed, from what I saw, 3-1. Item 17. Back at you, Joe.
Good morning. Well, I think we're back to afternoon, aren't we? No, not quite. Again, Joe Miller, Pennington County Highway Department. Item A in front of you is work order for engineering services on Deadwood Avenue reconstruction. So, about beginning of January, February timeframe, I reached out to the state. We were looking at a couple other safety projects, one being the Nemo Road and Bogus Gym, or Nemo Road and Norris Peak curves as safety projects, and kind of got my wheels turning as to why Deadwood Avenue isn't a safety project. So I reached out to the state, Dustin Witt, the manager of the federal safety dollars there at the state, and asked him, hey, could we take a look at this and maybe program this as a safety project? And he took a look at it and deemed that, yes, it would qualify for a safety project. So prior to that, the city and the county were splitting the cost 50%, 50%. The project was going to cost the county about $1.8 million at that time. That was 2 years ago. We've been working with the landowner on right-of-way negotiations. So with that being said, with the federal safety dollars, there's only a 10% match required. So the total cost of this project is probably around $3.5 to $4 million now. So the cost will only cost Pennington County approximately $200,000 instead of the 1.8. And this work order is for the engineering services for that. Now the engineering's already mostly done, but FMG needs to program this as a safety project and take a look at it and make sure the plans are up to snuff for that. With that, I'll stand for any questions.
Well, Joe, appreciate the fact that you searched this out to figure out a way of actually saving dollars. That is a badly needed project up there in the first place, has been for a number of years at this point in time. So appreciate the effort that you put into that.
Thank you.
Mr. Chairman.
Commissioner Lassiter.
Move to approve work order PD 11-22 with FMG Engineering Incorporated, the city of Rapid City, and SDOT for engineering services for Deadwood Avenue reconstruction.
Is there a second?
Second.
And a second. Any public comment? Seeing none, back to the commission. Any further discussion? All those in favor of the motion indicate by saying aye. Aye. Opposed? Motion carried. Item B.
Item B is an amendment to secondary road identification agreement with Ferber Engineering. So when we were first looking at Ordinance 14, we contracted with Ferber Engineering to take a look at just a specific area of the county where we knew some of these roads on section lines that weren't actually on the county system. So county currently claims or maintains 836 miles of road. We believe just since we've been looking at this, there's many more miles to be added. And to do that, we don't have the manpower in-house to do that. So we've contracted with Ferber Engineering to do the original part of it. They need to look at the entire county now that Ordinance 14 is passed. They need additional funds to look at the entire county and help us identify the number of residents that each road serves, as well as other additional roads that the county is responsible for. With that, I'll stand for any questions.
Mr. Chair.
Is there a motion?
Move to approve Amendment 1 of the secondary roads identification agreement with Ferber Engineering Company, Inc. in the amount of $12,000.
Got a motion and a second. Any public comment? Seeing none. All those in favor of the motion, or is there further discussion? All those in favor of the motion indicate by saying aye.
Aye.
Aye. Opposed? Motion carried.
Thank you,
Joe.
Commission.
Item 18, John Morrell.
Morning, Commissioners. John Morrow, Pennington County Human Resources. The item we have before you today is additional discussion around the suggestion to move to a 4-day compressed work week in the Pennington County Administration Building. This will actually be the fifth presentation, and I want to be sure I talk to the fact that this presentation and a lot of the data that's in it were prepared by Holly in your commission office. So I need to thank her for the amount of work and effort that she's put into this. And actually, I'm going to invite her, because you're probably tired of listening to me. I'm going to invite her to come up and actually speak to this. There's a lot of information, and I think there's a lot of data. You as a board had requested some additional data. So we have information in here about the employees. We have information in there about surveys that have been conducted on the second floor with customers in the treasurer's office and the planning office. But I want to make sure that we do address the questions that had been raised in the past. So if there are additional questions after we go through the presentation, I would encourage you to ask us whatever you may have. So. Move it? Oh, I'll do this instead.
So Commissioners, based on the request after our last presentation, we went back and did a survey of the public as the board requested. And we did it in the treasurer's office and the planning department. And as you can see, the overwhelming response from the public was in fact to support extending service hours to the public and being closed either on a Friday or Monday. I personally am surprised at the response of how many voted for a Monday. We actually had people request that we extend service hours with no close day. I don't know quite how we can accomplish that with current staffing levels, but just so you're aware, definitely overwhelming support with almost 85% of the public saying that they would support extended service hours being closed 1 day a week. So this all comes from a survey that we did from our employees way back when, and wanted to give the feedback specifically to the board of what the employees had to say. A lot of it, want it, love it, appreciate the flexibility, looking forward to more family time with the 3-day weekend, thankful for the extra day to be able to catch up on life things, appreciate the extra day to be able to make appointments without missing work. But there are some negatives that would go along with this. Some of the concerns expressed were that there would be less family time in the evenings due to the longer days, not getting home till after 6 o'clock. Child care, elder care, scheduling, conflicts with any school activities that maybe occur, pet care. We all have our critters at home that maybe not be able to go outside. And then difficulties in completing the tasks in 4 days versus a 5-day work schedule.
If I could touch just briefly on that last one. So, and we're going to get to the study actually from Microsoft in Japan. What they did to help alleviate some of those concerns in getting task completion, they moved meetings from an hour, which seems to be the standard, to 30 minutes. They also moved the number of meetings to being video calls and or just conference calls from gathering. Every time you have a group of people that meet, there's time before the meeting, time after the meeting, that that tends not to be used productively. They found ways to actually leverage the time that exists in those work days to make them more efficient and more effective. So I just wanted to offer that.
So again, more feedback in regards to what the board had requested. Commissioner Roskinek specifically was concerned about the title companies and the financial institutions, and had asked about the city of Rapid City. Registered Deeds Audra Castile had reached out to the title companies, and the feedback is shown here. One was supportive, one prefers the traditional 5 days but was willing to adjust their operations, and one was not supportive and is expressing concerns. Financial institutions, no known impact. City of Rapid City, my understanding is not currently discussing at this point in time. But other local entities are utilizing a 4-day compressed work week, and those are shown there as well. And interesting, Custer City Hall, effective August 1st. They will be open from 8 a.m. to noon and closed in the afternoon on Fridays to allow their city employees to catch up on their work for the exact reason that they're just overwhelmed and need that time of no interruptions to be able to complete their tasks. We did some other research. Other South Dakota counties that have altered work weeks are shown up there as well. Again, we have to take into consideration how big these counties are and how many employees that they have in their respective offices.
This is the test that I mentioned, and Travis, this is the one I referred to, where they had tried this and then reverted back to the normal schedule. This was done just as a 1-month challenge in Japan in the August of 2019, so a few years ago almost to the date. But they called it the Work-Life Choice Challenge of 2019 summer. Kind of a clunky name, but that's what it was labeled. They did see a substantial productivity gain. The benefits were that the employees felt that this was an advantage for them personally. Again, it's a pretty busy economy. They saw a reduction in electrical use. They saw a reduction in work-related printed pages, and I thought that was significant. Again, by reducing some of the meetings and reducing the number of hours that are actually in that setting, and the number of days, I should say, it actually reduced the amount of pages that were being printed in their offices, which is substantial. If you can reduce our supply use by 58%, it's pretty amazing. They also, and I mentioned this earlier, 46% transition to 30-minute meetings from an hour. Again, huge productivity gain because of that. 21% increased use of remote meetings and a 10% increase in internal networking to help get tasks completed. So they saw an increase in improvement in teamwork to actually get those things done. So,
Mr. Chairman.
Commissioner Lester.
John, why did they transition back?
it was just a 30-day test. As it says in the bottom bullet point here, they're actually trying different tests now in different countries around the world. Being Microsoft, you've got a presence almost everywhere, but they're looking at different countries, whether it be artificial intelligence, different types of technological solutions for some of the tasks that they perform. They're looking at different options to see what might be best. But it was presented to that group of employees as a test, and once the test ended, they did an analysis. So I printed out the analysis. It's way more detailed than I would have imagined from something like this, but it was like 75 pages of data from that 1 month test. And they've got graphs and charts, and it's crazy. But it was just to see what would happen. No, great question, though, Travis.
And we weren't able to find any other specific examples of any that did go back.
No, yeah, very good point. True.
So this slide just shows what the current operations are for the different offices and departments within the county.
Any surprises or any, I guess these are standard operations and have been for extended times, but we wanted to make sure you saw what we currently had in place.
Yeah, so basically the biggest benefit of going to a compressed work week would be the expanded in-service person hours for our citizens. On any given day, you can go in front of our building and we have people lined up waiting to get into the treasurer's office before 7 a.m. So this would definitely give expanded service hours for those individuals. Better quality customer service, reduced employee turnover, ensures higher skill levels.
So the reduced employee turnover, that's been some of the feedback from some of the other locations that have tried this. If you have an employee that's happier with the work environment, feels that they're being productive, they're being listened to, they're being respected in the fact, the type of work that they're doing, they tend to stay with those employers. So again, it goes back to the culture theme that we've had in the past. This is something that I believe, and again, would show that we'd have a reduction in employee turnover. It also, so I shared this with one of the elected officials earlier. As I'm in the back of the room here today, and I apologize for this interlude, I got an email from World at Work. Now, World at Work is one of the premier companies, if you will, that analyzes compensation, benefits, total employee rewards around the world. The email they sent me this morning was about the 4-day work week, and it says, is this the new norm? They're analyzing this constantly. They're getting a lot of feedback from employers, not all public sector, but private sector as well. This is being looked at on a number of fronts as a way to entice people to work for you and then to also stay with you as an employer. It is the future of work, in my opinion, and something that would give us an advantage when we're looking at recruiting and retaining employees. So,
Just remind us how this discussion was initiated in Pennington County.
oh, so initially it was the questions we asked initially this past winter or early spring. What are the types of things you'd like to see? And the feedback from employees, the feedback from the departments has been some of the different options, whether it be benefits that we could offer, childcare or elder care, and then also the work schedule flexibility and a 4-day work week. So this is one of the things, and then we just started to pursue that a little bit more. Would it be possible? What would it take to actually make that happen? How would it work if we did decide to implement that here? So that's been these presentations we've done have offered additional data over the last couple of months. What we have now today is additional data, I think, that helps support that and maybe explain what might be possible if we were to make that choice.
Mr. Chair,
Commissioner LaCroix.
just a question. I had a pretty long conversation with a person last night concerning this 10-hour work week and where did it come from. And I think you explained that.
Yeah.
He felt the survey was skewed, but I don't know if anybody else looked at that survey. I didn't see it skewed at all, but he voiced his concern on that. I'm just expressing his concern
No, it's
now
good
so
to hear.
he can view in on YouTube and see that. But one of the biggest things I think, we touched on was we talked about the employees, but also the service to our customers. I think you guys that's what pretty much initiated, as Holly just said, we had people lined up at 7 or 8 o'clock in the morning waiting for that. That's not saying that if we go to 7 o'clock in the morning, we're not going to have people at 6 o'clock in the morning waiting to come in. We could get a whole new group of people. But the biggest concern, what a lot of this brought this on was customer service, is how to better serve our customers, our community.
No, thank you for that, Commissioner. So the additional data that we had on one of the slides here where we talked about there's 80-some employees already on this type of a schedule, there's 100 plus. That was a survey we sent directly to the elected officials and the department heads and asked them to speak with their people directly. So we wanted the additional data, we wanted the additional feedback, and then that's what we received. As part of this presentation, we wanted to make sure we had that, to make sure we hadn't missed anything with the initial survey. Other questions or comments about this page before we move on? Okay. So, go ahead. Okay. So there is concerns. And again, you saw, roughly 85% said that they would support a 4-day work week because it gives them access before normal business hours and after business hours. But there still is concern from that additional 15%. Well, what if? What about? You're going to have that. Some of the things from the HR perspective that are concerning or things that we have to work through, I don't think concerning is the right word. Leadership has to be able to consider other ways of doing things in their offices. whether it be a different type of communication process, a different type of process that they actually use for completion of the tasks that they have. We have to make sure that the employees understand. The expectations are you still have to get your work done. You still have 40 hours of work. That's not changing. But the expectation is you're going to have to be able to do that in those 4 days then, because it's still 40 hours. We're not asking you to be less efficient. We want you to be as efficient or more efficient in the pursuit and completion of those duties. There is a potential challenge to the stress of a longer workday. Now, personally, I used to own a bakery, so I'm usually up by 1 or 2 in the morning. That's just kind of my nature anymore. I can't help it. Not everybody does that. I'm hoping that most people in the world have more of a normal timeline and they get up at 5 or 6 and do their thing. There is stress because it creates a challenge and a change in what we normally do, the patterns and behaviors that we have of what a normal day looks like now compared to what a normal day would look like in the future. So again, the challenges are, how do we make sure people are being efficient and effective? We have to make sure that the departments are able to change the way they look at work, and then understand that there could be some employee challenges with regard to those schedules.
Mr. Chair.
Commissioner Roskinek.
So John, I had the two title companies reach out to me the other day, and one of them does have some major concerns.
Sure.
Another one, they both have agreed to sit down with me in the Register of Deeds to see if we can address their concerns. So until I do that, I will not support this.
Okay. Nope, I appreciate that. Thank you, Commissioner. I think there's ways of balancing the needs of our customers, and by expanding our hours, like I say, before and after normal office hours, that helps address a lot of those things that they might have been concerned with. So, my opinion.
All right, so what's in front of the board for consideration today is to move to a compressed 4-day work week. The proposal is to be open to the public Monday through Thursday from 7 a.m. to 6 p.m. And the board wanted additional information on what that would look like specifically for the individual departments within this building. So your first slide here is addressing the state's attorney and the public defender's office. As we all know, they are directly tied to the unified judicial system, so they will continue to staff Monday through Friday. They would like to they are utilizing flexible schedules for their employees and remote work options when applicable. The ideal operating structure for them would be limited public access on that closed day. We've met with Buildings and Grounds and IT, and the system that we are looking into is this camera phone system. There's a picture of the one that is currently being utilized over at the CARE campus that would allow them to bring people in on that closed day and still be able to provide services and conduct business, but would restrict access so that we don't have any security concerns from that aspect. With them, daily operating hours would need to be determined based on what their demands are and what staff availability is. Next department would be the treasurer's office. She would also have partial staff working Monday through Thursday and partial staff working on Monday through Friday. More staff available for front window coverage over the lunch hours on the open days. She would not have public traffic or phone calls on that closed day, which would result in increased productivity, and staff that is working would solely focus on processing the mail-in traction. Staff will focus solely on that, processing the mail-in transactions, processing title work. There's always the convenient options for citizens that are available for renewing vehicles online or at any of the kiosks. Property tax payments can be made online or through the drop box and through the mail. So the other offices that are in this administration building: Auditor, Commission, Emergency Management, Equalization, Fire, Human Resources, Planning, and Register of Deeds. Also utilize flexible scheduling, limited remote work options, and authorized staff may work on closed day if necessary, but most would not have staff in here on that closed day. IT, they support 24/7 operations, so they will be here for 5 days a week, limited staff, and will continue to adjust schedules as needed. 911 is in this building. They are a 24/7 operation, so they would not, this change would not affect what they currently do. Same with the sheriff's office. They are a 24/7 facility. They have unique demands, and so there would not be a change with the sheriff's office. Other departments located in different locations around our community, buildings and grounds, again, they also support 24/7 operations and would continue Monday through Friday. Look at various shifts and flexible scheduling. Highway and natural resource already work their 4-day. And Health and Human Services, again, another unique office. They may look at a compressed work week in the future, but as of now, they will continue their shifts as they currently have them. If this were to be implemented, we would have to look at our holiday observance policy. For right now, if it is implemented in November, we have 2 that we would need to look at, and we would just keep those in place as our current policy states, but then revise it prior to 2023. So with that, we will stand for any questions the board may have. I know the board has some public comments that would like to hear, but we're happy to answer any additional questions, and I'm sure department heads would also be happy to speak as well.
Mr. Chairman,
Commissioner Lassiter.
question for you, Holly, or either one of you who want to answer this one. So looking at the public survey, it looked like Monday was the preferred day to be closed. Why did we opt to go from Monday to Thursday versus Tuesday for Friday? I mean, that's just an obvious question right off the bat.
Well, honestly, that's probably selfishly on my part because we already have a planning commission that meets on Mondays. We can certainly go and change their bylaws and change the schedule and move them to a different date. But also the fact that commission meetings are on Tuesdays and we spend Mondays getting ready for them, just seemed like that would be a harder implementation than a Friday because of set schedules and practices that we already have in place.
Gotcha.
Holly and John, Ron mentioned the Register of Deeds wants to work out some issues there with, especially with the companies that do business with them. But Treasurer's Office, I understand, is would really look forward to having the close time of not having customers at the windows and so forth to allow them more time for going through the information. And Holly, instead of hearing this directly from Janet, I know that you spent some time up there last week looking at what the requirement is of an employee when they're dealing with what comes into that office. From your perspective, would you like to explain that a little bit? Because I think most people just think at the treasurer's office, you go in there, you get your license renewed, you pay your taxes and so forth, and there's not a lot of detail that goes on. Where in fact, there's a lot of detail and a lot of liability concerns.
Yeah, I really wish we could get the full understanding out to everyone of how complicated and how difficult the work is that the treasurer's office does. Those employees are just amazing to me. When I first started with the county 13 years ago, I went and sat in the treasurer's office to learn what they do. And in an hour's time, we did 3 transactions. And every single one of them was from a different state. Every title looks different. The amount of information that they are responsible for in making sure that it is accurate, that they have real documents, that they're not fraudulent, that they are completing it timely, accurately. I can't even put into words accurately how much work and how hard those staff members up there work. They are truly unsung heroes in my mind because it's crazy how much they have to go through. So you take that times 50 different states. You take that times the foreign registrations. I mean, Janet showed me the other day a title that was in Japanese that they have to have translated. People don't understand how much that staff goes through, and they're amazing, and they work so hard. And with South Dakota being an open state, they're working on thousands of out-of-state registrations that get mailed in every day. And that's what they look forward to being able to process on that closed day without additional challenges. So,
Thank you.
a lot of liability up there on those employees, and they do an amazing job. They really do.
Commissioner LaCroy.
Thank you. I'm going to follow up on Mr. Laster's question. Quite frankly, I've been thinking about that quite a bit. Why not Monday instead of Friday? The end of the work week, people are done. They're at the beginning of the work week, they go back to work. They're trying to get their stuff done. So I see the Monday as, for the customer's part, seems better, and it seemed like that's what the survey showed. And I understand your part, but why couldn't the commission move to Wednesday instead of Tuesday? If that's something this commission wanted, we could move to a Wednesday instead of having every Tuesday. That'd give you the same. Just throwing that out there.
The only other thing that I could think of is of how many Monday holidays there are. And if that was something that was in their minds when they were looking at that, thinking, well, we have a lot of Monday holidays, they would already be closed. That makes sense. I don't know if that has anything to do with it, but that was just one thought that came into my mind, that why they would pick a Monday.
Well, from a person who worked for 27 years in a 24/7 manufacturing facility with rotating 12-hour shifts to where you worked weekends, you had every other weekend, same as our jail and our emergency services do, which, I got concerns from them too. They go, oh, this was unfair. But no, really, it's not quite that unfair, because you get rotating shifts, which you get, just as you made reference to, is during the week, you can get some of your stuff done during the week. And so it works kind of both ways when you work 10 or 12. I worked 12-hour shift rotatings for 27 years, and I think my last 3 years was 10 hours, doing just exactly what you guys are doing. And quite frankly, I wasn't in for it either. It was opted to me to do as an experiment, and then once I started doing it, I actually liked it better. I knew once I got my structure down, and I think just like the public and your family, once you get your structure down, then you learn to adopt to it. Just like rotating shifts, it takes you 3 months or a month to get structured to it. So I think what you guys have done is brought forward some good ideas. I think we got some hiccups, and I think change is hard, not only for staff, but also for public. This is a whole new concept that not everybody's on board with.
Right.
And how do we work with these title companies? If Ron meets with these title companies and they find out that Monday is a better day, because if they know deadline Fridays to get my titles done, they can work with that and plan with that, because they can tell their customers it'll be 3 days now, if we don't get this done by Friday. Is that a possibility? So I think I have to commend our department heads that are already, that's one thing that I believe COVID's done to us, is to make us think outside the box and start changing things around. It's not about the employees, it's about having the workforce. So I just want to pass.
Mr. Chair.
Commissioner Roskinek.
Can I have Auditor come up with register of deeds and see if we can work out some of the problems with the title companies? So if I go this direction today, would you work with Sam and Greg?
Oh, absolutely. I have no problem working with the title companies. And actually, I have a third. Dakota Title will be coming on too. So there will be 3 title companies. I've talked to all 3 of them, and the information that Holly included in the slide was exactly what they all 3 told me. They all have concerns, but Greg Wick of Pennington Title has told me that he would be willing to work with us on that. And Dakota Title would prefer that they're the one that we
would prefer the traditional work week, but they said they would make arrangements or they would figure out how to work within our 4-day work week if that's what we chose to go to. So, but I have no problem meeting with them, discussing any issues they have, discussing any issues that any of you have. I'm all open-minded for anything.
Okay, and I told them that I would try to set up a meeting with you and them and then in the third title company, so if this is the route that I go, then you'd be willing to sit down with me and them and get that worked out. Other than that, I haven't had any real concerns, but even as a real estate appraiser, I rely on the register of deeds to verify my data.
Right. I've worked in real estate for 20 years. I know the ins and outs of it. I know the concerns that they've brought forward, and they're valid concerns, but I think there are ways that they could work around them as well.
Okay, well, I appreciate your willingness to do that.
Okay. Any questions from anybody else for me?
Any questions, Register of Deeds? Thank you.
Thank you.
Appreciate it.
I like it back here.
Commissioners, any question of myself or Holly at this point?
I don't. Does anybody else, any other commissioners have any questions?
Do we have public comment on this?
Oh,
yep,
sure.
I do.
One thing I will point out quickly is the difference between the Monday and Friday is it's basically 50-50. The Friday was 50.2, or I'm sorry, Monday was 50.2%, and Friday was like 49.8%. So if we're focused on Monday, I just want to make sure that the board sees that it was basically a 50-50 split, and some had no preference.
Yeah, quite frankly, holidays, whatever that, and there's people that will sit down and figure those out. If most holidays are on a Monday, well, then you're off, you get paid for that. And I think we have, one floating holiday?
Not anymore.
Not anymore.
Not anymore. Okay,
They're all fixed on the 11 days that were identified this past year.
There's pros and cons.
Sir.
Okay, we ready for public comment? Okay, I have Jeanette McIntyre.
Good morning again.
Morning again.
Good morning again, Jeanette McIntyre. I basically kind of cut my teeth on a 4-day week issue many years ago with the Custer School District. And at the time, I understood that it's a good idea for the employees, and I understand it's a good idea for employees here. A longer day works, and they have an extra day off. The 3-day weekend is an ideal thing. But it's never in the best interest of the customer. And it was never in the best interest of the children in the school district. To take away 20% of their education period, which was 1 day a week, and probably their morning hours, which is their best learning time. So I fought it and we lost. So now you see Custer School District was the first district that went to the 4-day school week. And I predicted after that they would have many, many more, and we've seen a third of the state go to that. But I come back to the same premise. It's not in the best interest of your customers. And so I think I would come out and say I'm against the 4-day week for your employees, but I'm really not. And I think that might come as a surprise. I think the 4-day work week is a good idea for your employees. So I think what I would like to see you consider is a 4 10-hour days, but still be open on Friday. Let your departments work out their schedule, and maybe that would indeed require additional employees, but they would in fact still be serving the public. Even better, it would be a win-win for the employees. Maybe some employees work Monday through Thursday, and the other employees work Tuesday through Friday, but they're still able to work their 4 10-hour days. So I think there's a compromise maybe, or a way to look at it differently than what we're just kind of trying to slap together and take away services from the public. So I think if you would consider that as an option and have your department heads look at how they could look at that in structuring their people to work. And I know it would be tight. It would be hard to do with less employees on certain days. But if you look at your Tuesday, Wednesday, Thursday, you'd have a full complement of all the employees that you had. But your hours would still be increased from whatever they're suggesting, 7 to 6, on Monday through Friday, which would be a good service to your community and the people that are using your services. So I'm in support of their 4 10-hour days, but I'm not in support of cutting off Fridays or cutting off the 5th day of services to your community. Thank you.
Any questions of Jeanette?
Thank you.
Thank you. Dan Richer.
Back again. I think you all know where I stand on this thing. I have my comments last time. The only thing I'd like to point out is the county, they're not employees. They're better than employees. They're servants of the people. And that they serve the people. And I am not a customer. Customers come into a place because they want to be here. I'm a taxpayer because I have to be here. I got to get my taxes paid, my burden. So I resent the fact that they keep calling us customers because we're not customers. We're taxpayers. I don't think anybody is in this building because they want to sit down, drink coffee with people. They're in here because they have to be here. So that's that, and you all know where I stand on this thing. So, thank you,
Mr. Chair. So Dan,
Commissioner Ross, can I?
so the servants and the taxpayers. Well, you got to have servants to work with the taxpayers, and this is what we're trying to address. We don't have enough servants. They're not. We're looking for alternatives so that we can get servants and keep those servants longer, so they can provide the services to the taxpayer. And one of the ways to do that would, same number of hours, just be 10 hours a day. And I think there's pros and cons to everything, but the 10 hours would allow those taxpayers to come in an hour early or an hour later to provide services to the taxpayer. So, it's a double-edged sword.
Well, I can tell you this. I mean, I was responsible for 2,000 people at one time. And we had it all split up with the supervisors supervising 100 people at a crack. But we worked 410s 24/7. But we managed to do it minimal crew on Monday, Wednesday, and Friday. Your junior grades all had to take Wednesday off. And the supervisors worked, well, I had to work 24/7, 7 days a week. So I got more time on the telephone. I got in my own bed there for a while. So, but yeah, it's doable. I'm not saying it's not doable. I just wish I'm a taxpayer. I'm not a customer. When I walk into Shields, I'm a customer. But when I walk into here, I'm a taxpayer.
So do we all agree that we're servants?
And I agree. I'm proud of my 30 years of service. So, and I feel it more important being a servant than to be an employee. So I feel like I don't have an obligation. If I'm an employee, I don't have an obligation. I can quit any time. I'm a servant. That's higher. And it also reminds you of the fact that you're there to serve. So that's where I'm at.
I think everybody needs to be reminded that one of the challenges that we have is not only retaining good employees that we do have, and we have exceptional employees, I think, in Pennington County. But at the same time, we need to be able to, I don't know of a department that isn't short on employees at this point in time, simply because we have not been able to hire. And the number of applicants is way down compared to what it normally was. And I'll say this is prior to COVID days. And so not only do we need to be able to hire people to fill those positions, but to retain individuals. And so this is a discussion that really came from the employees, from the department heads, for our consideration. And so that's why we're hearing it. Mike Mueller is the last form I have.
Thank you again. So emphasis on public service. If the service maintains or improves, how will we get the feedback, like the survey that went out for 2 weeks to ask what their preference would be, Monday, Friday, or no, for an off day? What kind of feedback will go through the departments asking if that service has improved now, if this is instituted? Will that be a wide sweeping request by all the departments? I was just treasurer's office, several hundred replies and only about 20 out of the planning department. I would ask that that would be instituted if this would pass. How are we going to communicate this when somebody might drive in from Wall on Friday and we're closed? Now I got to turn around. I didn't get to communicate. I don't have email. I don't have whatever. So thinking how this is advertised. Budget, holidays, Monday holidays. Is that an 8-hour paid holiday or is that a 10-hour paid holiday? Do they work 32 to offset the 8? Because it's 88 hours per employee per year. What comes of that when it's a Monday paid holiday? Is that full 10? Productivity and fatigue, I think there's a concern there. HR director said that. Can you sit at a desk 2 more hours? Are you already fatigued from sitting there and leaning over a computer? Are you getting up and moving around? Some of the service departments, buildings and grounds, highway department, I can understand. You got 24/7, 168 a week they've got to cover. But some of these jobs, if this is mandated and there's a young family that has school kids or daycare or something to consider, will they be mandated to do the 410s or will they have the flexibility like is in place now for 5/8 to accommodate their family and their kids' needs? Just some of the concerns I have, and if some of those are answered down the road, this may be a good thing, but as it was said, the service to the public is a higher priority than employee comfort and convenience, and you have to balance that. But, and retention is important because it costs to train people, but good luck with your decision.
Thank you. Janet.
I have some answers. Janet Saylor, Pennington County Treasurer, that Mike just addressed. I do have employees in my office that cannot work 410s, and I have assured them that their hours would not change. They could work Monday through Friday, 8 to 5, or the ones that have a special need, 8:15 to 5:15. It doesn't matter to me. They will be allowed to work the schedules they can because of their children. The 410s, and the reason that we're on board for the closings on Friday is because the out-of-state mail is crazy. We can't keep up with the mail, no matter what we do. When we come to work in the morning, and I'm a public servant, I've been here for 35 years, and there's not a lot of people that are here at 5:30 every morning. But I can tell you, the people start lining up outside. Sometimes at 6:30 in the morning, sometimes 6, depends if it's the last day of the month. They're going to be out there at 6 o'clock because they want to be first in line. My employees are not going to want to work extended hours and work on Friday too. And we have to have a staff in order to take care of the people that are coming through that door. So I would not be in favor of extending hours and making them also wait on people on Friday, answer the telephones. We can't do it all anymore. Rapid City is growing that much, and because South Dakota is an open state, we're one of the few counties that are left. They're doing out-of-state paperwork for people. Most of the counties have refused to do it. But as an elected official, I feel that it's my job to make money for Pennington County. That's what I was elected to do.
Janet, one of the items I have here is somebody suggesting we be open on Saturdays too. Can I presume that's out of the question as far as?
I'm serious. I can't get my staff to work overtime on Saturdays. They do not want to do it.
Understand. Thank you. Any questions of Janet? Thanks, Janet. Joe?
Good morning, or good afternoon now, I think. Joe Miller, Pennington County Highway. We obviously do 410s at Highway Department, and, you know, you spoke to employee retention and employee attraction to the county. Our 410s are one of the only reasons we've even got applications in the door. And one of the main reasons we're retaining people. You know, we're not the highest paid, we're not necessarily the lowest paid, but, you know, the city did what they did with their employees. You know, we don't have, as far as the highway department, much to offer for a CDL driver, right? That's one of our big requirements. And the 410 schedule is one of the only reasons we are getting applications, you know, the 4 that we do have. We've been advertising for 2 months, almost 3 months for positions, and we've got 4 applications. So we just hired an individual a week ago, 2 weeks ago, and came for 3 days and quit to move back home. So the employee challenges are real, you know, not only for county highway, but I think every department in Pennington County. So you guys asked the department heads to think outside the box, and I think that's what they've done. And I just wanted to voice my appreciation for allowing county highway to do that, and know that it's one of the only reasons that we're even getting applicants. So
Thanks, Joe. So Commissioner Roskinick, I know that you had talked about a continuance. Is that your desire to have a motion for a continuance, or?
You know, I guess my position would be that if Audra agrees to work with those title companies so that when we're done visiting and we've resolved their concerns, I could go ahead and live with supporting this as written today with that condition.
Mr. Chairman.
Commissioner Lasser.
I haven't said much on this one because I have wanted to listen to what everyone had to say. And in my regular job, we deal with Monday through Friday, and that's what we're open with. And we've also had to deal with, you know, either retention or hiring on and things of that nature. And so we've had to do a flexible schedule so that we can maintain our regular operational hours or extend our operational hours, but also be open Monday through Friday. I'm also not of the opinion that we should micromanage each department. I think the department heads should be able to evaluate what they're doing and make a decision on what they think is appropriate. And they're going to hear from the public on that one. My biggest concern is, though, and I'm not sure, I don't remember exactly who said it. Maybe it was Mr. Mueller, that somebody drives in from Wall and we're closed on a Friday. And then, you know, if I spent, especially now with gas, I'd be a little upset with that. So that's kind of where I'm at, is I'm kind of torn on the aspect. I understand it's beneficial to go to 410s for the staff that are working, but it's also beneficial to keep the county open through the timeframes that the community is used to coming in to taking care of business too. Quite frankly, pay their taxes and the other services that they're doing here. So I'm kind of torn on this one because I do want the staff to be able to work 4 days, but I also want the county to stay open the 5 days. And I think it can be done, but I also don't want to micromanage what the departments are doing, because I don't think that's beneficial either, because we don't do it in other areas. Why would we do it on this? I think maybe we need to determine whether or not we want the building to be open and accessible to the public from a certain time period to a certain time period, and then the departments figure out how to fit their work schedule in there. And I get it. I've talked to Janet. I've talked to several other individuals. Don't worry, I haven't forgotten about you. You're standing up here. You're right. There are some work processes that you can't do your work and be open to the public at the same time. Where I work, the same thing happens. We're open 5 days a week. We will take some stragglers on a certain day, but we still have to be there to get things done, and we don't see clients every single day, all day long, because we had to block out time so we can get other things done, or we can't continue to see clients. I totally get that aspect, Janet. If that's what you're coming up here to talk about, okay. So that's why I say it's a teeter-totter, if you will, on how to balance what's coming, and with low staff and trying to meet all those requirements. I would just ask to say, is there a possibility to stay open those 5 hours, those 5 days, but, and give the people the relief they need? Because that's what other businesses that I've worked with have done. I mean, I've worked Panama shifts, I've worked 24-hour shifts, I've worked all kinds of shifts, and we figure out a way to make sure that we're open, for who we're serving, but also to make sure that our staff has the appropriate rest and time off as well, depending on what the position is that I was in. So that's my comments on that.
Doug, follow up?
Sorry.
Go ahead. She's coming.
Well, number one, you forgot to mention that we do have a wall satellite office that's open one day a month. And when my staff has been down there, as far as I think it was a week ago, Annette was down there, and there were people in there talking about they had to get done because they were headed to Rapid for the day. They're headed to Rapid for the day, but we have a satellite office in Wall. So they have the option to go to the Wall satellite office and get their stuff done one day a month. I think you forgot that, Commissioner. I just wanted to remind you.
Gotcha.
Okay.
Thank you.
Thank you, Janet. Eric?
Eric Witcher, Public Defender, and I've been thinking about this exact problem for the last several weeks because we're going to remain open 5 days a week. So and we've had a lot of discussions about what does open mean. You know, if we have to be open from 7 to 6, Monday through Thursday, and then Fridays 8 to 5. Really what that does is it adds an 8-hour day, just like if you added Saturday to our office. How much business is the public defender's office going to have from 7 to 8, 5 to 6? How would we staff it? How would we provide services to our clientele in that time frame? And I can tell you if we were going to be truly open, and every department's going to be a little bit different, but if you're going to be open, it ends up for my office of basically adding about 20%, which makes sense. It's adding like another day. And then we end up in a lot of issues as far as, well, how do we staff that? Because that's real money. And so, as much as these are the complicated, and I just wanted to let you all know, I've been working through that, and if we were to be, it is a significant number of staff to add just that 8 hours. So, and I think if you do that department-wide here in the county administration building, it'd be a significant amount. So, just want to make that comment.
Mr. Chair.
Question? Go ahead.
Oh, thank you. First of all, thanks, Dan, for how you worded that as far as servant. I always, by all means, by no disrespect, I thought I would, when I refer to customer service, a higher level of standard was the highest level of standard is that's why I refer it to. So our two different takes on that, I hope you can see mine and I can see yours, so we're both on the same page. The biggest concern, Janet McTire, I mean, your point is well taken. I mean, I've seen shifts like that too. You're rotating, but you're keeping the 5 days. Absolutely, if we had enough people. And that's the whole thing. We could do that expanded maybe 2 years from now, 3 years, I don't know. This whole thing is about getting the level of service back or keeping it the same instead of it deteriorating. Is what prompted all of this. It's not, yes, the employees is a key part. The ones that we got, we want to keep, but also maintaining the level of service that we are providing. And that's why we're looking at it. Each department is different. Each department's going to have to work through their own, as you just heard. Some are going to have to work 5 days a week, but they're going to rotate to help to deal with the family problems, the daycare, that type of stuff. They're going to work with people like that. I think it's worth a try. that's all I can say. I mean, my biggest concern through most of this was, as Ron was saying, we do have title companies, and I think Jeanette works for title, nope, she doesn't. But I mean, so that, I'm willing to give this a try, and it sounds like each department's different, and I do agree with Mr. Laster that, you know, each department is different and has different needs, and so they fill their departments and work with them, but we just try and set a standard and give them that faith to do what they need to do.
Mr. Chair,
Commissioner Oskinen.
maybe we could add a condition that this gets reviewed in 1 year, and then if it's working, we just keep doing it. If it's not working, we quit doing it. Or if it doesn't work the way we want, we modify it so that it does work.
Jeanette, you have something else?
Well, I was just going to point out, your question was, could you do it? Maybe in reference to the HR head of that department, it will be in fact an enticing thing to make people want to work for the county. So maybe you wouldn't have the difficulty in getting people if you had the 4 10-hour day option. So it might add to the people that would actually like to come and work here if they had the 4 10-hour option. And so I think it could be a win-win for the extended hours for the taxpayers and the customers, or whatever you'd like to call them, and an advantage for the employees as well. But I don't think you cut off the 5th day to the people that you're supposed to be serving. So I think that's the important part of it that I think needs to be really considered, as some have said, even above the employees' convenience.
Okay,
Thank you.
thank you. So I do think we need to provide some direction here since this has come before us. And I believe that there may need to be some massaging of this as we move along and see the little issues that come along with it for individual departments. But I think it's worth an attempt.
I can't log in. I'm sorry. We'll have it back on the screen in a second. So this page, oh, sorry, go ahead.
I didn't know if I could just make a quick comment about this. I've been listening to everybody, and we aren't cutting back hours for the public. We're
Just
still
identify
gonna-
yourself, Lori.
Oh, what? Oh, Lori, IT department. We aren't cutting back hours for the public. I think the biggest benefit of this, because my department still would have to staff our office 5 days a week. The biggest benefit of this is the treasurers, the public facing office like the treasurers. It's a nightmare out there. They need to figure out how to get through their work, and they can't do it staffing 5 days like they do right now. They can't help the public while they're trying to process mail. That's their nightmare. And I think it'd be beneficial for planning because the contractors could come in early in the morning. I know it could be kind of challenging for the title companies, but I know Greg Wick and he'll work through it. He'll figure it out. They'll figure out what to do with it. But personally, I think this would be so beneficial for the treasurer. I see her fight every day.
Okay. Thanks, Lori. Is there a motion?
Mr. Chair,
Commissioner LaCroix.
I move to approve implementing a 4-day work week for the county administration building being open Monday through Thursday, 7 a.m. to 6 p.m., starting November 14, 2022, to continue support remote and flexible work schedules for all county offices and departments, and for the current holiday observance policy to remain in place, plus to review this in 6 months.
Is there a second?
I'll second.
Got a motion and a second. There isn't anything there that indicates that things can't be massaged and worked through in the meantime.
Mr. Chairman.
And I like the last part of it, to review in 6 months. I suspect that we may be reviewing it even before that.
Yep.
But
Yes.
that guarantees that
That
it's going to be brought
guarantees-
back at
yeah.
that point in time.
Mr. Chair.
Mr. Chairman.
1 second, I got Commissioner Lassiter.
Couple of things, and And since it sounds like we're going to move forward with this, or at least that was what the motion was, I agree, we need a if we're going to do this, we do need a trial period. I was thinking a 3-month trial period, so I was going to ask if you'd consider 3 months instead of 6 months, but also I was going to ask that we do a feedback survey. That way we can figure out what the public's pulse is on this, if it becomes a challenge to meeting certain different needs.
Can I respond to his
Commissioner
request?
LaCroix.
I don't think 3 months is enough time to set the structure. That's why I said 6 months. 3 months is they're still learning it. It's getting implemented. You probably might get the last month to where things are getting the bugs worked out. That's why 6 months would give a long enough time. But as Mr. Drew said, I think it's going to come back in meetings, getting feedbacks of what's working, what's not, what can we change.
Well, I guess maybe the reason why I suggested 3 months is because I do remember, and you can correct me if I'm wrong. The Japanese study, the Microsoft study was a month, right?
1 month.
They collected enough data and they were able to see significant information, data in 1 month's time. I figure 3 months' time would be appropriate for accounting, but.
If I could, Mr. Chair. The caution, again, is from the reaction and the responsibilities of the employees as well as the public. A 3-month change, and we're implementing this several months out. They're disrupting their entire lives to make this possible, and then to pull the rug in 3 months or to let them know that it may change in that quick of a time, that's more disruptive than beneficial to the employees as well as to the public. So it wouldn't support the needs, and it wouldn't support their ability to take care of the things they have to at home. They've got to change their schedules. They've got to change their routines. They've got to change their daycare. There's a lot of moving parts for them personally, and I worry that if we would do this with a 90-day, there's no benefit to them, and it's not going to help us recruit or retain.
How about this? How about a 3-month report from HR and a review in 6 months?
Well, and the other thing, I think, John, you can be in charge of doing the survey.
Oh, yeah.
Because that'll start basically probably even before day one.
Before we even get to November.
That's right. And so I think we're going to be kept informed as to what the reaction is all the way through this. Joe,
excuse me, Chair, Joe Miller, Pennington County Highway Department. Just from my standpoint, I've got a 1.5 and a 2.5-year-old. Daycare is difficult at best to find. We are 6 to 4:30, and my wife takes our children to daycare. So, and I mean, when we first started looking for daycare 2.5 years ago, it took us 6 months to find a daycare. So to implement it for 6 months, I think that's even, in my opinion, having small children that are in daycare, making that change is going to be difficult for employees that have small children that are in daycare or school or anything like that. So that's just my standpoint. I do have small children that are in daycare, and I don't know that I would be able to make that change for that amount of time and then be able to change back, right? So,
Mr. Chair.
good information. And I think that there's some things in life that's going to make it for employees difficult to do maybe exactly what they'd like to do at the time they'd like to do it. So daycare is one of those, is that instead of being able to switch at a certain time to it, it may be the first of the year before they can do that or whatever. So,
sure.
Yeah.
Commissioner LaCroix.
I'll yield to Mr. Laster.
Oh, I was just going to point out, again, go ahead, Joe, I'm not going to ask you a question. I understand.
Please ask him.
You want me to ask him? Not you? Actually, I was just going to make a statement. Again, I've worked in the workforce for many years, and many of those jobs I've had to work Panama shifts or whatever, and even in our community, there's jobs that require you changing your shift every so often, and that's, that whenever you're working in that particular job, or at least once you get hard on, we're changing this kind of midway, so they would still have an idea that in 3 months it could change, or 6 months it can change. So my point being is that there are a lot of shift workers in our community, and their shifts change. They're never perfectly set. I mean, there are some that are perfectly set, but they still have to deal with the challenges of childcare and other things of that nature that would come along with something just like this as well. I just pointing that out, that they can't be our sole one way or the other, because ultimately, when it comes down to it, there are other jobs in our community that are facing the same challenges with their normal everyday job.
If I could, Mr. Chair?
Yes.
That's part of the challenge we're trying to alleviate here. We don't want to be fighting for those same groups because we have shift work and changing schedules. We want to have something consistent, something that's desirable, and something that helps our people make plans longer term. This gives us an advantage from a recruiting and retention perspective. We don't gain any advantage if we look at this saying we're going to do it for 90 days and then revert. The 6-month window is tough, but I think the fact that we're going to be able to review it in 90 days, come back in 6 months and do a more in-depth review, it gives those employees, current employees and potential employees, a better chance at having some normalcy in their lives that they can plan for and predict.
Mr. Chair.
Commissioner LaCroix.
Let me clarify what my intent was on a 6-month review. It's not to pull the rug out and change things. That's more of a report to us as a commission, what's happening, what's working, what's not, because every department's going to do some little things different. What may not be working for us, this one could work with that one. That was the whole intent. Absolutely not. And in 6 months, would this commission pull the rug underneath employees who would put the structure and time into doing what they need to do? But at that point in time, or even in 3 months, from 6 months, you come back to the commission and say, in this department, this is what they did to make things work a little better. And it's not actually just as some of them said, we're rotating shifts. Maybe we're caught up enough to where we want to start putting a little bit more services on Friday. Who knows? But I mean, that was the intent. So let's not go down the rabbit hole saying we're going to pull it, because that really wasn't the intent.
Good. Thank you, sir. I appreciate the clarification.
Is there any further discussion by the commission? All those in favor of the motion indicate by saying aye.
Aye.
Opposed?
No.
Motion carried. 3-1.
That's 3-1.
Motion carried.
Thank you, commissioners.
Items from the public. Is there any items that members of the public would like to discuss before the commission that's not on the agenda?
Henry must have left.
I don't know if he's still here.
Is that Henry?
Yeah, Chuck Henry.
Yeah. He was trying to get it
Doesn't
in.
appear to be here. Okay. No items from the public? Scheduled for a recess here. Would you like a recess?
Yes. I'd make a motion to go to take a 10-minute break, please.
Second.
I got a motion and a second. All those in favor indicate by saying aye.
Aye.
Opposed? Motion carried.
From Pennington with
Declare us back in the session.
Mark.
Need a motion to go to Board of Adjustment.
So moved.
Got a motion. Is there a second?
Second.
Motion and a second. All those in favor indicate by saying aye.
Aye.
Opposed? Motion carried.
Afternoon, Commissioners. Jason Finnison, Assistant Planning Director. Agenda item A is subdivision regulations variance 22-07 to waive the requirements to dedicate and improve the undeveloped section line right-of-way. Applicant is J.V. Gulch. His agent is Isaac Almanza. And the property agent is Renner Associates. Other affected landowner is Karen Murphy. Location of the properties are 23790 Highway 385. Currently zoned agriculture and ranchette districts. Existing land use is residential. And access is off Highway 385. And there is 100-year and floodway on the property. When basing their decisions, staff takes a two-prong approach. First prong determines whether granting a variance runs counter to the public interest. I'll read staff's responses beginning with number 1. They're on the screen if you'd like to follow along. Number 1 is no. Access to both proposed lots will be via the existing approach and bridge off of Highway 385. A 66-foot wide access easement for proposed Lot 2R will be established via the plat. Number 2, yes, the proposed neighborhood will be residential and agriculture in nature. Number 3, yes, in such instances where adjoining landowner may decline to participate in a right-of-way dedication, or if it is not practical or not desirable to construct the street within the existing section line right-of-way, The Board of County Commissioners may authorize a new right-of-way where the developer will improve and dedicate the entire required street right-of-way within the boundaries of the developed property. Number 4, yes, the current comprehensive plan identifies both proposed lots as Ranchette District. Number 5, no ingress, egress, and emergency response access to both proposed lots will be via the existing approach off Highway 385. And prong 2 determines whether special conditions exist to grant a variance. Again, I'll read staff's responses beginning with number 1. Yes, Spring Creek, a FEMA designated floodway, parallels Highway 385 at the existing approach. An existing improved approach and bridge allow access to the proposed lots. 1A, yes, improving both section lines would involve unnecessarily constructing new bridges within the section lines and the FEMA designated floodway. And 1B, yes, the ordinance's spirit is to ensure access is provided to the proposed lots. A proposed platted easement across an existing improved approach and bridge will provide access to the proposed lots. As you can see here, this is the proposed lots 2R and 1R, or lot 1 and 2R. I've identified in red where the section lines are that the variance is concerning. So you can see from the plat, they are reconfiguring a lot line on these properties. Lot 2R will be 5.059 acres and Lot 1 will become 54.985 acres. The request was sent out for interdepartmental review. County Highway Department did state that the highway is not opposed to waiving the dedication and improvement of the section line. However, any road built within or along the section line must be built to Ordinance 14 standards. The Highway Department would be opposed to vacating this section line. There were no other concerns or objections received. Staff's analysis of the request is that the Board of Commissioners approved minor plat 22-30 on June 21st of this year with conditions, and approval of this variance will satisfy conditional approval and allow the planning process to continue. There are portions of 2 separate section lines being considered in this request. Improving both section lines would create an unnecessary hardship by requiring 2 new bridges to be constructed within the section line and the FEMA designated floodway when inadequate access to the proposed lots currently exists. With that, staff recommends approval as there are special conditions that would warrant approval of this variance request.
Mr. Chair.
Commissioner LaCroy.
I make the motion to approve subdivision regulation variance SB 2207 to waive the requirements to dedicate and improve section line right of way as there are special conditions that exist to grant request. And improving both section lines would create an unnecessary hardship in requiring 2 new bridges to be constructed within the section line and FEMA designated floodway when adequate access is proposed lot is currently exists.
Second.
I got a motion and a second. Is there any public discussion on this? This is one of those that requires 4 positive votes in order to pass. Is there any discussion by the commission? All those in favor of the motion indicate by saying aye.
Aye.
Aye. Opposed? Motion carried.
Move to adjourn the Board of Adjustment and reconvene the Board of Commissioners.
Second.
Got a motion and a second to reconvene as Board of Commissioners. All those in favor indicate by saying aye.
Aye.
Aye. Opposed? Motion carried. Consent agenda.
Board of Commissioners uses the consent agenda to act on non-controversial and routine planning and zoning items. The consent agenda is acted upon by one motion and vote of the board. Items may be removed from the consent agenda and placed on the regular agenda at the request of a board member or citizen. The consent agenda for the planning and zoning contains the following items. Agenda item B, conditional use permit 22-30 for Larson recreational properties. Their agent is Pascal Perot. To allow recreational vehicle park on the subject property in a highway service district. And the planning commission recommended to continue conditional use permit 22-30 to the August 2nd Board of Commissioners meeting.
Jason, why would the planning commission make that recommendation of continuing it until the August 2nd?
I believe the majority of the commission had pretty serious concerns about the special flood hazard area and floodway on that property.
Okay, but this would not come back before them, correct?
Yes, it's gonna come back at their next meeting on Monday, this coming Monday. And then it would come to you on August 2nd.
So why does it even come to us before it comes back to them the second time?
I believe it's a formality for the agenda. It just needs to be heard by you because it was scheduled on this agenda.
Mr. Chair,
Ross Connect.
I made a site inspection last week, so did Deb. And so, you know, these sites are just about 100% in.
Well, I went up there with Deb, I think the day before you went up there on a visit, and I visited with Lars. He assured us that he was gonna put in a flood monitoring system, that there would be warning signs and sirens that were up there. And I know on your site visit that you noted that those elevations for those new RV sites are gonna be outside of the flood hazard area. But what we need from their surveyor or their engineer is some sort of a study of the topography of that area to show us exactly where that FEMA designated flood zone is. Because when FEMA came through and drew the lines on the maps in 2013, they didn't do boots on grounds inspections. They leave that onus on the property owner to prove otherwise, basically. So that's what we encouraged him to do. I think the Planning Commission wanted some extra time for him to follow through on those things.
So did the planning department approve that? And then it went to the planning commission? The planning department's recommendation to the planning commission was to approve?
Right.
Quite frankly, I don't have any problem with this.
I don't either. I'll make a motion to approve.
Got a motion to approve conditional use permit CU 22-30. Is there a second?
I'll second. Okay, yeah.
Is there a second? I'll second.
Can, if you'd like, sir, I can go ahead and bring up the presentation I made to the Planning Commission so you can get an idea of what they're proposing. So it's going to be a three-phase project. Phase one is in red, and I believe that's 24 sites. Then they're going to add an additional 24 sites as well on this phase two portion. The phase three is actually going to include a bathhouse as well as a laundry facility and potentially a pool. Something that came to light during the Planning Commission meeting was that they have 6 additional owner-operator spots available for them. I would still need to modify my staff report to capture those and include those in this proposal.
Mr. Chairman, point of order as well.
Commissioner Lasser.
I was brought to my attention that we'd have to pull it off the consent agenda to do that.
Okay. You're probably right.
We would have to just continue it so he can put the information in there that he's discussing anyway.
Why don't you continue on with your information here, Jason?
Okay. Give me 1 second there. So I did get the information from Pascal about the 6 additional sites. There is an on-site wastewater treatment system approved for those sites. Moving forward, I just need to include that into my report, or if this is sufficient, that's fine too. The request was sent out for interdepartmental review. The county floodplain manager did include 5 conditions that are included as conditions of approval, which include egressing this area here, which is in the special flood hazard area. I did note to him that having 1 ingress and egress for that area is not desirable, so he did modify his site plan to add a second means of ingress and egress for those RV sites. South Dakota Department of Transportation, concerning this approach here, did state that this section of 385 is classified as rural with a minimum spacing of 1,000 feet between access points. South Dakota Department of Transportation has concerns with proposed exit onto US 385, and we'll reach out to the applicant, and there is a condition of approval in this conditional use permit that states that they need to work through that issue prior to operation. Staff's analysis of the request is that the applicant is proposing a recreational vehicle park to be constructed in 3 phases. Phase 1 will include 24 parking spots with utility hookups. Phase 2 will include an additional 23 RV parking spots with utility hookups. And Phase 3 will include constructing a pool, laundry facility, and a bath shower house. The pool, laundry facility, bathroom, shower house, and 36 of the RV sites will be located within the boundaries of the FEMA designated special flood hazard area and floodway. Floodplain development permit and building permits will be required for these structures. Conditions of approval provided by the county floodplain manager have been included to address RV parking requirements in these areas. Again, the applicant's plan also includes utilizing an egress-only approach off of the subject property onto Highway 385. So they will have to work through those issues with Department of Transportation.
With who? Have to work through those with who?
Work through the issues that Department of Transportation had with this egress only. I believe they wanted 1,000 feet between approaches, and as proposed here, they're nearly right beside each other.
At the State Department of Transportation? Or?
That's correct, yeah.
Okay.
Mr. Chair.
Commissioner Roskinek.
So I talked to Rich Sacker, who is the DOT for the Southern Black Hills, and he indicated that the Alexander and the applicant here, they're working on a shared access. I think that's going to be one of the conditions.
Okay. All right. With that, staff recommends approval of conditional use permit 22-30 with conditions.
Okay, I think Commissioner Laster is correct that I inappropriately allowed for a motion to be made on a consent agenda item, different than what the recommendation is. So I will basically declare the motion invalid.
Okay.
So, Mr. Chair, if the motion's invalid, the current recommendation is to continue. Excuse me. I understand where some people may be on this, and from looking at it out of due process and respect for the planning commission for what they do, they had a reason to continue it. And if they had that expectation it was coming back to them, and we're gonna put it on our agenda and change it, it kind of leaves them out of their process. I understand that staff may be recommending to approve, but just from what I heard, there's still some things that are in the works, and I think that's what they wanted to have confirmed. So just for a heads up, I'm for following the process and having it go back to planning commission before us to get their concerns addressed.
Okay.
So, Mr. Chairman, I believe I would make a motion to approve the planning and zoning consent agenda as presented, which means it's to be continued. Is that correct, if I read the presentation correctly?
Okay, I've got a motion to continue.
I'll second that motion.
Second. Any public comment? Was there anybody here that was wanting to testify in regard to this issue? I don't think I asked if there was any members of the public that wish to have this taken from the consent agenda. I missed that. Okay, we've got a motion and a second. All those in favor indicate by saying aye.
Aye.
Opposed? Motion carried. Item C, under uncontested hearings.
COSAC Environmental Planner. Item C is preliminary plan PPL 22-33. It is to subdivide and create lots 1, 2, 3, and 4 and a utility lot of No Bad Day subdivision. The applicant and landowner is Rob Livingston. The surveyor is All Aspect Surveying. Location of the property is 16001 West Highway 44. It involves 18 acres. Current zoning is Highway Service District with an existing land use as a campground. Access is off Highway 44, and there is a special flood hazard area on the property. The proposed lots, so lot 1 will be 7.23 acres and will contain the convenience store with an existing septic. Lots 2, 3, and 4 will be over 3 acres and will be vacant of any structures, and the utility lot will be 1 acre and contain the communications tower. The applicant has applied for a comprehensive plan amendment and a rezone to rezone lots 2, 3, and 4 to rural residential. Those will be heard on the next agenda item. This was continued from the June 5th Board of Commissioners meeting, as there was a discrepancy with the acreage. Their survey shows that it's 18.25 acres, and our records showed that it was 14 acres. After working with the surveyor, the 1960 plat and where they found the actual pins were off, so we go by the best available information, which would make that the 18 acres. So staff is recommending approval of preliminary plat PPL 22-33 with the Planning Commission's concurrence, adding those 2 additional conditions that you see in the packet.
Mr. Chair,
Commissioner Roskinek.
move to approve preliminary plat 22-33 with 9 conditions.
Second.
I've got a motion and a second. So do we need to modify that for the 9 conditions to add the additional 2, or?
Correct, so it'd be approval with the 11 conditions, and the applicant has applied for a variance to waive the request for that 24-foot wide road.
Okay, so it'd be 11 conditions.
So, yeah, I'll amend that to 22-33.
Okay with that?
With 11
Yes.
conditions.
Second is okay.
Any public comment? Seeing none, back to the commission. Any further discussion? All those in favor indicate by saying aye.
Aye.
Opposed? Motion carried. Item D.
Item D is Comprehensive Plan Amendment CA 22-15. It is to amend the comprehensive plan to change the future land use from Highway Service District to Rural Residential District. Again, the applicant is Rob Livingston. The surveyor is All Aspects Surveying. This was continued from the June 5th, 2022 Board of Commissioners meeting due to the discrepancy in the acreage that has been taken care of. So staff is recommending approval of Comprehensive Plan Amendment CA 22-15 with the Planning Commission's concurrence.
So moved.
Second.
Got a motion and a second to approve. Any public comment? Seeing none, back to the commission. All those in favor of the motion indicate by saying aye.
Aye.
Aye. Opposed? Motion carried. Item E.
Item E is rezone RZ 22-21. It is to rezone 9.83 acres from Highway Service District to Rural Residential District. The applicant landowner is Rob Livingston, surveyor All Aspects Surveying. Again, the property is 16001 West Highway 44. With approval of the comprehensive plan amendment, staff would recommend approval of rezone RZ 22-21 with the Planning Commission's concurrence.
Mr. Chair,
Commissioner Roskinek.
move to approve rezone RZ 22-21.
Is there a second?
Second.
Got a motion and a second. Any public comment? All those in favor of the motion indicate by saying aye.
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 Opposed? Motion carried. Item F.
Madison Ransom, Environmental Planner. Agenda item F is road construction within a section line right-of-way. The request is to construct 962 feet of road within the section line right-of-way between sections 3 and 34 in T1 North, R8 East, to provide access to property located in section 34, T1 North, 98 East. The applicant is Mitch Morris. The existing land use is vacant. Access is off Old Folsom Road, and there is no special flood hazard on the property. It was routed for interdepartmental review. County Highway commented, the Highway Department is opposed to waiving Ordinance 14 requirements. Any road built within along a section line must be built to Ordinance 14 standards. An approach permit is needed prior to issuance of a building permit, as a permit will be off a section line right away. Any road construction within the public right of way of a section line falls under county jurisdiction and must be built to Ordinance 14 standards. A turnaround must be built and must meet dimensions as shown in Figure 1, turnaround dimensions per Pennington County subdivision regulations. The applicant, Mitch Morris, is requesting to construct a road within a section line right-of-way. The road is being constructed to access a future residence. Therefore, staff recommends approval of road construction in section line right-of-way with conditions.
Mr. Chair.
Commissioner Lassiter.
Madison, can you give a bigger overview of that area? Because I know Old Folsom Road is over there, kind of where the industrial park is, but I don't know where it is in consideration to this. So kind of I know part of Old Folsom Road is supposed to be
Development,
developing
industrial
road.
development.
I'm guessing this piece is not even part of that because it's probably further south of it. Is that
correct? It's right here.
And the industrial park is up there in 29, is that?
Yeah, I can.
Okay. I just want to make sure I get my bearings of what's what and what's coming and what's where. The only question I had, just to make sure we're aware of what road we're dealing with and how close it is to. He says for private residence.
Correct.
Mr. Chair,
Commissioner LaCroix.
I'd move to approve road construction within the section line right-of-way CS 22-09 with 9 conditions.
Is there a second?
Second.
Motion and a second. Is there any public comment? I have a email here. I don't know if all of you received a copy of this or not from the Zimetz. Maybe not. Says, my husband and I are unable to attend the meeting. We are sorry to say, is that?
That's for item J.
I'm sorry, it is. It is. And we're on F. Sorry about that. So I have a motion and a second. No public comment. Any further discussion? All those in favor indicate by saying aye.
Aye.
Opposed? Motion carried. Item G.
Item G is the request to waive ordinance 14 standards. The applicant, Mitch Morris, is requesting to waive the requirements to construct 2-foot deep ditches and a road width of 24 feet. The road will be 18 feet wide. Staff attempted to contact the applicant on July 12th to verify the details of this request. At the time of writing this memo, staff has not received a return phone call at that time. Staff would recommend that if the Board of Commissioners approves the above waivers, that 4 conditions be included.
Mr. Chairman,
Commissioner Lassiter.
I'd be inclined to continue this one because if he hasn't responded back for them to get clarification, I don't think it's appropriate for us to approve.
And he is here today too, if you would like.
Oh, is he?
Mm-hmm.
So do you want to pursue your motion or do you want?
Well, unless, do you think he can answer your questions for us, or does he just have to write them down? I mean, how much, Madison, what's all required that he hasn't answered for y'all?
To me, it seemed like he wanted to request to waive the requirement for engineered roads plans, but that wasn't indicated. Also, help me out, Joe, what were the other ones that were?
Mr. Chair,
Commissioner LaCroix.
I believe, as reading what in the last one, let me look at that.
Oh, gravel depth of 6
Right here.
inches wasn't discussed.
On the backside. Well, he's here. He's here, right? The applicant's here? He can come forward and explain to us.
So at this time, Commissioner Lassiter, I'm going to discount them.
Fair enough.
Okay.
Good afternoon, I'm Mitch Morris, the petitioner and owner. And I'm not sure what the questions are, but I'm here to answer any of them.
Well, what this is doing is you've got a request to waive the requirements of the ordinance of 14 construction, which is a 2-foot deep ditch and a road with 24 feet. What you're asking for is to construct an 18-foot wide with 4 conditions. And now I have to look at this other. So you're wanting to do, instead of 24, you're wanting to do 18.
Basically, I want to use this as a residential driveway with the approach off the Folsom Road meeting the county specs for the first few feet, and then just reducing it to basically a residential driveway.
I think that's what the commission wanted to know, more of a private road after that. That's
correct.
So it's good that you're here to come up and, do you have any?
No, I just, whenever it says that they try to reach out to them to answer their questions, that's what kind of threw a flag for me, but since he's here, I just want to make sure that their questions are answered. Joe's got something to say, it looks like.
I just want to make sure, the county highway is very adamant on the construction of roads within a section line. As you can see here, there's already a road that is actually already connecting over to 79, so it very well could be a true road at some point, right? Looks like there's a fairly decent road. I've never been on that road to date, but if we allow him to not build the ordinance 14, then if this ever develops, right, then it'll be on that owner. So it sounded like after talking to Brittany that you're in favor of building the ordinance 14 for 100 feet and then diving off onto your property is what Brittany kind of enlightened us prior to the
Yes,
meeting.
that's okay.
So basically you build 100 feet and then jettison onto his property, is that what I heard you say?
Correct. So essentially, and I don't know why we haven't put this like this before for you guys. So essentially they're constructing a county road when they're constructing a driveway or a road within a section line. And then their driveway actually comes off the section line. So when Sean gives them an approach permit, it'll be off of the section line. It won't be off of Old Folsom. So that section line, whatever 100 feet that is, will be a named road. And then his driveway will come off the section line.
So, are you aware of the conditions?
Yes.
Okay. So you're going to build it to standard on the section line until it hits where your approach is going to go, then you'll.
For the first 100 feet, as I
First 100
understand,
feet.
correct, yes.
Okay.
Do we need to put that wording in here? Because it doesn't say that he's going to
It
build it that
doesn't.
first.
Yeah.
Right, that's what I was getting at, yes, sir.
Yeah, one of the conditions do.
Do you have any specific wording that you'd prefer on that one then, if we're going to do that? Do we just need to say he needs to meet ordinance 14 standards for the first 100 feet before he then jettisons onto his property?
If I may, and I don't know, this would be a question for Brittany or Megan, I think you guys would deny the request for the waiver of the requirements of ordinance 14 for this. So that means he would have to construct it to ordinance 14 standards while it's in the section line, and then he can do whatever he wants while it's on his
With the
private
approach.
property.
I'm tracking, so he has to deny this, so that way he has to build it to the standard, and then wherever his approach permit allows him to come on, then he can do whatever at that point.
That is
What I'm hearing
correct.
you.
That's the way I understand it anyways. Brittany or anybody, correct me if I'm wrong.
You understand that now?
Yes, I do.
Okay. Because we're getting it now.
Okay.
Sorry, Brittany Molitor, Planning Director. I actually did a site visit yesterday with the previous owner of the property, and we took a look at it. There's actually a pretty large power pole, if you look just to the left of that one. So if you look down that section line, so it would require some movement of power poles and things to like improve that all the way across. So when we went out there and looked at it, if the board was okay with it, just them doing it the first 100 feet and then going off into his property instead of doing the perpendicular. That way, if the road ever gets improved to the other, it doesn't impact his property. And then the road is actually started construction to standard. So the approach off of Old Folsom would be constructed to standard for that portion. And then it would continue instead of having a long section of it not constructed to standard. So that was kind of the compromise.
Power company?
Those go to that DC tie because the DC tie is just north of that big power facility that's just south of the Black Hills Industrial Park.
Mr. Chairman, just a Point of clarification now, does that mean that item F, that we approved 962 feet of road? Do we need to go back and readdress that and say 100 feet?
Reconsider, yes.
I believe that would.
That would be the most appropriate.
So I'd move to reconsider. I think this is appropriate right now. If we're considering that 100 foot, I think we would need to move to reconsider item F.
Second.
Got a motion and a second to reconsider item F.
And then,
Public comment?
So one of the conditions, we'd have to move for approve with a 10th condition.
Well, first of all,
On
or-
reconsidering that? Do you want to vote to?
For second.
all those in favor of the motion indicate by saying aye.
Aye.
Opposed, motion carried. Okay, we're back to item F now.
and then I would move to approve item F, approve road construction within the section line right of way, CS 2209 with 9 conditions, but to construct it to the first 100 feet, not the 962 as originally stated.
Correct.
There you go. Second.
Okay, we've got a motion and a second. Any public comment? Back to the commission. All those in favor of the motion indicate by saying aye.
Aye.
Aye. Opposed? Motion carried. Now we're on G again.
Deny. Mr. Chair, move to deny the request to waive the requirements of ordinance 14 to construct 2-foot ditches and road width of 24 feet. It is further moved to, the road will be constructed, no, we're not,
Nope.
deny.
Deny.
Just move to deny.
Okay, so is there a second?
Second.
Okay, we've got a motion here to deny on item G.
Chairman, if I could, there would be a request, though, to waive the engineered road construction plan. So he's willing to construct it to ordinance 14 standards, waiving the requirement for engineered road construction plans.
I think that was my motion.
Okay.
And the seconder would conclude
I think we're gonna need a second motion here. First motion is deny,
to deny.
yeah,
And then,
and then you'll have to have a motion to give the approval to what you want.
right.
That sound, okay. Uh-oh.
Sorry.
So all those in favor of the motion to deny indicate by saying aye.
Aye.
Could I stop you real quick? Megan Kruger with the State's Attorney's Office. My preference would be to have you guys do just a substitute motion because you're still technically waiving some of the requirements of Ordinance 14 if you don't have him build to engineered standards. So it would be a motion to approve, but he would only have the waiver of the engineered standards. That's technically what would be the most correct in my opinion.
Move to approve, but only.
Only for the engineered plans.
Engineered.
It's probably why it would have been best if the applicant would have spoken to the planning department prior to this meeting, because it's a little bit confusing.
Uh-oh.
Cody Zach, environmental planner. And then that would be keeping conditions 3 and 4.
So then give us the wording on this motion.
So we're not denying anymore? We're taking the denial off? Is that?
That's where we're still at this point in time until we have a substitute motion. But I don't have the language for the substitute motion.
So it would be to approve to waive the requirement for engineered road plans with 2 conditions, and that being condition 3 and 4.
That sounds like a great motion, and I would make that motion as a substitute motion.
Second.
Sarah, have you got that?
I'll just have to re-listen to it. Thank you.
So Commissioner Lassiter, then explain what you got.
So I took what Cody just said, which was to approve. Cody, you may have to come back up here and help me out here with that. Approve the request.
To waive engineered road construction plans with 2 conditions, and those conditions being condition 3 and condition 4.
And 3 and 4 is the applicant name the section line prior to any construction, and that the applicant obtains a survey to show the road is constructed within the section line right away.
Okay, does everybody understand the motion? Any public comment, public questions on this? All those in favor of the motion indicate by saying aye.
Aye.
Opposed? Motion carried. Item H.
Code Stack Environmental Planner. Item H is road construction within a section line right of way, CS 22-10. It is to construct 200 feet of road within the section line right of way. The applicant is Kevin Quinn. The location is along Nameless Cave Road. Current zoning is agriculture district with an existing land use of residential. Access is off Nameless Cave Road, and there is no special flood hazard area on the property. This was routed around for inter-department review. The county highway department is opposed to waiving ordinance 14 requirements. Any road built within or along the section line must be built to ordinance 14 standards. The highway department is not opposed to submitting engineered road plans due to drainage and topography. Culverts under the road fall under county jurisdiction for maintenance and need to be sized by an engineer. Culverts under reference driveways are landowners' responsibilities, not the county. And the turnaround dimensions must meet table 1 of Pennington County subdivision regulations. An approach permit for proposed lot 5 must be filed prior to the issuance of a building permit. Again, the applicant, Kevin Quinn, is requesting construction of a road within the section line right away. It is to be used to access a future residence. The applicant is plotting through the city of Rapid City. We just got an email from the city stating that they are in favor of building to ordinance 14 standards. The applicant is, however, though, requesting that instead of 200 feet, 400 feet, after they did some measurements, they need the additional 200 feet. So this would be to approve a road construction with 400 feet, to allow 400 feet. With that, staff is recommending approval of construction of section 9 right-of-way CS 22-10 with conditions.
Mr. Chairman.
Commissioner Laster.
Cody, as it stands right now, as I see it here in my package, are they gonna have to replat the land if they're gonna put another home on there? Because it looks like there's already a home on that piece of property.
Correct. They're going through the platting process with the city of Rapid City. So they're creating lot 5 and lot 3R.
Gotcha.
The applicant here.
I believe there is a representative, yes.
You want to speak to this or answer questions? What would you like to do?
I'm not the applicant, but I'm his dad. I'm Gene Quinn.
Okay.
I own the 25 acres there, and he's looking at taking 10 off. It has been approved by the City Planning Commission for the plat. So now we're asking for the access point to it.
Was that just recently done by the City Planning Commission?
What's that?
Was that just recently completed by the city?
I don't know, 3 weeks ago, a month ago.
Any questions of Mr. Quinn?
Nope.
Thank you, Mr. Quinn. Any other public comment in regard to item H? Is there a motion?
Move to approve road construction within a section line right away, CS 22-10 with 9 conditions.
Second.
Is there a second?
Second.
Any further discussion? All those in favor indicate by saying aye.
Aye.
Opposed? Motion carried. Next item.
Item I is request not to submit road construction plans and to waive ordinance 14 standards. The applicant, Kevin Quinn, is respectfully requesting to waive the requirements to submit engineered road construction plans to construct a turnaround to 2-foot deep ditches and less than 6 inches of gravel on a road and a road width of less than 24 feet. The proposed road will be 20 feet wide with 4 to 5 inches of gravel base. The highway department is opposed to waiving ordinance 14 requirements. Any road built within or along the section line must be built to ordinance 14 standards. The highway department is opposed to not submitting engineered or engineered plans due to the drainage and topography. Again, culverts under the road fall under the county jurisdiction. For the maintenance and need to be sized by the engineer. Culverts under the reference driveway are landowner responsibility and not the county. And turnaround dimensions must meet Pennington, or Table 1 of Pennington County subdivision regulations.
Public comment. John, you must have something.
Yeah. Sean Smith, Pennington County Highway Department. I actually did visit the site and walk this with the landowner. I would highly suggest we stick with ordinance 14, specifically engineered plans. The topography on this, there's some significant grading that's going to be involved to meet the roadway from where they're coming from. There's a draw there that you're going to cross that is significant drainage. That's why we said in our report that this culvert will be our responsibility because this will be within public right of way. So we need to ensure that it is sized by an engineer and that this is designed correctly. So I would strongly suggest we stick with ordinance 14 on this one.
Okay,
Mr.
thank
Chair.
you. Commissioner Roskinek.
So Sean, is the applicant aware of that before they went through this process? That
I spoke with Kevin on site and I told him that would be our position when we walked through the site, that because ultimately similar, his approach permit would come off the section line, which would be up on that parcel.
okay, so they knew it going in.
What's the distance on this?
I believe the original request was for 200 feet and now they're looking at 400 if I'm correct on that, Cody. Yeah.
Okay. Okay. Quinn?
This would be a driveway into, going into the property, and I can't see where they would ever want it as a future section line road, because Nameless Cave Road could actually have parallel that and used the section line, but they never did because of topo. It wouldn't be the end of the world if we had to have engineer drawings. It takes so long right now to even get an engineer to look at it. My younger brother used to own Quinn Construction, and I asked him if he would need engineer drawings to build that, and he said no. I guess we're just asking that if you would allow the exemption for the, build 20-foot road. And
Mr. Chair,
Commissioner Roskinek.
I guess my position would be, it is just going to be a driveway. It doesn't look like it can ever be more than a driveway, and if they want a 20-foot driveway and not engineered drawings, I guess I don't have a problem with that. If it was going to be extended on to other lots, I guess that would be a different story, but if it dead ends at a residence, this doesn't, I don't have a problem with it.
Could, in response to Mr. Roskinek's,
Pardon me?
can I respond to Mr. Roskinek? Mr. Chair? In the last item we had up here, we said first 100 feet, and listening to Joe with the culverts for the drainage, I would have no problems of waiving that if the first, what would you say, 100 feet with the culvert?
There was just...
And since you have got connections with construction, they could do...
There was actually a driveway put across the same drainage area, which would be downstream, closer to Highway 44. And then there was a house just built down there too, so if we match the size of those culverts, we'd be conservative.
Joe?
I would just like to point out, once again, the section lines and state statute dictates that once a road is built on this section line, it's not just his driveway. It's county's responsibility. And in our process of looking at all the roads within the county, this one would be a road that is the county's jurisdiction, and we would have to post a no maintenance sign or maintain this road. So if he's constructing the road within the section line, it is a county road. It is not a driveway. His driveway comes when he leaves the section line going onto his parcel. So I just wanted to make that clear that and I think I definitely agree with Sean being out there driving this road. We want engineers' plans because of the grade. I understand he owns, or his brother owned a construction company, but that doesn't mean just because we built roads for a lot of years doesn't mean that we know all the stuff that goes into this specific location. An engineer will look at all of that stuff and make sure we have the county has a good road at the end of the day. So,
Mr. Chair,
Commissioner Roskinek?
Bill, could they vacate that section line and then the county wouldn't have any responsibility?
I mean, they could, but then they would have no access.
Right.
Because they need the public access to access their parcel because their parcel doesn't touch Nameless Cave.
Well, what I'm saying is vacate the section line and initiate an easement so they would have access.
I mean, if the neighbor's willing to do that, I guess that's a possibility. But again, the highway department will be opposed to that. But it's definitely, I think it's a possibility. But it would be more work and more money. You know,
I'm just
along the same line, I know he doesn't want hunters and stuff coming up it too, thinking it's a, so how about if we post a sign and make that a requirement that it's a private road?
But it's not a private road, sir. It's in a section line. It's 66 foot of public right of way.
Or else, I don't know, word it
So you
however.
have to post
It's a
it
dead
for-
end road.
So you have to post it for no maintenance?
There's a lot of them that just say a dead end and.
Megan Krieger with the state's attorney's office. It is not possible to post a road saying it's a private road because it's not a private road. It's a public road. In state statute, it actually is a public highway and anybody could walk on it. Even right now, I could go out there and I could walk on it if I wanted to. So it's not private. It's not a driveway. It's a county road if it gets improved.
Mr. Chairman.
Commissioner Laster?
How about if we worded it like, dead end?
Commissioner Laster?
Joe, if you don't mind coming up here real quick. I was trying to get your attention, not to walk away. We keep addressing these things. We keep having this issue, and I know we're working on the new ordinance 14, and kind of working through some of the road issues. I'm wondering now, as some of these come up, if someone asks for a waiver to not build to ordinance 14 standards, whenever we approve any of those variances, maybe we should, at that moment in time, designate them as no maintenance roads if we're not going to meet them to county standards. What are the nuances in that aspect if we did that?
So that'll have to take place most likely after we get an entire county road resolution put together. So then we have the ones that we know of, and then when these new ones come up, it'll take another resolution basically for the county commission to say, hey, this is a no maintenance road, right? That it takes a resolution done. So you guys can approve the exception, right? So next week, Wednesday, Holly, is when the new ordinance goes into place.
27th.
So next Wednesday, the 27th is when the ordinance 14 goes into place. So then we'll be under a whole nother set of rules for this sort of thing. And there'll be exception requests and there will be another process, right? It'll be similar in nature, but to answer your question, it requires a road resolution by the board and a vote of the board.
I understand that, but I'm just wondering if we could maybe start getting ahead of it and thinking that if we're going to give these variances, we may want to start planning that we're going to say, if you're going to do this, then don't expect the county to maintain it, because that's really what we're going to get to, because we've had how many of these requests over the last, I'm just back thinking, and so this is what's starting to become a concern, is if we're given all these requests of variances and then the county's got to maintain these roads because of the state law, unless we say, wait a minute, these ones that we're implementing from, whatever we recently done today or whatever, we've got to look at those seriously as no maintenance roads, and people who are applying for those variances need to understand that. I mean, maybe we put that as a condition that it most likely will turn into a no maintenance road in that section line that you're applying for the variance. Just something for us to consider as the commission as we work through the ordinance 14 stuff and any new applicants right now for section lines.
I think that would be a good idea. I definitely feel strongly that engineered plans need to be drawn up for this section line. It's, the topography and the drainage that goes down through there is something to be, I mean, it's difficult at best. I don't know if we have Google Earth images of it or not.
Joe, when we sign a road such as this as no maintenance, what authority then does that property owner that's using that have to maintain that?
They can maintain it, the county's just not going to, right? So the statute, I believe, and Megan can correct me if I'm wrong, but on the no maintenance, the county is responsible for man-made obstructions only. So if somebody were to come out there and dump a pile of dirt or a pile of scrap or something in the roadway, the landowner could say, hey, county, come get this out of the way.
So our liability no longer exists, is what you're saying.
When we sign it as a no maintenance road, correct?
Okay. But if they are doing anything as maintenance on it, then I presume they're picking up the liability.
When they're on there doing the maintenance, just as, same as when you're doing.
You still can't restrict access to it.
Correct.
So if something is wrong and something happens, the liability is where then?
I'm not a lawyer, so I don't know exactly.
Megan, you're up.
I'm not sure. I would have to research it. Tracy Decker is usually the one that does a lot of the highways work. So unfortunately, she's not here right now. But if that is something that the board would like us to research, we could definitely do so.
I think if we want to follow along the lines of what Commissioner Lassiter is saying, we probably need to make some determinations, or at least have the knowledge of where that transfers to.
Yeah, I'll take a note down, and both Tracy and I can start researching that, because just off the top of my head, I don't know.
Okay, thank you.
So you can kind of see there's a kind of a sheer cliff right here, and I believe right here is where they want to come off. Is that correct, sir? Further west? So
Well, across up a little further. It's hard to see on
right
here
there.
anyway. You can.
Yeah, and we don't have Google Map view. But there's you can see the significant drainage that does come down through here, and the hillside and the cliffside. So.
Well, would it be reasonable to match the culverts further downstream? You just got two crossings.
I'm not a professional engineer. I don't have my stamp, so I'm not going to say. I mean, that's up for an engineer to size those culverts.
Okay.
Sean Smith, Pennington County Highway. Another thing to consider here as far as engineered plans, the significant grade change from the road surface to where this would come from, we need to ensure that we're meeting grade for emergency services, that we're not exceeding that slope. So that would be the other consideration on why we're looking for engineered plans, not just through drainage, but also your slope of the road, so that we're not exceeding our emergency services. So.
Mr. Chair,
Commissioner LaCroix.
I'm tending to agree. I'm almost at the point where I would like to continue this to be able to go out and take a site visit myself.
Is there a motion?
I'd make the motion to continue.
Second.
I've got a motion and a second to continue.
To the next.
The next meeting.
Any further discussion?
Mr. Chair,
Commissioner
so that would give us time to look at if the new ordinance 14 gets implemented, then we'd have an avenue after that to look at the no maintenance portion of the road.
And it would give State's Attorney's Office a little bit of time to maybe give us some more insight.
Sure.
Because I think this is going to start to become even more and more of a problem. I know Joe's been trying to tell us that. He's been jumping up and down at many of these meetings. But, seeing this and knowing what Ordinance 14 looks like, I think we really have to address this, because what I can see happening is whenever we when Ordinance 14 comes into being and you start doing that road, and I don't know, survey or whatever to figure out what's roads are gonna be no maintenance and stuff. I have a feeling some of these should be on there just because we're giving it to them as a driveway, not as a roadway. And so I think that's gonna be a significant shocker for some of the individuals who think that the county's gonna be maintaining the roads. So.
Okay, any further discussion? All those in favor of the motion indicate by saying aye.
Aye.
Opposed? Motion carried. Let's continue. Item J.
Codisac Environmental Planner. Item J is Plan Unit Development Overlay PU 22-10. It is to allow a recreational resort on the subject property. The applicant and landowner is Wheaton Enterprises LLC, Natalie Wheaton. Location of the property is 12175 White Horse Road. Involves 16.25 acres. Current zoning is agriculture district with an existing land use of residential, and access is off White Horse Road. And there is a special flood hazard area on the property, Zone A. When reviewing plan unit developments, the zoning ordinance of section 216 lists the following standards. They're on the board. I'll read the answers aloud. Number one, yes, the uses of the proposed PUD overlay district conform to the uses by right or conditional use permitted in the agriculture district. Number two, yes, the uses of the proposed PUD overlay district are the type and are located to minimize detrimental influence upon surrounding properties. Number three, yes, the uses of the proposed PUD overlay district meet the standards governing area density and off-street parking of an agriculture district. Number four, yes, the proposed PUD overlay district involves 16.25 acres. Number five, yes, the proposed PUD overlay district is owned by the applicants, Wheaton Enterprises. Number six, yes, the uses of the proposed PUD overlay district are not designed as to be detrimental or endanger the public health, safety, or general welfare. Number seven is on the following table. Again, the answers are on the screen. I'll read them aloud. Number one, no. The uses of the proposed PUD overlay district should not be detrimental or endanger the public health, safety, or general welfare of the public. Number two, the uses of the proposed PUD overlay district should not substantially impair or diminish the uses, values, or enjoyment of other property in the neighborhood for purposes already permitted. Number three, no, the uses of the proposed PUD overlay district should not impede the normal orderly development and improvement of the surrounding properties for the permitted uses in the district. Number four, yes, the proposed PUD overlay district contains adequate utilities, access road drainage, and other necessary site improvements. Number five, yes, the existing approach will provide ingress and egress as to minimize traffic congestion on White Horse Road. Number six, yes, the requested uses conform to all applicable regulations of an agricultural district with an approved PUD overlay district. And number seven, yes, future land use is identified as agriculture, large lot residential, and natural areas is consistent with this district. Currently on the property, there is a single family residence. There has been several additions to that property. There's a second story addition, a deck, a sunroom bathroom addition, and there's also a detached garage. There is an on-site wastewater treatment system that was put in place in 1997, and they are current on their operating permit. There are two conditional use permits on the bed and breakfast, or on the property. One's a bed and breakfast and one's a vacation home rental. If this plan unit development is approved, those will be reviewed and ended. This was routed around for interdepartment review. County Highway, the applicant must have access and usage agreement with the Forest Service. The applicants are requesting a PUD overlay to allow vacation home rentals, 3 to 6 RV spots, 4 cabin rentals, and a manager's residence on the subject property. The current single-family residence and garage will be converted into 4 vacation home rentals. At the time of the staff report, staff had not received any concerns, but since then, staff has received 2 emails from the same neighboring property owner with concerns on the uses that the applicant is proposing. Staff is recommending approval of Plan Unit Development Overlay PU 22-10 with conditions, and staff would like to add a condition that an approach permit be obtained from County Highway off of White Horse Road.
Mr. Chair.
Commissioner Lassiter.
Cody, I'm going to assume the on-site wastewater treatment system is going to have to be upgraded and upsized and everything for, are they going to do all the RVs connected to that and the cabins, or do you have the plan on that?
I'm not sure. The applicant is in the audience if there are any questions for her. To address the concern for the email that you guys received this morning, everything that they're gonna require would have to require permits, so the cabins would require permits, the converting the garage to finished space would require permits. At that time, if the septic's not sized properly, they'd have to get the septic sized properly. If they can't get the septic sized properly, they wouldn't be able to use that use on that property.
Mr. Chair.
Commissioner Roskinek.
So Cody, how far does the septic system have to be physically from Spring Creek or the drain field?
It's
125 feet, 150?
100 feet from the highest water level.
So would that be possible based on your site inspection?
I believe so, yes. The creek is down here, and they're proposing the future cabins up here, which would be connected to a separate system. They'd have to pump up, or I guess they'd have to pump downhill, but I'm guessing the applicant would be able to speak more to that. They'd probably put a septic up on that hill up there, and would be room for the RV spots if they did a separate septic system for that as well.
Would the applicant like to come forward and speak on this?
Good afternoon. I'm Natalie Whitten, the owner of the Whitten Enterprises LLC, and we're requesting permission to have specialty resort on the 12175 White Horse Road property. So what the questions are, I guess.
I got one, sir.
Commissioner LaCroix.
Ma'am, have you gotten this email from Cliff and Cassie?
No.
It seems like they're concerned on, they may not know what the plans are. They plan on building them their forever home somewheres.
They were here last Monday, I believe we had the meeting.
Planning commission meeting?
I met with her afterwards, and if I may.
Sure.
Let's see. Does it go
What are you
smaller?
Oh, you don't go
Yeah,
zoom in
just.
on this, or just?
Well, oh, that was a slide. Okay.
So we'll try to get rapid map pulled up. They're looking at building a house on so their property that the lady who sent the email, she lives in this, or her grandfather owns this piece that has the 22 in it.
Yeah.
They're proposing to put a house farther down. If I can get rapid map pulled up, I'll show the larger.
So I'm guessing once she got to see some of your plans, she was okay after that?
Yeah,
Okay.
they had concerns. They were worried that we would be building too close to the property lines and that we would be running UTV rentals, which neither of those are the plans.
Neither.
Commissioner LaCroix, this is dated today. Concerns that were brought to us. Maybe you don't have this.
I have this one. I don't see that one.
This one's in the packet.
Okay, the one that we got today is the one that Commissioner Laster is just showing you right now.
Mr. Chair.
Commissioner Roskinek.
I think the one that I received today, their biggest concern would be the septic. And if we're going forward with that and the septic's going to be approved by the county and done on a safe manner, then I don't, as far as the neighbors building a shop, I don't see that being a problem. I got it.
So I spoke with the state health department because we had to obtain a lodging license and without any additional tests, just by their own charts, they approved our septic system for up to 12 residents. And he also told me that based on prior percolation tests on the soil, on the property, it can be the same exact drain field can be approved for more, for up to 25 people. After that, it would become a public water source, and that's a whole other set of rules and regulations. with with the stage we're at now, we're looking at 4 units, 8, 4, 4, and 4. So that's under 20 people. So that would still be within the 25 people requirement that state health department would make us have. And then the cabins and RV spots, if they ever come to fruition, would be on separate septic system and separate drain field. Simply because water doesn't flow uphill. So if we're building the cabins up on that shelf there, it wouldn't be very easy for us to lift that water up to provide for the cabin. So we would have to go into the field that's next to it on up in the corner up there. Yeah, or I guess I can use the mouse here. So this is a shelf right here. This is a shelf right here. And then over here, there's a large flat area. It doesn't look flat because there's trees, but it's a large flat area, and but that's probably where we would look into.
So how do you get access to that shelf area you're describing?
This right here is a road.
Okay.
And right now you can drive up all the way around and up to the top over here. We've taken that road. It's
And Spring Creek is where?
Spring Creek is down here.
Okay.
Down here. So we're not looking at the floodplain at all for any sort of development or structures.
Okay.
Mr. Chair,
Commissioner
I'll go
Oscar.
ahead and move to approve Plan Unit Development Overlay PU 22-10 with 26 or 27?
27.
27 conditions.
27, adding the condition that they acquire an approach permit.
Okay, that would be my motion.
Second.
Got a motion and a second. Any public comment? Back to the commission. Any further discussion? All those in favor of the motion indicate by saying aye.
Aye.
Opposed? Motion carried. Item K.
Item K is ordinance amendment 0822-01. It is to add section 321 hard rock mining to the Pennington County zoning ordinance. This was continued from the July 5th, 2022 Board of Commissioners meeting. I believe that the Board of Commissioners wanted to take additional public comment today before it was brought back in August. So with that, staff would, I guess, give it over for public comment.
So, okay, there we go. So I have a number of people that have signed up speaker request forms to speak on this. Is Nancy Hilding here?
She should be on Zoom.
Nancy Hilding on Zoom? Looking for Nancy Hilding. Joan, do you know if she's on Zoom?
Can you hear me now?
There we are. Okay. So we're going to limit the testimony to 3 minutes. I'll let you know when, or Holly will let you know as your time is going at like 2.5 minutes or so to give you 30 seconds left. So go ahead, Nancy. Nancy, if you're talking to us, we're not hearing you. Can you hear us, Nancy?
Hello, can you hear me now?
Can now, yep.
Hello? What, now you can hear me?
Yes.
All right, okay. So there's a lot of confusion or concern about the state's attorney saying that we can't be more stringent or in conflict with state law or rule. This is actually not a federal issue. This is a state issue going back to a state law rather than anything having to do with the feds. It's South Dakota Code Law 141-3.4 and 45-6B-4. to get a, I mean, I do not know, I'm not an attorney, and you need the attorneys to explain this to you. But if you notice, if you go to Lawrence County's mining ordinance, they did the whole thing as a conditional use permit. All of the mining things at Lawrence County are done as a CUP. And I think if you look at South Codified Law 45-6B-4, the only people who are allowed to have mining ordinances are ones who have a comprehensive plan and zoning. Comprehensive plan is not enough. You have to have a comprehensive plan and zoning. So as far as I'm aware, the state does not have any zoning rules. You know, they have rules about mines, but they do not have zoning rules. So Lawrence County has put their whole mine application and permitting thing under a conditional use permit, which makes it fully in the realm of zoning. And zoning fully belongs to the county and not the state. So I'm suggesting you look at this approach as you know, the state's attorney keeps saying you're going to get sued or whatever. This gives you a layer of legal argument and a layer of protection in a court case if this is a conditional use permit like how Lawrence County has done. Okay, the state's attorney said we can't have a socioeconomic study because it's more stringent than or conflicts or whatever. There is a requirement for a socioeconomic study in state law. And I gave this to you, I gave you this, it's in 45-6B-33, tiered to 45-6B-33.1. And it's tiered to the special exceptional, critical, and unique law. And when they make a SECU, we call that determination. Before that, making that, they can ask for a socioeconomic impact study.
Okay,
So
Nancy?
if the feds can if the states can ask for a socioeconomic impact study, so can you.
Nancy?
There's also a statute
Nancy?
in South Dakota that was passed. What?
Your time has expired.
No. Okay, well, there's an environmental impact law in South Dakota. The state can require, agencies can require an environmental impact study.
Okay, thank
So
you.
if the states can require that, you can too. All right, I had more to say. All right, but I'll hang up. Thank you for putting me first because I have another hearing I have to
She
go
can
to. Thank
email
you.
that in to us and put it in the packet.
Nancy, if you want to email your information in, we can, we'll take it. Okay, Robin Zephyr. Not here?
Did I mute myself?
No, you haven't. Did you hear, Nancy, where we said that if you want to send further information in, you can provide it to us?
Yeah, I will do that.
Okay.
I'm trying to mute my phone. I'm talking to my.
Okay. Lilius Jarding.
Good afternoon, Mr. Chair, Commissioners. I wanted to make two things clear before I got going on a couple of specifics that were requested at the last meeting. One is that I'm for the ordinance. I think that this is an important addition to our county's ordinances and protections for the public interest and the public in general. The second thing I forgot to do is to talk about my background at all. And at my age, you might figure that I had some experience, and you would be correct. I have worked in the area of mining issues most of the time since 1979, and I have a PhD in political science with a focus on environmental policy. I have presented papers and presentations in scholarly and community settings, over 200 presentations on mining issues, and I have been involved in this for some time in the Black Hills. So you had I believe it was primarily Commissioner Hadcock had requested some things that should be included or that could be included under the theory that the county could require things that were stricter than the state. But there's one thing I noticed that I think is important, especially since the commissioner's not able to be here today. In the version that says it's from the version of the ordinance that says it's from June 13th on the first page and May 23rd on the following pages, there are definitions of hard rock mining operation and of mining operation. They are D7 and D12. They both state that they include waste from underground mining. And this term is typically used to talk about digging tunnels under the ground. But there are, of course, is a great deal of rock waste and other waste from open pit mining and other kinds of mining besides what we usually call underground mining. So I think that open pit mining should be included, and the simple way to change this would be to delete the word underground so that it covered all types of mining and waste from all types of mining. So I have specific information that I can share if you're going to move forward today. If you're not, I can wait till Commissioner Hadcock is present. That's all I have for right now, unless you have questions.
Okay, any
Mr.
questions?
Chair.
Commissioner Oskinek.
So Lilius, some of the things that I remember seeing in emails, there used to be a clause relative to social economic that was just totally stricken. And I guess I don't agree with that, and I think it should be in there.
Okay.
And then there was one, the distance from a residential neighborhood that was 50 or 100 feet, and it was suggested it be 500 feet.
Yep.
And that would be my recommendation as well.
Okay.
And then there was a third one, I can't remember what it is.
I would agree with both of those, of course, and the operations plan and the site plan were, in this version, modeled after the state's requirements, which are very limited. And the earlier version of the ordinance had much more complete requirements for operation plan and a site plan.
I know one of the things that we requested was to see the actual black and white documentation that said the county could not be more strict than the state.
It's right in the past version of those two sections.
Okay.
Where?
Other questions?
No, where did you say the county can't be more restrictive?
The county can be more
Okay.
restrictive, is my understanding.
I misheard what you said. That's why I was like, wait a minute. Okay.
Okay.
Okay, thank you.
All right, thank you.
Rebecca Turk.
Mr. Chair, Commission members, Rebecca Turk, resident of Pennington County, live on Dark Canyon Road. So I did submit about, I think, a week and a half ago, some kind of overview of state statute in regards to zoning, conditional use permitting, and hopefully you've had a chance to see that. I submitted that via email, and I'm happy to answer any questions. My contact information was on that. And you know, the kind of broad overview of that is that there's a desire for clarity, I understand, on what the state allows, but that local control gives such broad authority. It's actually much more efficient for the state to be specific about what it doesn't allow, what it prohibits. So it makes your job a little bit harder, but it also gives you a lot more authority. So I also have a couple of comments related to some things that were mentioned in the previous hearing. And one was that I think it was Mr. Mann who mentioned the idea that an overly restrictive ordinance could potentially present an illegal taking. And, you know, I'm not sure what would constitute an overly restrictive ordinance in industry's idea. But what I will say is that, because of a lot of the things that zoning requires you to do around protecting health, safety, and welfare, existing uses, property values, et cetera, that an underly restrictive ordinance can also create a situation where you may be kind of infringing on those current uses, businesses, things like that, current residents, that state actually kind of instructs you to to take a look at in your decision. And then the second one was, Mr. Neff suggested that adding a requirement for the commission to provide reasons in the event of denying a permit. I would strongly suggest or advise against adding that, and here's why. So first of all, the state doesn't require that, does not require you to state your reasons for denying a permit, just like it doesn't necessarily, make you state your reasons for accepting it. The other thing is that it can present a situation where you may get into legal trouble if you don't specifically reference in your denial language in the ordinance. So I just want to that little caveat, that little warning, that you may not want to include that. And so I see that my time is running short. Happy to answer questions. Would love to see us do a special meeting because I know there's a lot of people who couldn't stay. So thank you.
Any questions, Rebecca? Thank you.
Great, thank you.
Next one I have is Mark Bauer.
Good afternoon. My name is Mark Bowron, and I am a professor in the mining department at South Dakota Mines. And today I am here representing the South Dakota Mineral Industries Association, which is a newly formed nonprofit entity with the stated purpose of fostering education in the state with regard to mining and mining issues. So I ask, why are we here? I mean, we're really here to address a problem that, one, hasn't occurred yet, and two, in my experience, quite likely will not occur for at least the next 10 years. That is how long I teach permitting and reclamation at the school, and one of the many classes I teach, and that is how long the permitting process is for a new mine. Mining is one of the most regulated industries in the United States. It's regulated by the Clean Water Act, the Clean Air Act, the MPDS, stormwater discharge permits, the EPA, and I'm not suggesting that you not take action. I'm in favor of the ordinance, but there is not this urgency, perhaps, you might think. Person following me is going to talk about the preemption of state statute over local municipalities and county regulation. But I would take issue in one of the, I met with the planning department several months ago, and one of the things that I suggested, the shortcoming in this ordinance is that it does not address adequately the distinction, the difference between surface mining and underground mining. I teach both of those classes at the school. It's very, there are different underground mining methods, and it's very common to actually take mining waste and put it back underground. That's good for the environment, it's good for the surface disturbance, and so this ordinance doesn't really address that. So I would recommend not taking out this distinction for underground mining. The surface aspects, the surface impact of underground mining is all appropriate under the ordinance. The other thing, the last part of my comment was, I also teach mineral economics. Mineral economics is the process of valuation of mineral deposits. And all of these things that go into determining whether a mineral deposit is economic and will provide a return on investment. And the only operating gold mine in the Black Hills is the Wharf Mine. Mr.
Bauer, your time has expired.
Okay.
But we thank you. Appreciate the
open
information.
any questions.
And did you testify before the planning commission?
I did.
Okay, so I presume that all your remarks, your comments that you made today are probably already part of that record?
I believe so.
Okay. Okay.
Mr. Chair.
Mr. Chair,
Commissioner Roskinek.
Mark, what's the difference between our section 321 and what Lawrence County has?
I have not.
I think we're trying to mirror that, because why reinvent the wheel?
For sure. But I have not read Lawrence County's ordinance, but they too only address surface mining, is my understanding.
Commissioner Laster.
Mark, thanks for coming. I got a couple of questions. Maybe it's just one that might have an expansion on it. You teach at School of Mines, is that what I heard?
Yes, sir.
Okay. So is it wise, or have you seen it for ordinances or things of that nature, to have test wells in the area to kind of see if any of the water is getting contaminated before it goes out off the lands and into the public, just out of curiosity?
That's part of the existing regulation. Yes, absolutely.
That's part of the existing, like, Clean Air, Clean Water Act?
Absolutely.
That they have to have certain well test monitoring?
Yes. And it's prudent. I mean, it's good business. Miners and mining companies are not in the business of intentionally spoiling the environment. The mining practices of today are greatly different from the mining practices of even 50 years ago. The concepts of sustainability and taking care of the environment are paramount, and you will read that in every annual report of every mining company, publicly traded mining company that would, happen to operate a mine.
So if you know where that's at, do you mind, can you send that to us or to whatever, Holly or something, so she can get that out to all of us? If you know where it's at, either in the Clean Air Act or whatnot, so that we can review that, because I know that's one of the things I'm concerned with is the water. And I live in Eastern Pennington County District 4, where we already have water contamination because of the PFOA. So clean water is a big deal, and I want to make sure that we prevent any other contamination throughout the county, especially whenever it reduces the property value, because that impacts our county revenue. So that's why I would like to see it in black and white, so we can see how we can maybe work that either into the ordinance or make sure that it's going to be followed.
There may be a preemption by the state with regard to the specific standards of the water quality, that you could have the same standard as the state, but you could not have a more stricter standard than the state, because the state already regulates water quality.
Right. Yeah. If you put in a well, it's a private well, you only have to test for X, Y, and Z, and as long as you're good to go, then it can be utilized as a private well. But if you put in a commercial well, it has to be tested for all these extra things. I get that. There's that water quality standard, but I'm talking about for the water that's leaving the property that may be contaminated, could be contaminated with a chemical. That's more what I'm getting, like a test well.
Even that's regulated, because the mining operations have to have a discharge permit, anything that leaves the property. So I'm not sure I really understand the concern, because it would already be regulated.
Okay.
So there's.
And then to add to that, the state has to comply, or the preemption of the federal government. So the EPA and the federal government have an agreement where they typically allow the states to set standards, but they cannot set standards that are stricter than the federal government.
So that's pretty much where I'm asking. I haven't seen that in writing. That's what I would like to see in writing, where that's referenced at. Is that something?
I will see if I can find that for you.
Okay, I appreciate that. Because I know I've worked with water contamination and stuff for the last couple of years, and And sometimes the state can be a little slow getting out to looking and evaluating something like that, which in turn means that there's more contamination that's coming out if it turns out to be contaminated. So that would be my concern.
Mark, one of the areas of concern in Pennington County is the Jenny Gulch area. And I don't know how familiar you may be with that area. Is that something that's so sensitive that we should have very much a concern for that particular area?
First of all, exploration is not mining. Drilling holes is not mining. It is simply exploration. They drill a core hole, they extract a rock core, and then they fill the hole back in. They cement it back in. And that's all in accordance with state law. It is no different than drilling a water well or anything else. Even if it pierces the aquifer, I don't believe it's a problem. The drilling muds are made of basically water, surfactants, and bentonite, clay.
Mr. Chair.
Commissioner Roskine?
Mark, I watched a city council meeting last night on TV.
I'm sorry, the what?
I watched a city council meeting last night on TV, and there was a gentleman that got in front of the city council. And he asked the city council folks, he said, why would a company spend $2 to $3 million to drill holes, pull it out? It's just the first step in hard rock mining. It might be 10 years, but it's that first step. And that's the concern of the people in Jenny Gulch.
And I'm not sure why that's a concern, because this is the nature of the mining business. There might be out of 100 exploration projects, maybe 10 of those a mining company might drill. And out of those 10 that they spend millions of dollars on drilling and exploring, there might be one that turns into an operating mine. That is simply the nature of the business. High risk and an appropriate, commensurate return on investment. You know, when somebody says, why would they do that? They're drilling prospects all over the world. And this is simply another. And to take that a step further, companies, it's a business model. Exploration companies are solely in it to explore. And that's a good thing, because if they do find something, they turn it over to a larger company, well-capitalized company, that one can not only has the experience and can do a mining operation correctly, but also has the financial wherewithal to back up their bonds, perform the closure and the reclamation and the requirements adequately in accordance with the permits. Unlike Brome, which was a fly-by-night Canadian company, and we all know that story, that reneged on their obligations. Agnico Eagle is a $20 billion company. They're evaluating the Gilt Edge property, and it would be the best thing in the world for the citizens of the Black Hills and the citizens of the state for them to conduct a mining operation there, because they're a 20 billion company and they would assume all of the environmental obligations of that site in perpetuity. That's a great thing. No more tax dollars.
Further questions?
One question, Mr. Chair.
Yeah.
Yes, sir.
Mark, I kind of been telling everybody, I'd like to see, if possible, if you could write out what you'd like to see changed or what your beliefs are and have it sent into Holly. That way we can compile them, because I think with all these testimonies, I know my notes are going to get messed up. And so if I have an email the book of all the comments coming in, that'd be fantastic, so we can sit back and go through each one and reference them ourselves. I'd really appreciate that.
Sure, I can do that. And I have done that, and I met with Brittany
Okay.
on that.
Thank you, Mark.
Thank you.
Mike Seapack? Am I pronouncing that correctly? CPAC?
As you mentioned, my name is Mike Seapack. I'm a retired DA and R employee. I worked with the Minerals and Mining Program for 32 years. And right now, well, first I should say, I'm not here to represent the DANR at all, so it's, I'm not doing that. The other thing, I'm also on the board of the South Dakota Mining Association, Mining Industries Association. I've been on there for like 2 or 3 weeks now. I didn't even know it existed until 2 or 3 weeks ago. Anyway, just to repeat, look at a few of the things that were said earlier on the preeminence of the county and the state. SDCL 456B4 does talk about the county's role. And the county can have ordinances that deal with mining, but they have to be consistent with the state law. And the state law, when the state does its permitting, it also goes back to the company to say, did you get your county permit? Also, in state law, we do have a list of, the Board of Minerals will look at reasons why this company cannot do a mining operation. And it can be as simple as the application's not complete. There's that wrong information in the application. It could be something in that application or in that mining operation that could cause a problem in the future. Or it's special or unique lands or something like that. So it might be a good idea. You can look on your own local area to make sure that there's areas that should not be mined. There should be areas that you should have a good application. Make sure the people own the minerals that they say they're going to mine and things like that. And also, I'm available to answer a few questions since there's a little bit of time left.
So Mike, as you heard, the suggestion was made is that if you're going to do a denial, that you not really give the reason. With your experience with DANR, are there reasons given when a denial is made?
Well, there wasn't very many times, and a couple of them were overridden, but sometimes we have normally we do a real extensive check on the application. We divide the applications beforehand that were incomplete. Some of those didn't go anywhere. So yes, but it hasn't gotten to the board yet that I can't remember in my 30 years plus with the board, dealing with the Board of Minerals and Environment, whether or not they actually denied an application.
Okay. Now, would that been for exploration?
They don't even look at exploration permit unless to release the bond. Once they've actually finished their exploration project, backfilled the holes, which we'll send out our inspectors there to check. And then we give them clearance and we go before the board and say, yeah, they plugged their holes and it's all reclaimed. Then the board releases their bond and
Sure.
is that.
Okay. So I'll ask you the same question I asked Mark, and that's relative to Jenny Gulch. Is, from your knowledge, is that such a sensitive area that should be, I mean, there isn't basically any private land there. That's Forest Service land. We'd have to work with the Forest Service and ask them to give consideration of not allowing mining in Jenny Gulch. But is that a concern of yours, or would that be a concern of yours, the Jenny Gulch area?
Well, until I would know a little bit more information of what type of rock they're dealing with. Is it rock that could produce acid or something like that? There's different levels of things would have to be considered. Also, just looking at that whole Rapid Creek area, that's been explored since the first day I worked was back when it was a DENR, Homestake, Western drilled out there extensively during the 1980s up in the Rochford area. People forgot all about it. They drilled deep holes. Now we got the new company up there, and I forgot, Mineral Mountain is, I think, the name. And that's been going on for 30 or 40 years. And as Mark was pointing out, these companies go out and look at prospects and keep drilling and drilling, and, you know, they've spent a lot of money drilling out there, but nobody's developed a mine out of that yet. And the same thing might be happening in the Jenny Gulch area. I have no idea. There's not a lot of, from my memory, there's not been a lot of gold production in that area, which would tell me if there is gold there, it's probably deep. And I'm kind of guessing at that a little bit, but because I don't know the geology that well there.
Sure.
It's more Lawrence County rather than Pennington County.
Sure. Questions, Mike?
Mr. Chair, you know, one of the things that we have to take into consideration, Mike, is that the second largest industry in the state of South Dakota is tourism.
Yes.
Recreation is a very large component of that tourism. And Jenny Gulch has got a very heavy recreational overtone. And we just try to figure out how, relative to the drilling in Jenny Gulch, F3, we just wanted, to me, I'm trying to figure out, you know, would that have an impact on tourism and the recreational overtone?
It depends on if the project goes on and on and on, if you know what I mean. This might be the first level of it. They might walk away after they're done with it. There's a couple of the land disturbances that you'll have. You'll have the roads getting into the drill sites. There'll be a drill pad. Then the actual drilling in the hole. They'll have mud pits for circulating the fluids they need and stuff like that. When they're all done, they don't find anything, or even if they do find something, they'll reclaim that site. They'll plug the holes, reclaim the drill pads, and then mostly reclaim the road.
Who oversees that process, the Forest Service?
Both. It'd be state and the Forest Service, because we would be looking at that also. The state and the Forest Service do have what we call I worked on it. It's kind of a memorandum of an understanding that we both, on Forest Service lands, we both work on it together.
Sure.
So our inspectors will go out with their inspectors. It's not totally separate. The state is looking. It's Forest Service land. They're looking, so both of us would be looking.
Good to know. I didn't realize that.
So if a company wants to drill on Forest Service property and they got the mining rights or whatever, then what's the process? Just the length of the process going through the Forest Service just on a permit to drill, like F3 just got kind of where they're at right now.
What's that? Excuse me, I didn't know what
the length to get a permit like F3 did.
For the Forest Service,
Yeah.
that can go on for a long time. Some of those permits with the Forest Service drag out for quite a while. The state is usually a lot quicker. We'll look at what they're doing and things like that, but here I am talking for the state. Yeah. I mean, in my former days. But the state would be a lot faster on that. And then we'd figure up a bond for, you know, and I think it's safe. I think the bond is set at just $20,000. So that's one thing we have to be, you know, cognizant about.
Okay. Any further questions?
No, Mr. Chair.
Commissioner LaCroix.
Mike, thanks for coming here today and kind of clarifying both you marks here. My question would be for you, since you're on DNR and Chairman Drews has asked extensively and everybody about Jenny Gulch, because that's a pretty hot topic right now. You know, our the city council a year ago requests comprised of a letter of opposition to any drilling near Rapid Creek, any opposition on that. And I think they turned it in, sent it out to all bodies that it's available to. If this commission was to do the same thing, would we be sending it to DNR, the Forest Service? You guys, you know what I'm saying? I know a lot of what we learned here today is we can't supersede the state. We're following by that, but we could give what our opinion is.
You could give your opinion. One thing you could do, the state does put conditions on exploration permits. If you would want to recommend some conditions for the state to look at to see if they could put certain conditions on that drilling. I think that might be a way, if it does go forward, the state, like for instance, back towards the end of my career with the state, we had drilling going up in the Spearfish Canyon area. And the operator was told not to drill over 250 feet in particular area because we were worried about the aquifers going into Spearfish Canyon. And they ended up drilling over the 250 feet. And then we had to, we had them stop, and they ended up getting fined for doing that. No damage was done to the environment from what we could tell, but they violated what the conditions were in the exploration permit.
So you're saying we could add some conditions?
There might be some room for that. Because, if you say, you can't do it at all, that might not fly. But if you say, have them avoid certain areas, have them be so far away from water, that type of thing.
Okay.
That might be acceptable, because they can, modern drilling, they can go in spectacular angles. They can, when they drilled up at Keystone, they had a main hole going down, and then they shot off on various directions off that one hole. So they can do all kinds of amazing stuff with drill rigs.
Okay. Thanks.
All right, thank you.
Yep.
Appreciate it.
Thank you.
So, Brittany, it would be my suggestion that we may want to draft a letter to state DANR and to the U.S. Forest Service, just indicating to them the amount of comments that we had relative to the sensitivity of Jenny Gulch, and that not necessarily requesting that they not do anything, but make them aware that there's extra caution that we would ask that they use if there are any requests for that area for exploration or drilling.
So I guess I just want to clarify with Holly, would we need a motion to put that on the next agenda as an item? So you and I can work on a letter proposal?
Motion, just direction that you would like it prepared and put on the next agenda.
I think so, yeah.
Okay, so
Are you agreeable to that?
Yep.
we will work on that and then provide it for the next meeting.
Okay. Lilius, did you have something you wanted to add?
Lily is starting. They already have their state exploration permit. So the conditions on that have already been set.
Okay.
Just want to make sure you can do that.
Thank you. So recommendation is to have a public hearing, move the schedule to have a required public hearing on September 6th for ordinance amendment OA 22-01.
Sir, that'd be my motion.
I have a motion. Is there a second?
I'll second that.
Got a motion and a second. Any further discussion by the commission? Those in favor of the motion indicate by saying aye.
Aye.
Opposed? Motion carried. Thank you. Items from the chair and the commission. Start with Commissioner Lassiter.
All right, mine's going to be quick and brief. I didn't go to the Rapid City Public Library Board of Trustees meeting. I was going to zoom in on it because I was stuck at the office and filling in, but I was going to zoom in, but there's no longer a Zoom link for that, so I can't zoom in whenever I'm at my office. The other one, the Emergency Management Users Board, pretty much discussed budgetary discussions, the next CERT class, which we heard one of the citizens today come and talk about that, which is good. There's another one coming up, the LAMPG review of their, what we all had to review for today. And then there's an on-call position. I'm trying to remember what the term was. I don't have my notes here. But it's basically a joint position, fire, sheriff's department, basically someone who is a point of contact. They're moving forward with that, and they've already got I believe it was fire and sheriff, I could be wrong, of which agencies are going to submit names to be a part of that. But basically a point of contact if there's an emergency, a major emergency, that they can have an on-site individual so they're not calling the same person over and over again. So they're working through all that. Outside of that, that's about all from those meetings that I had.
Commissioner LaCroy.
The ESCC 911 Users Board meeting, I think one of the biggest discussions we had, you were there too, Travis, weren't you?
I was there.
Okay. One of the biggest discussions we had on that one was that some of the towers are getting completed. Adding security cameras, because potential vandalism, so forth. So that was a discussion on the cost for that, about 60, I want to say 60, or was it 30? About
I want to say
63,000.
63 is
Yeah.
something that comes to mind.
So that was a discussion. Another one I think that came out of there was, we get some funding through other entities that we provide service for, like Box Elder. And Box Elder was one of the ones I think we're going to have to raise our fees for and have discussions since they're growing so rapidly. And I think they're working.
The calls for service.
Yeah, the calls for service, but same band, or I don't quite remember how that worked. I was counting on you, dude.
You're counting on me to remember the radio traffic and the amount of it going to the same band.
There's some discussions going on with Box Elder growing that in the next couple of years, they're probably going to have to either have their own 911 center, or we're going to have to really request a couple of full-time employees for them. If I remember right, we're at that point.
It's getting close to that point, if not already at that point.
Yeah, and from what the last thing I heard is I think Box Elder is actually talking about they got land donation and may build a new city hall, or that was in the paper. So I don't know.
Lloyd, if you don't mind me touching base before you move on to that. Also, some of the other entities that we do 911 service calls for after hours too, because those are growing. Some of those were growing as well.
It's growing all the way. So that's kind of the report on that. The Black Hills Association of County Commissioners, we gave our report on the WIR board. Randy gave an update. Is it Lori from Black Hills area?
Jennifer.
Jennifer,
Black
sorry.
Hills Council.
Jennifer gave her report just as she did here with us, and she did a very good job. And I think, now everybody's kind of aware where we're at with that. So with that, the extension board meeting was canceled last night, which worked out because then I was at the MOA Human Relations Commission meeting. And if you guys remember, I had them put this in your box for that immersions program. I got a little more details on it for you. This next Wednesday, if you decide to go on this, it's not just a one-day trip. You have an orientation dinner at 6 o'clock, between 6 and 8 on the 28th. August 19th is the tour. It's going to start out at Oyate Health, and they'll give an update on community health, where that come from, how it started. One of the discussions is healthcare perception for IHS is free, but in all reality, that was a negotiated contract. So, but they'll go through that. Then you'll go up to Mother Butler's, where you'll tour around Lakota Homes and the Sioux Edition before going up to Mother Butler Center for dinner, and then going over to the college, the college, and have a presentation there. Then you'll go down to NDN for a presentation there. And I wanted to clarify, and I think at the last meeting, NDN is wanting to do an immersion school out on North Rapid. Well, now I finally figured out where it was. I thought it was between Sioux Edition and Vicky Powers Park, but I was totally off. It's across the street between Dollar General and Country Road. They bought all that property over there, and they plan on putting a school and housing and so forth. And NDN will be giving a presentation on what their development plans are for that. So that's a big chunk of land in between Dollar General and Country Road. But, and then on September 8th, this group would do a post dinner, have a discussion, what they learned, anything they'd had done. Then there's a play September 30th they'd be going to, and October 27th. So it's a 5-day, but there's a couple of free meals in there for you if you decide to go. So I can make up another copy if you want to, but I think I'm going to do it because I originally thought the 28th was going to be the start of it, but actually the full day tour is August 19th. And, oh yeah, they'll be doing the Indian boarding school land over by West Junior High, also doing that visitation too on August 19th. But I think with that, I'm done.
Okay. Ron and I attended the Central States Fair Board meeting on a week ago,
I think 11th.
Monday, July 11th. And
so.
Bridger Steel building restrooms are almost finished. They'll be ready by the time the fair rolls around, they'll be ready for that for sure. We've been having weddings at that building, at the Bridger Steel building, basically every weekend.
Good.
And so this is going to be a real enhancement, having restrooms.
Are they gonna give us a good, before the ribbon cutting ceremony? Come tour it?
What's that?
Before they open it, are they gonna do a ribbon cutting ceremony to show us what they're doing?
I don't know if they're planning that or not. So the improvements on the buildings, utilizing the vision funds is going great. The biggest holdup is just trying to get all the supplies that are needed for it. I mean, there's delay on some of those, but otherwise it's going along well. The concrete is all finished in the floors in both the Bridger Steel and the Soleil buildings. So that's a big improvement over there. Ticket sales for the fair, the grandstand events are up this year compared to last year, and that does involve, so there is some ticket increase prices there, so that's good news.
So question on that while you're there. Someone had told me that the VIPs are sold out.
Yeah, I think it did. What's that? The VIP, didn't that sell out?
I know the stock or the demolition derby did, and I heard VIP. Yeah, I believe you're
I
right.
think they did.
Okay, I just heard that, and I think that's amazing. This early it's sold out.
Yeah, I think we talked about that actually at the meeting prior. But I think you're correct.
Yeah.
It
And then
says VIP sold out as of June 28th.
June 28th, okay. And then we've had the Midco stage there for a number of years. Midco sponsored that. Well, that's now going to be sponsored by Monument Health. So that will become the Monument Health stage out there.
Wow.
So a lot of good things going on. Right now, some of the employees are taking some vacation time. They've gotten all the work done in preparation for the fair, taking some vacation time right now and hope to be regenerated by the time the fair starts. So that's all I had. Ron.
Well, let's see here. I attended a STIP, Statewide Transportation Improvement Program presentation at the Ramcota Convention Center, which provided an overview of the major highway projects that will take place in the Rapid City region in the next 4 years. 2023 Highway 385 will be widened from Sherrod Lake to Pactola for a distance of 8.2 miles at an estimated cost of $29.5 million. In 2024, these are the more significant ones. Highway 385 will be widened between Pactola Reservoir and the Lawrence County, Pennington County line at an estimated cost of $26.2 million. 2025, new intersections will be installed between Reptile Gardens and Rockerville for an estimated cost of $9.7 million. And there will be a bridge, a new bridge, I believe, on Neck Yoke Road. So these intersections, you'll be able to take a left. For an example, if you're on Neck Yoke and you're going to Rapid and you need to go towards Sheridan Lake, you're going to have to take a right. And you're going to have to go down a mile or 2 miles and then do a U-turn and then go back. You will not be able to go across Highway 16, which should eliminate, one option was to put a stoplight down at the bottom where Reptile Gardens was. They didn't want to do that because the trucks would, if they came to a complete stop and they had to go south, they're going right at pretty major grade. 2026 is when Catron Boulevard interchange will be developed, and that'll be a single point interchange, very similar to what you see at Haynes Avenue. Estimated cost on that's $36.8 million. I also attended a South Dakota DOT US Highway 385 construction sequencing focus group meeting to help identify which option to go with for the widening of US Highway 385 from Sheridan Lake to Sheridan Lake Road, with a goal of scheduling the project in a manner that would provide the least amount of inconvenience to local users, businesses, and travelers. This stretch of the project would completely shut down Highway 385 for roughly 90 to 100 days. Option one would be shut down Highway 385 from Calumet Road to Sheridan Lake Road, May through August. And that option is the option that the city school district likes. Option two would shut it down September to December of 2024. These are all 2024. And that's the option that the downtown businesses like. And option three is a combination of option one and option two, which the meeting that I attended, that seems to be the most desired option. Option four would keep the road open, and you'd be able to sit there and go through. I mean, that option just would be so cost expensive that I don't think that one's even on the table anymore. Building committee, the items listed in three of the options. Now, these are the options that we can look forward to that the building committee presented, that consultant. So the item listed, three of the options presented at our last meeting did not include an off-site jail, land acquisition for that jail, and infrastructure needs for the current jail. Estimated cost of the new jail is around $6 a square foot, or $600 a square foot. Lawrence County's new jail came in at $825 a square foot. Henry Pittner with KBV suggested that we purchase everything that we possibly can in the immediate vicinity of our current campus, such as the Great Western Bank building and the Jefferson School property. I reached out to Kumar with Rapid City Area Schools, who is now aware of our interest in that property. Kumar will send me specific information relative to the building and site improvements going forward. In the near future, Doyle Estes will have a 38,250 square foot building situated on a 3-acre corner lot for sale. That building measures 170 by 220 feet, 225 feet, and was constructed in 1974-76. Assessed value is $1,077,000 or $28 a square foot. Building is currently occupied by South Dakota Department of Social Services, who will be relocating in their new facility once it's complete. That facility is right behind Lowe's, that Hanny's building. Courthouse Centennial celebration is scheduled for October the 5th, 2022 at 4 p.m., at which time the time capsule will be opened, 100 years old, and replaced with a current time capsule. A committee has been formed and will seek funds from the Board of Commissioners.
Ron, did I miss a meeting? Or is this?
No, that was at the last
your
meeting.
Notes from?
Attended Black Hills Association of County Commissioners and officials at Deadwood Mountain Ground on July 8, 2022. Good presentation by South Dakota Department of Revenue, focused on property tax legislation and implementation. HB 1325, which will give the local DOE the authority to reclassify Class 4 soils, either as cropland or non-cropland, at their discretion. And SB 162, which revises the discretionary formula for reduced taxation of new structures and residential property. The formulas are spread out over 7 years. First 2 years, no more than 25%. Third and fourth year, no more than 50%. Years 5 and 6, no more than 75%. And year 7 will be the full assessment. Pennington County resolution was voted on and approved. Thank you, Janet. Attended Central States Fair meeting. Motion to authorize bonuses in the form of $500 gift cards to 6 maintenance employees for a total net of $3,000. Motion to write off $5,650 in accounts receivable. Motion to authorize executive committee and the general manager and assistant general manager to obtain a draw account loan in the amount of $1 million from a local financial institution at the current market interest rates to be used to finance capital improvements projects and to repay those draws as reimbursements coming from the city and the county are received by the Central States Fair, and to further authorize the same to write checks to facilitate the process. And then increase in passes, VIP, and if I read this right, it looks like 200 to 250, general admission 50 to 75 to 50 to 55 to 80, premier 90/100 to 100/125, event guide 75 to 100, and then Gary already mentioned the Monument Health Building. And then I did get an email from Jim Gubbles, who's the district ranger, and what he said initially, our staff has just finished up the heritage review for the archaeological resources at this site. There were no significant findings. I signed a programmatic agreement documentation today, and we are cleared to move ahead with finalizing the NEPA process. Donna is starting to draft a special use permit this week. This is relative to the Silver City Fire Department. This will be a 30-year permit. We can waive the cost collection and other fees as it is a government entity. We're working for an August 1st, 2002 completion date for the special use permit at the district level. Once we have completed the special use permit, it will go on to the supervisors in office for final review by the signature for Supervisor Jeff Tomac. I would allow 2 to 3 weeks for the final review. We will stay in communications with staff and Custer for any needed changes and further information that is needed. So basically what they're telling Phil, who's the fire chief of the Silver City Fire Department, volunteer fire department, that at the end of August, they should have a special use permit and a piece of land identified roughly at 3 acres for their new fire station.
Okay, thank you. Anything else? Is there a motion? Oh, I need a motion to approve vouchers in the amount of $4,908,867.65.
So move.
Got a motion. Is there a second?
Second.
All in favor of the motion indicate by saying aye.
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 Opposed? Motion carried.
Did you add that 220 in there?
I did.
Wow, man.
I need a motion for executive session.
So moved.
Got a motion. Is there a second?
Second.
All in favor indicate by saying aye.
Aye.
Opposed? Motion carried. Okay, call us back into regular session. Do we need a motion? Okay, need a motion to return to regular session.
So move.
Second.
And a second. All those in favor indicate by saying aye.
Aye.
Aye. Opposed? Motion carried. Motion to place Pepper Massey at B23, step 7, $23.87 an hour, effective July 24, 2022.
Second.
Got a motion and a second. Further discussion?
Gary made the motion.
All those in favor indicate by saying aye.
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 Opposed? Motion carried. Motion to adjourn.
Second.
Third.
So move.
All in favor indicate by saying aye.
Aye.
Opposed? Motion carried.